resolved. So Chair has directed that Advocate Ngalwana, who appeared on behalf of the applicant, to be in contact with Advocate Soni to engage as to the issues or the questions that were raised in Buthelez's affidavit. I'm here to confirm, Chair, that yesterday on the 16th, the two advocates confirmed that the agreement be reached. I'm not sure if the letter should be read into the record, or I can just confirm that the parties have agreed to call the two parties at a later stage so that the issues that were outstanding as raised by the applicant to be dealt with.
As I understand the position, the evidence leader, Mr. Soni, proposed that the two witnesses be recalled and so that he could put to them Mr. Buthelez's version.
Yes, Chair.
And ask such further questions as he may deem necessary.
Yes, Chair, that's correct.
And it will be after that exercise that Mr. Buthelez's legal team will decide whether they want to pursue the application for leave to cross-examine or not.
Yes, Chair, that's correct.
Yes.
That's correct.
Okay, no, that's fine. I'm happy with that arrangement.
Thank you, Chair.
So that is what will be done.
So in essence, the application is postponed pending what the Chair has just mentioned?
Yes.
Yes.
Yeah.
Thank you very much,
The
Chair.
application is postponed. Yeah.
Thank you. Can I be excused, Chair?
You are excused.
Thank you.
Thank you. Good morning, Mr. Myberg.
Good morning, Chairperson.
Before we start, I just want to make some announcements. The Commission did not have hearings from, I think, the 2nd of June up to the 14th. And its term is coming to an end at the end of June. And I think there are a lot of people who wish to know what is happening with regard to the Commission completing its work and what is happening with the return to the Commission of the President. So I think it's necessary that I make some announcement and explain where the Commission is. When the Commission applied for the extension of its term from the end of March to the end of June, I had made an assessment that we would be able to complete the hearing of oral evidence by end of March, and that April, May, and June would be used for the preparation of the report. As it turned out, we did not complete the hearing of oral evidence at the end of March. And in part, that would be because, one, when one hears evidence in a forum such as this, there are witnesses and lawyers who need to be accommodated within certain reasonable limits. And two, one's assessment can never be absolutely accurate, and as one proceeds, sometimes one becomes aware of some evidence or matters that one may not have been aware of. So the fact of the matter is the assessment that was made in good faith, but it just didn't work out. The evidence that still needed to be had at the end of, beyond the end of March, was very important evidence. It included the evidence of former senior executives of SOEs such as Transnet and ESCOM. It included the evidence, I think, of a former chairperson of the Denel board that was appointed in 2015. It included the evidence relating to parliamentary oversight. It included the evidence of the ANC that was given by its national chairperson and former Secretary General, Mr. Gwede Mantashe, and by the president of the ANC. It included evidence relating to a former minister of the Department of Public Enterprises, Mr. Malusi Gigaba. It included the evidence relating to serious allegations of the looting of public funds in the State Security Agency, which I, as the chairperson of the commission, considered to be quite important for the commission to hear. So it was necessary that the commission should continue to hear that evidence. It had that evidence in April and May. Some of that evidence is still being had and will be had until the end of June. During the time that the commission has not been sitting from beginning of June, that time has enabled us to carefully look at the work that has been, or the ground that has been covered by the commission in the various work streams. And I'm able to say that as things stand, subject to one qualification, we should have had all oral evidence by the end of June that the commission considers to be important. I said this is subject to one qualification. That qualification is that there are about 5 or 6 witnesses that the commission has identified as important to be called to the commission before the commission can properly conclude the hearing of oral evidence. That is apart from the president, because the president must still come back. The president and the commission had previously tentatively identified the 29th of June and the 30th of June as the days when the president would return to the commission to complete his evidence in his capacity as the president of the ANC and to give evidence in his capacity as President of the country and former Deputy President of the country. But the 5 or 6 witnesses or implicated persons that I've said the Commission has identified will not be able to give evidence during June. Therefore, it means that by the end of June, we will still be needing some days to hear the evidence of those 5 or 6 witnesses and the evidence of the President before we can finally conclude oral evidence. We are going to be applying to the High Court to get more time so that we can complete the work of the Commission properly. If the High Court grants us an extension, we will be able to hear the evidence of those 5 or 6 witnesses in July, as well as the evidence of the President, hopefully before or not later than 15 July. And once we have heard the evidence of those 5 or 6 witnesses and the evidence of the President, then that should conclude the hearing of oral evidence of the Commission, which started in August 2018. In the course of this morning, I will sign the affidavit that must form part of the application papers that must be launched in the High Court, where the Commission will ask the High Court for an extension of time. We are going to ask for an extension of time from the end of June up to the end of September. My assessment is that the preparation of the report should be complete by the end of August, but I would like to have September just in case we don't complete the report at the end of August. A lot of work has been going on for quite some time of summarizing and analyzing the evidence. That will facilitate the preparation of the report. I know that some within the public have grown very impatient with the Commission, demanding that it should complete its work. Some of the people who say that do so in good faith, but others do so for their own reasons. I am very keen that the work of the Commission be completed as soon as possible. I have a very dedicated team in the Commission, all of whom are working very hard to try and make sure that the work of the Commission is completed as soon as possible. In this regard, I'm speaking about the members of the legal team. I speak about members of the investigation team. I speak about the Secretariat and all the staff of the Commission. everybody has watched and seen how everybody in the Commission has been working very hard, including sessions in the evenings and sittings on Saturdays and on public holidays. Because they are all very committed that the work of the Commission be done and completed as soon as possible. I'm also grateful to very many members of the legal profession, advocates and attorneys who appear on behalf of various persons who have given this Commission cooperation and have appeared in evening sessions. Everybody is working hard to try and assist the Commission. But the one thing that I will not do is this. I will not end the work of the Commission in an irresponsible manner. I'm going to repeat that. I will not end the work of the Commission in an irresponsible manner, just because I want to satisfy those who demand that the Commission should finish its work. When I started with this Commission, I made it quite clear that this Commission will do its work properly. That remains important. In seeking to complete the hearing of oral evidence, we will act properly, we will act in a responsible manner, we will not seek to act in a haphazard manner or abruptly. I have a responsibility to make sure that the work of the Commission is done properly. I have a responsibility to do my best to ensure that there is fairness to people who are implicated, and I intend to do my best to make sure that when we have finished the work of the Commission, we are able to look back and say we acted properly and we acted responsibly. Having said all of that, I'm happy that where we are is very close to finishing. As I say, by end of June, we will be left with about 5 or 6 witnesses, plus the President. Other than that, the left is the preparation of the report. So I thought it's important just to update the public as to where we are, and to also indicate that we will be launching, I believe today, our application in the High Court for the extension of the term of the Commission, so that the Commission can finish its work properly. That is the announcement I wanted to make. Yes, Mr. Maybeck.
Yes, thank you. Chairperson, today, this morning at least, has been scheduled for the continuation of the evidence of Mr. Singh within the Transnet stream. Mr. Singh is here. I presume we need to
Yes. Please
re-administer the oath of
administer the
affirmation.
oath and our affirmation. Good morning, Mr. Singh.
Good morning, Chair.
I've already greeted your legal team. Good morning. Thank you. I understand, Mr. Singh, that we all hope that this is your last day here.
Indeed, sir.
Yeah.
Please state your full names for the record.
Anoj Singh.
Do you have any objection to taking the prescribed oath?
I do not. I do not.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. And just to make sure that there is clarity about what I announced. So the President is not going to appear before the Commission before the end of June. Another date will have to be arranged. That is because it's proper that the President should be the last witness to give evidence. So, and there are other witnesses that must still come before him. So he's not going to appear before the Commission on the 29th and 30th of June, but we will wait for the High Court to deal with our application. If it grants us the extension, then we will fix a date for the President and for the other witnesses, and that will be announced in due course. Of course, if the High Court does not grant us an extension, that will be that. Okay.
Thank you, Chairperson. Good morning, Mr. Singh.
Good morning, sir.
At the end of the last sitting, we had been dealing with the acquisition of the 1064 locomotives. You'll recall that we dealt with the original business case, the alleged misrepresentation in relation to the increase in the ETC. We dealt with the role of regiments, and we had ended by dealing with the hurdle rate. I just want to pick up and end off in relation to the role of regiments. And perhaps what I'd like to do is just to show you some documents that may illustrate the role that they played. You've already given evidence and summarized what they did. Could I ask you please to pick out Transnet Bundle 4B. Transnet number 4B, Bundle 4B, has got a number of dividers in it. Could I ask you please to go to what I think should be the second last divider, and that is BB4H. Are you there?
Yes, sir.
All right, so what you find at BB4H at page 795 is a supplementary affidavit of Mr. Callard. Are you there?
It's black numbers.
Sorry?
The black numbers.
Yes.
Yes.
795 black number.
Yes.
Now, I'm not going to take you through the affidavit. I want to actually show you the documents that are attached. Perhaps I could just, for context, take you to 799. What Mr. Callard deals with, paragraph 17 to 23, is the so-called regiment's price walk. And what he puts up is a number of documents emanating from regiments running from February 2014, you'll see that at paragraph 17, all the way through to paragraph 23. These are slides that form part of the presentation to the board in May 2014. But it's to the documents that I'd like to take you, Mr. Singh. Could you please go to page 816. Now you'll see in many instances what these documents comprise of are emails and then slide presentations. Now, at page 816, you see an email from Mr. or Ms. Gabriel Selassie, dated the 25th of February, and it's sent to Mr. Leher and Mr. Smith. They were persons assisting you in the post-tender negotiations, correct?
That is correct.
And you will see that often these emails are CC'd to inter alia Mr. Niven Pillay. You see that?
That is correct.
And the attachment here is summary slides. And if you go to page 817, you'll see it's dated the 25th of February 2014, and the slides are headed Transnet Financial and Risk Analysis for the 1064 procurement negotiation. I take it that, was this a slide presentation that was then made to you by regiments?
I don't recall the exact presentation, but I recall something like this.
All right. If I could then ask you to go to page 821, again from Gabriel Selassie, now the 6th of March. You'll see at 822 another slide presentation dated the 5th of March. Do you see that?
I see that.
And then if I could ask you to go to 826, this time from AJ Mystery from Regiments, the 7th of March, again to Messrs. Loher and Smith. The email says in the second paragraph, find attached for your review updated executive summary slides of the 1064 project. The summary has been updated to include the revised escalation drivers as requested. Do you see that?
That is correct.
And that slide presentation then appears over the page. You see that?
That is correct.
And then if you go to page 832, there's a further communication from Mr. Mystery. And another one at 833. And 833 reads, find attached for the updated executive summary slides for the 1064 project. Those slides you find commencing at page 834. You see that?
I see that, sir.
And so we go on. If you go to page 839, there's an email on 28 May. Please find attached the deck with the changes to the two last slides as requested. And those slides appear at 840. And then there's a different document at 848. It's put up by Mr. Callard, so-called Regiment's Price Walk, where you see how the price evolved from February through to May. Do you see that?
That is correct.
Then at 850, there's another slide presentation, this time dated 12 February from Regiments. And that's quite a lengthy deck, as it's called. It goes all the way to 878. And then if you can go to 880, on the 17th of February, another communication from Regiments to Loher and Smith. Attached are the slides showing that there's actually a net cost if you pay big deposits for the locos. And then there's slides attached to that. Do you see that?
So you're at 880.
880.
Yeah. One second. Okay, I'm there. That's correct. I'm there.
And then at 886, another communication from Regiments, another slide presentation at 887. Those slides are dated 21 February 2014. You see that?
That's 886, no?
Sorry?
You're at 886?
I'm at 886, yes. And then if you go to 891, communication from Regiments dated 25 February 2014. Now, this time it's addressed to you. Dear Anoj, my call earlier with Dani refers, please find attached the Excel workbook that includes the total cash flows per year for the diesel and electric locomotives for the respective bidders. The cash flows are based on a maximum 50 locomotives delivery schedule. I hope this is in order. You see that?
I see that.
And then attached, presumably, is what is referred to as the Excel workbook at 892 and 893. Do you confirm that?
Yes, I see that.
And then if you go to 895, there's a further communication at the top of the page on the 5th of March. You see that?
Yes.
And then of importance, and this is really where I wanted to take you to, could I ask you please to have a look at 898? Because what we know is that the Board of Directors approved the increase in the ETC at a meeting on the 25th of May, 2014. And at 898, you see a communication from regiments dated the 21st of May, and the subject is summary slides for the report to the board. You see that?
I see that.
And it says, Dear Yusuf, please find attached the backup slides for your report to the board. Now that report to the board we know is what we referred to previously as the ETC memo, correct, Mr. Singh?
The revised ETC.
Yeah. And then it says, in the slides on cost escalation, we have made an assumption that you have negotiated a flat cost escalation in brackets for CNR, CSR, and Bombardier, close brackets, as per the results of our model. Please do not hesitate to contact us should you need further information or clarification. Do you see that?
I see that.
And this time, this email is CC'd to Mr. Eric Wood. You see that?
That's correct.
And then the next day, if you go to page 900, on the 22nd of May, again to Mr. Leher, we've attached the summary slides with all the proposed changes. Should you require to include further changes, please send us your comments or suggestions as soon as possible. You see that?
I see that.
Now those slides you find commencing at page 901, dated the 21st of May. You see that?
I see that.
And then if I could take you finally, please, to page 909. And I'm sorry, I may have said that the meeting of the Board of Directors was on the 25th of May. It was, in fact, on the 28th of May. And this email at 909 is on the 29th of May from Regiments, Gabriel Selassie, again, CC to Mr. Wood.
You said 29 May, it's written 28 May, is that right? Correct?
Yes, I beg your pardon.
Yeah.
So it's the same day as the Board of Directors meeting, 28 May. I think we are said 9 is at page 909.
Okay.
Mr. Singh, are you there?
Yes, I am.
And what it says is, Dear Yusuf, I've had a discussion with Niven. Or I had discussion with Niven a few hours ago about the changes you would like us to make on the slides. You see that?
I see that.
So I assume that's Niven Pillay,
That's correct.
and it's CC'd to Mr. Wood. Is that right?
That is correct.
Those are the two people who are alleged to have done the deal with Mr. Essa in relation to the appointments of regiments that he would take 50 cents in the rand. You know that by now, correct?
That's correct.
All right. When you engage regiments, did you engage them on a confidential basis? Were they required to keep the information that they gained as your transaction advisors confidential?
I would assume so, sir.
And I assume that you would accept that given this conflict of interest that we've discussed, because there's no way of knowing whether regiments shared this information with Mr. Essa,
That's correct, sir.
and whether Mr. Essa in turn shared it with CNR and CSR.
That is correct.
When you do understand that in effect Mr. Essa was in a partnership with regiments, and at the same time, simultaneously on the evidence that's been led by money flows, he was in a partnership with CSR and CNR.
On evidence that you've
Yeah.
stated.
All right. And you've quite candidly said that, of course, on this evidence, regiments would have been wholly disqualified from being your transaction advisors, obviously. Sorry, I don't mean on this evidence, I mean on the evidence that I've just sketched to you, the conflict of interest.
Had we known about it?
Yes,
Yes.
they would have been wholly disqualified.
Yes.
Just so that the transcript clearly reflects your answer was yes.
On had
what?
we known this
Yeah.
at the time when we engaged?
Yeah.
Now, we know that on the 6th of December 2012, we're now going back in time, an LOI was concluded between McKinsey and Transnet, where we saw that regiments replaced Letsema. Do you recall that?
On the 6th,
6th December
2012, yes.
2012. And I'd asked you, you remember, some questions about whether in the run-up to that LOI, you had any dealings with McKinsey and regiments in relation to what became the appointment as the SD partner. Can you recall the evidence that you gave in relation to that?
I think at that stage I said that I don't think I had any interactions with Rich.
Could I ask you to go to, so your exhibit is BB23 and it's split into two bundles, 5B and 5C. Can you please go to bundle 5C? And could I ask you, Mr. Singh, to go literally to the very end? I think it's the last 2 pages that I want to take you to, if I may. Page 2203,
Sorry, the page number again?
2203 and 2204. It's the last 2 pages. Well, sorry, when I say it's the last 2, my bundle may be differently configured. Perhaps you should just go to page 2203.
I am there, sir.
So 2203 is an email that has been obtained by the investigators of the Commission. And on the face of it is from Mr. Essa, sent on the 28th of November 2012 to Niven Pillay and Eric Wood, people we've just discussed. And it says, hi, meeting confirmed for Niven, 10 a.m. Monday, December 3. Please email Anoj.Singh@transnet.net to confirm your attendance ASAP. Regards, Salim. You see that?
I do, sir.
Did you have any dealings with Mr. Essa in setting up a meeting with Mr. Pillay and or Wood on the 3rd of December 2012?
No, I did not.
Have you any comment on this email? Where is it that Mr. Essa would have got your email address from?
I don't know from where he's got it.
So what, are you saying this is a fabrication? This didn't happen? He didn't contact you, he didn't set up a meeting?
No, sir, not in any way, shape,
Sorry?
or form. Not in any way, shape, or form.
But did you have a meeting with Mr. Pillay on the 3rd of December?
If you look at the next email, it
Yeah.
seems like I did confirm a meeting for the 3rd of December.
So you did actually have a meeting with him?
It seems like I confirmed the meeting, whether I don't recall I had the meeting.
Okay, well, let's go to this. So you confirmed a meeting on the 3rd of December. Are you saying that meeting didn't come about here with Mr. Essa, it came about in other circumstances?
Yes, sir, because if you would see, the meeting actually relates to something relating to the pension fund.
Yes.
And as you would see, this email was sent way before Mr. Essa had sent my email address to
Yeah.
Mr. Niven Pillay.
So how did this meeting come about, the 3 December meeting?
Honestly, I have no recollection, but it would have been, I guess, requested by Mr. Pillay through my office.
So let's just deal with this. Up until this point, I remember, and you must correct me if I'm wrong, Mr. Singh, because there's been a lot of evidence led. We have Letsema falling out of the equation. They're replaced by regiments. There's an LOR on the 6th of December. You have testified that you had a long-standing relationship, and I mean that in a loose way, with McKinsey. You had dealt with them for some time. But do I understand correctly that you had not, prior to regiments becoming McKinsey's SD partner, you hadn't dealt with regiments before?
Not to my recollection, no.
So then again, I must ask you, I mean, can you not recall, not having dealt with regiments before, on the face of 2204, you now agreed to meet with Mr. Pillay on the 3rd of December?
Yes. This may have come across via a introduction via McKinsey, but I can categorically state that this was in no way, shape, or form due to the introduction by Mr. Essa.
Okay, why don't you just speak up a bit, please, if you don't
sorry,
mind.
sorry.
Or maybe just closer to the microphone.
Yes, I'm saying that this may have come across, or actually would have come across via an introduction from McKinsey. And my interactions with McKinsey at that time was primarily with Mr. Sega. So I would assume that it would have come about as a result of an introduction from himself. But I can categorically state that at this point, there was no interactions between myself and Mr. Essa relating to this meeting.
Okay, but then, so you say it came about as a consequence of an introduction by McKinsey.
That is correct.
But it's headed Meeting Repension Fund. What is that about?
I do not recall, sir.
Okay, then let me ask you, did you have this meeting with Mr. Pillay?
I do not recall the meeting, Mr. Chair.
All right. I mean, you know the history, I take it, in relation to regiments and the pension fund. You know what happened ultimately.
Sometimes after that, yes.
Yeah. I mean, regiments, you must correct me if I'm wrong, were appointed the administrator of the second defined pension fund. And
I don't know that.
And what happened is they disbursed for themselves 250 million from the pension fund. There was litigation that ensued, and they in fact paid it back. You know that.
I'm given to understand, yes.
So your evidence is, you see the mail, it appears that you agreed to a 10 o'clock meeting on 3 December, but you can't remember the meeting.
I don't recall it actually taking place. Not offhand, no.
So can you remember the first time that you met Mr. Niven Pillay?
No, sir.
All right.
Are there other times than the first one when you met?
Sorry, sir?
Are there other times other than the first one when you met him? In other words, Mr. Mabek asked you whether you remember the first time you met him. You said no. I'm wondering whether that means you never met him, or that means you did meet him, but you don't remember the first time, but you do remember other times?
Well, Mr. Chair, subsequent to that, through the transaction advisory work, I obviously met Mr. Pillay.
Yeah.
But my first interactions with Mr. Pillay would have come about as a result of the introduction by McKinsey as their supply development partner. Prior to that, I don't think I had any interactions with regiments, Mr. Wood or Mr. Pillay.
Okay. Mr. Member?
Thank you. Let me then move to a different issue. I just want to ask your comment on one or two things before we move forward. Could you please turn up Exhibit BB27, that's the Transnet POI reference bundle. And can you go to page 184, please?
And yes.
Now, this is something that we have already dealt with, but I, in fairness, just want you to have an opportunity to comment on it. If you have a look at paragraph 5.9.12.6, the second paragraph at page 184, this is part of the Fundutsi locomotive report. The finding is Malusi and Singh therefore misled the BADC into believing that the ETC of 38.6 billion excluded the relevant costs, and it was Singh who instructed Mohammadi to change the business case to reflect that the relevant costs were excluded. Have you got any further comment to make on that?
I think, Mr. Chair, we've traversed this particular matter at the previous sessions at the Commission. Other than to say, other than to add to what has already been said, Mr. Chair, in this regard, the issue of presenting the revised variance to the board did not only occur, Mr. Chair, on the 28th of May 2014, as we would see here. The Board Acquisition and Disposal Committee, Mr. Chair, was presented with the final estimated cost of the locomotive contracts in February 2014. And at that meeting, Mr. Chair, the revised cost of the locomotives were disclosed to the Board Acquisition and Disposal Committee. And at that stage, Mr. Chair, if I recall correctly from memory, this was a meeting that happened in February 2014. I think it was the 26th of February 2014. And the revised contract value of the locomotives at that time was 52 billion. So the 38 to 55 escalation was disclosed to the board way before we concluded the contracts. And the reasons for the escalations were also disclosed to the Acquisition and Disposal Committee at the time. At that meeting, Mr. Chair, there was no indication that the board had disagreed with the fact that we had misled them. They were fully aware of the increases and the reasons for the increases, as we've discussed them in terms of the escalations, and the forex and the batch pricing, as well as the 52 billion, Mr. Chair, that I mentioned did not include the contingencies. Even when we presented to the board in May, Mr. Chair, the minutes will reflect that none of the board members actually queried or actually said that we were misleading them in any way, shape, or form. Which corroborates the original intention that I mentioned before, is that the objective or the intention by including the words that we included was to convey the fact that the business case is subject to certain economic factors that will change over a period of time. And that was the original intention and only intention behind including those words. It was not meant to mislead, or it was not meant to, in any way, shape, or form, for any other intended purposes.
All right, so you deny any misrepresentation.
That is correct.
Can I just take you to page 187 and ask you to look towards the foot of the page. The second last paragraph, 5.9.12.21, according to the spreadsheet found in Mr. Garma's emails, Callard calculated the ETC of 38.6 billion, and he's given evidence about this. The table below indicates the breakdown of the 38.6 billion according to Callard, and you'll see in the table there's an amount of 1.7 million for Forex, and then over the page 2.775 for escalation and 2.232 for contingency. Do you see that?
I see that.
And then you will see under that table, as discussed earlier in the report, the ETC calculated by Callard included Forex, escalation and contingency fees amounting to 6.7 billion. Well, if you add up the three figures that I've just referred you to, you get to the 6.7, correct?
That is good.
Then could I please take you back to your bundle 5C? And this time, if you could go right to the end, to page 2337. Are you there?
Yes, sir.
Now, this is an email from a Mr. or Miss Huma from the DPE. At the foot of the page, sent on the 31st of March, addressed to you. Morning A. While we await Transnet's official response on the 100 locomotives, we have also noted that the Transnet media release on the procurement of 1064 indicated that the value of the transaction was about 50 billion. However, the department only approved 38.6 billion as per the Section 54 PFMA application. Why is there such a huge difference between what was approved and the actual transaction value? And will Transnet be making a formal submission to explain this difference to the minister? And you then respond, is that correct, on the same day? At the top of the page. Mr. Singh?
Yes, sir.
You responded at the top of the page.
Yes.
And you say, thanks for your email. Yes, indeed, the approval was for 38.6 billion, but excluded the impacts of foreign exchange and escalations. Well, that we know not to be correct.
In the context, yes.
And then the second last paragraph, you say, typically the above items are not included in the ETC, but they were in this ETC.
Yes, sir.
I see.
But I think in the context, Mr. Myberg, we'd have to read the full sentence. The full sentence, the context of the full sentence is that they are subject to economic conditions at the time of contracting and are not avoidable, and they are mere functions of the economic inputs at the time of contract. So this again goes to the fact that they may have been included in the business case, but at an estimated value.
And then you go on to say, hope this helps, but will also provide to DPE a full report on the transaction once the BOD has approved same.
That is correct.
And we know then that it was, well, the increase in the ETC was approved on 28 May 2014, correct?
That is correct.
2 months or so later.
That is correct.
Could I ask you please to go to Bundle 5B, your other file, Transnet Bundle 5B. And could I ask you to turn to page 977?
Nine, sir.
977.
And yes, sir.
So, Mr. Singh, this is the SACA finding, South African Institute of Chartered Accountants. It's a finding that was made in respect of a hearing in relation to you, and the sanction that was imposed is that you were excluded from membership of SACA, correct?
That is correct, sir.
Now, I just want to take you to paragraph 42, and I'm not going to go to each one of these paragraphs, and I'm not going to come back to this. But by way of illustration, we know that there were a number of findings made against you in relation to the 1064 transaction. You're aware of that?
Yes, sir.
And here is one that we're dealing with now, paragraph 42 at page 989. We therefore find Mr. Singh guilty of improper conduct in respect of charge 2 within the meaning of bylaws 34.2 by conducting himself grossly negligently in failing to ensure that the business case accurately and clearly stated that the initial costs of 38.6 billion included the potential effects from forex hedging, foreign escalation, and other price escalation. Do you have any other comment? You've dealt with this already.
I think my comments have been commented.
Perhaps what I wanted to ask you, though, is why is it that you didn't participate in these proceedings?
Mr. Chair, I think I've been asked this question before, and it was based on legal advice that we did not participate in these proceedings.
It was based on legal advice
That we do not participate in these proceedings.
All right. And is that legal advice that you're not prepared to share?
I'm going to object at this point, Chairperson. My learned friend knows as well as I do whatever transpired between Mr. Singh and his legal advisors are privileged.
Well, he hasn't demanded that he should share it. He has asked whether he's prepared to share it. And
But still, Chairperson, that's just another way of getting a witness without informing him of the consequences to waive his privilege, and I do object.
No. He obviously knows these things, and he just wanted to confirm that Mr. Singh would say whether he is prepared to share it or not. What was the answer, Mr. Singh?
Sorry, sir, I didn't hear.
Are you prepared to share it or not?
No, sir.
Yeah, okay.
Fair enough. Could I then...
Mr. Chair, before we move off this point, Mr. Chair, I would like to just direct the Commission's attention to paragraph 43 on page 989.
Yes.
Basically, they conclude, which states, for paragraph 43 states, we accordingly make no finding in respect of charge 1, though we do express a view that we would have a difficulty in concluding that Mr. Singh was dishonest in misleading the BATC or the Transnet board.
Yes.
I'm not going to take you through, there's a series of findings made against you here. You accept that? I mean, there's findings in relation to the hurdle rate, et cetera, et cetera. There's no, I mean, the point is that your evidence is your evidence. So insofar as there are findings made against you, you would take issue with them on the basis of the evidence that you've
That is
given.
correct.
There's no point in us going through the finding on a sort of a blow-by.
That is correct, yes.
All right.
You are obviously aware of the findings. You have read the ruling.
Yes, sir.
Yes. I thought I must ask because somebody else had testified that he had not read findings that had been made in another forum against him. So at least
No,
you
sir,
have
I-
read, you are aware. Yeah.
Yes, I.
Okay, all right.
Chairperson, I see that it is 11:15. Do you intend to take tea? This might be a convenient
Yes,
point.
yes, let me take the tea break. The tea break might be longer than 15 minutes because I need to attend to something. But at the most, it should be 30 minutes. I hope it will be less than that. Okay. We adjourn.
page 694. That's the second money flows report that we've already dealt with. This is something arising from Mr. Peter's evidence that I would like your comment on. Now, you'll remember that the second money flows report deals, amongst other things, with the confinement of those 4 contracts to McKinsey. You remember that?
Yes.
And if you go to page 697, you see some reference to that at paragraph 8. Those are the contracts that we're familiar with: coal line contract, NMPP contract, etc. Now, the annexures to this report include the RFPs submitted by McKinsey. But I want to take you to Annexure 3. If I could ask you please to turn to page 743.
743.
743. Annexure 3 comprises a few pages of emails. And perhaps in the interest of time, I can just take you to page 745. You'll see that this exchange of emails is between Indran Pillay of Regiments and Janine Kumar of McKinsey. And if you have a look at 745, at the foot of the page, or in the middle of the page, Kumar writes, "Hi Indran," and it's headed Re-SD Commitment. Now, this is in 13 June 2014. And what you see from these emails, Mr. Singh, is that this is a costing of the skills development component. That's what McKinsey and Regiments are interacting about. And she says, "Hope you are well. I've noticed that the contract values you are using are different to the contract values I have on my side. I have attached a spreadsheet highlighting the differences." You see that?
Yes.
And then the last paragraph says, "Once this has been done, please could you resend us the ST value summaries and your SD plans," so that supply development plans, etc. Then at the top of the page, you'll see that Mr. Pillay responds. He says, "Hi Janine," and his response is, "The numbers that I'm using is based on the Anoj memos to Brian regarding these projects. Does not include expenses." And you see that comes from him. Because if you turn to page 744, you see at the foot of the page, Pillay, 13 June to Kumar. Do you see that?
I see that.
Now, what I just want to ask you about is when Mr. Peter gave evidence, he in fact alerted us to this. He made the point, as I recall, that this is highly irregular, that Regiments, in the form of Mr. Pillay, had the memos between yourself and Brian, assuming that to be Brian Malefe, in relation to these projects. They're memos that we went through before. Would you agree that it would be utterly irregular for them at this point in time, where they are looking to complete their RFP and to put in a tender, albeit on a confined basis, to have sight of those memos?
That is correct, sir.
But perhaps I could just take you to those memos. If I could ask you to go to Forming. Bundle BB 2.1 D. And could I ask you please to turn to page, the right-hand side, PSV 1283.
1283.
Yeah, 1283. There's 4 memos. But it's just, the 1283 deals with coal. And you confirm that that's a memorandum from yourself to Brian Malefe.
That is correct.
And I'm not going to take you to all of them because I don't think this is contentious, but there's similar memos, Mr. Singh, in relation to each of the projects, correct?
That is correct.
And it was upon the adoption of these memos that McKinsey were then invited to put in an RFP.
That is correct.
Have you any idea then how regiments come to be in possession of these memos?
I have no idea, sir.
And would you, like Mr. Peter, consider it highly irregular that they, on the face of 745, were in possession of them?
Yeah, that would be so, sir.
I want then to go back to where we ended off last time, and that is in relation to the question of the justifiability of the increase in the ETC. Now, what we know is that the increase was a large one. It equated to 41%, 15.9 billion in just over a year. Mr. Chabi, and we're going to come to your evidence and that of your expert, but let me just summarize it so that we locate ourselves. Chabi opines that the increase was not reasonable. According to him, an 11% increase to 42.8 billion would have been reasonable, or an 18% increase to 45.4 billion, allowing for Transnet engineering costs, would have been reasonable. Put differently, at best, on his opinion, the increase was 9 billion too high, which equates to approximately 56% too high. So you're familiar with his evidence?
That's correct.
Now, in the interest of time, Mr. Singh, what I intend to do, or what I plan to do, was to ask you really about 4 things. The first related to the hurdle rate, the second, batch pricing, the third, cost escalation, and the fourth, contingencies. We've already dealt with the hurdle rate. I'm not going to return to that. So I'm not going to go through all the aspects of the increase. I'm going to confine myself to leading you on the batch price, the cost escalation, and the contingencies. We know that those 3 things made up, I think, just over half of the 16 billion increase. So I'm going to focus on those 3 things, if I may.
That's fine, Mr. Maibach.
Sure. Just on the issue of the hurdle rate, I don't know if that's what you wanted to address. I don't intend to go back to that. Is there anything you want to add in relation to the hurdle rate and the questioning previously?
Yes. Okay. Just, there was, Mr. Chair, if I may, on the hurdle rate, you will recall that Mr. Maibach led some propositions in this regard at the previous hearing, and the issue was let's call it the allegation of the manipulation of the hurdle rate to justify the project. And you will recall, Mr. Chair, this was the 18.56% versus the 15.2% versus the 16.3% issue. Mr. Chair, and one of the questions that Mr. Maibach had put to me was, do we know if the project was actually an NPV positive project at a hurdle rate of 18.56%? Because that was the official hurdle rate at which the business case was approved. Mr. Maibach then went on to say that on approaching Mr. Chabi indicated that this would probably be a 3 to 4 week exercise to be able to understand that. Mr. Chair, that disturbed me a little bit, and then I went on to do some investigations of my own. So if we have reference to the business case, the approved business case, Mr. Chair, we will find that there is sensitivities relating to the hurdle rates and various other components. And maybe if, Chair, you would allow, maybe we can actually go to the business case and I can demonstrate the effect of the 18.56% on the revised ETC.
Okay, let's go there. Right.
The business case found in kilowatt, BB4B, and at page FQC 401, 402 in fact.
Thank you, Mr. Chair. FQC 402, you said?
Yeah, I think it starts at 402.
So, Mr. Chair, you will recall that when Mr. Myberg put this proposition to me, my first response was that the business case was prepared on a conservative basis and actually didn't include what we had termed operational efficiencies relating to the acquisition of additional locomotives. So if we had to look at the end state of the revised ETC of 55 billion and its impact on the original business case, we would then have to include these, let's say, operational efficiencies. If we go to page 20, let me just get it here and I'll give you the reference. If we have regard to FQC 423.
423.
That's correct.
Okay, and
If you then look, Mr. Chair, at the bottom of the page, you will see a heading called operational efficiencies. And then if you look at the fourth line in that paragraph, and it says, rightly and conservatively, the fleet plan does not estimate unproven potential additional operational efficiencies.
Sorry, Mr. Singh, why don't you just read into the microphone?
Oh, sorry, sorry. On line 4, Mr. Chair, you will see it says, rightly and conservatively, the fleet plan does not estimate unproven potential operational efficiencies that could be achieved from optimization of flows based on new technologies. And it goes on to explain what those new technologies are. So that basically confirms that the business case did not account for these operational efficiencies. Mr. Chair, if you then had to go to, I'll give you a reference now. Let's get it here. We then had to go to, Mr. Chair, page FQC 452.
yes,
Mr. Chair, there you will see a table, and it's marked Exhibit 38.
yes,
And then you will see, Mr. Chair, in that table, there's blocks, 1, 2, 3, 4 blocks. So we're looking at the fourth block, and it is numbered 7 in a small circle, if you could see that.
yeah,
Then if you move towards the right, Mr. Chair, you will see that there's an NPV of 2.7 billion.
yes,
Then you will see an NPV of negative 0.8 billion.
yes,
and then you will see a NPV of 6.3 billion.
Yeah.
So, Mr. Chair, the relevance of these numbers is as follows. So, item 7, which is that block that I've referred you to, basically tries to understand what happens to the NPV if you have a 5% improvement in operational efficiency, or if you have a 5% decrease in operational efficiency. And it measures it against the base case NPV, which was the 2.7 billion, okay? Which was, as we know, is in the business case. And that 2.7 billion, Mr. Chair, is at the 18.56% hurdle rate. So, Mr. Chair, if you then move, as I said, the 2.7 billion is at 18.56, so that is base case. If you then have a 5% deterioration in operational efficiency as a result of the new locomotives, that 2.7 billion becomes a negative 0.8 billion, which is the second NPV number. But if you then have a 5% increase in operational efficiency, you then have a NPV of 6.3 billion, which means the 5% operational efficiency captures an additional 3.6 billion in NPV value. Now, Mr. Chair, why is this of relevance? Because you would recall that in the board memo that we submitted to them, we were fully transparent with the board to say to them that at the original hurdle rate of 18.56%, at 55 billion, the NPV would be 1.2 billion negative. So that was contained in the board memo. So what we are now saying is, if we had taken into account the operational efficiencies that the business case did not take into account, we would have had a 3.6 billion additional NPV for this table that was included in the business case, which would be more than sufficient to offset the 1.2 billion negative NPV that we disclosed to the board. So in summary, Mr. Chair, if we had to rewrite the memo to the board, we'd probably have to say that the operational efficiencies were not included in the business case and in the original NPV calculation due to us wanting to be conservative. And we've disclosed that in the business case. Adjusting for that, you would have had a 3.5 billion rand improvement in the NPV, which would offset the negative NPV of 1.2 billion at the original 18.56% hurdle rate. So, Mr. Chair, the 15.2%, I've done some investigation regarding that as well. And the 15.2% hurdle rate, Mr. Chair, actually is not of my making, as Mr. Lehe alluded to in his affidavit. That 15.2%, Mr. Chair, was actually calculated by group financial planning, which is a function within my area at Transnet as CFO at the time. And there was a gentleman called Mr. Thabo Lebelo who was heading up that division at the time. And he alluded to the fact that there were very specific reasons as to why the 15.2% was actually calculated and shared with TFR, which was Transnet-related at the time, which was then used in arriving at the, let's call it, revised NPV. But Mr. Chair, as I've demonstrated, whether you look at the original 18.56, which is the worst case scenario, the NPV of this project would still have been positive. If you look at the 15%, it would have been even more positive. And obviously at a 16%, it would have been positive still. So at any of these hurdle rates that one would choose, the business case for the locos still was positive.
So, Mr. Singh, can I ask you to go, please, to page 727? This is the ETC memo.
7?
The same bundle, 727.
Sure.
At paragraph 80,
Just 1 second.
Are you there?
7.
So it says the updated NVP results in a positive NVP of 11.68 billion at the new hurdle rate of 15.2.
Sorry, sir.
Do you-
7?
727.
720.
Now, previously you accepted that that is an error, the 15.2. It should be 16.24. Do you change your evidence now?
$727.
727.
Down there.
Paragraph 80. Previously you accepted that 15.2 was wrong and it should have been 16.24. Do you change your evidence?
Mr. Chair, on the, based on my discussions with Mr. Lebello, he has indicated that the 15.2%, according to his recollection, was approved at some point in time. But he has subsequently left Transnet, so he doesn't have access to his emails or any documentation. So he doesn't have the ability to be able to give us indications as to where this was approved.
But we've seen your policy that you signed,
Yes.
and that reflected 16.24.
Yes.
All right.
Yes.
So there's one error. And then you say the NVP would become negative R167 billion at the original hurdle rate of 18.56. You say that's wrong as well.
No. So in arriving at this,
Yeah.
we actually had full transparency with the board to say that we have at 18.56 a negative NPV.
Yeah.
Okay? So in order to deal with the proposition that this was a loss-making project, I'm suggesting
I understand that.
it's not an error.
Well, what you're saying is that it shouldn't read that. What should it read?
Mr. Chair, what we are trying to say is that if we had to compare the original 18.56, we would have a negative 1.6 billion in PV. Taking into account the fact that the business case did not accommodate the operational efficiencies that would accrue due to new equipment, if we adjust for that, you would have a positive NPV.
All right. So that should have said it was positive even at 18.56.
Yes.
So it's wrong. In one paragraph, got two errors.
I wouldn't classify them as errors.
All right. I see. But just so that you understand it, what's not dealt with in this paragraph is the officially approved by you hurdle rate of 16.24. Now, perhaps I can just put this to you and we can put in an affidavit if it's contentious. We contacted Mr. Callard to find out whether or not he could run the sums for us at the hurdle rate of 16.24%. And Mr. Callard still has access, as I understand it, to the McKinsey model. There was a model that was used in producing this kind of information. And he is unable to run those figures. He's unable to tell us what the NFB, whether it would be positive or negative at 16.24. Apparently it's a very big job if you don't have the model. You say it's not so.
Well, I've just done it for you.
Yeah. I see. Well, what have you done?
I've demonstrated that this project is still NPV positive at 18.56.
All right.
So if you look at the 16% hurdle rate, it would be probably bigger. The NPV will be larger.
All right, Mr. Singh. So you wouldn't agree with what Mr. Callard has to say? And Mr. Chaubi, you said that I had said that it would take him 3 weeks. That was to run the 16.24. Of course, he doesn't have the same access to information, perhaps, as Mr. Callard has. But you doing a sort of a broad analysis, you come to the conclusion that it would be positive even at 18.56.
Based on the business case and the information we have, yes.
Accepting your evidence that you've given about how you interpret that table.
Well, that is the officially approved business that was prepared by Mr.
But the point is, that's not what you told the board. You come with that version now when the concern is raised.
Well, Mr. Chair, as I said, The concern should have been raised by the board at the time when they were presented with a 1.6 billion rand negative NPV project.
The concern should have been raised by the board.
Yes.
You presented this memorandum to the board.
Yes, in full disclosure that there was a negative NPV.
Let us then, have you got anything else to say about the hurdle rate?
No, sir.
Do you have any explanation why you didn't insert in your memo your officially approved hurdle rate?
I think at this point in time, this was obviously the numbers that were run, that was included in here, was done as of the contract signing date, which was obviously the end of March. And that is why in my affidavit, we had the 3 columns which you pointed out at the end of the last session, which was the middle column, which was the 31st of March 2014.
Yes, I think we went through that.
Yes.
If you've got anything to add to that?
No.
All right. So, can I ask you to go? Perhaps we can just keep this document open to the ETC memo, as we call it, which you find at page 714.
Okay, let me just get the... On this.
And perhaps I could ask you to turn, because the increases are conveniently set out in a schedule or table at 718. Now, Mr. Singh, just again to summarize the position, and then we'll go into the versions. I'm now dealing with batch pricing. 2.7 billion of the 15.9 billion increase was attributable to batch pricing, arising from a reduction in batch sizes to 40% and 60%. Do you agree with that?
That is correct.
And what happened is there were 2 bidders for diesel and 2 bidders for electric locomotives, respectively. Correct?
That is correct.
And just for the assistance of the information of the chairperson, that appears from, Mr. Chairperson, 718. You see there's a column on the right-hand side, and then to the left of the figures, you see A, B, C, D. So that's note D. It says batch pricing adjustment for reduction of batch size to 40/60%, and the cost of that, Mr. Singh, as you've confirmed, was 2.7 billion. Correct?
That is correct.
Now, what I'm going to do on each occasion is to take you to Mr. Chabi's evidence, just so that you know how I'm going to deal with it. I'll then take you to your own evidence, and insofar as your expert also deals with it, we can go to your expert's evidence, and then we'll go to Mr. Chabi's reply. So you can feel free to respond whenever you want to, but you'll certainly get an opportunity. So we'll first deal with Chabi, then with you, stroke your expert, and then Chabi's reply. You can perhaps keep this page open because you're going to come back to it. Now, Mr. Chabi, when I talk about his evidence, he produced a report that he testified about, and that you find at Exhibit BB, 8 in brackets B, point 1.
BB 8.1.
BB 8 in brackets B, point 1. If you could turn, there are only one set of numbers in this bundle, to the red numbers, page 40. Now, Mr. Singh, you would appreciate in the interest of time, I'm not going to go through everything. We have your affidavits, submissions will have to be made, and the chairperson will have to decide this question on them. I'm going to highlight the things that I'd like you to deal with, and sometimes I'm going to paraphrase things. So at page 40, paragraph 9.5.11, Mr. Chaubi says, 9.54.11, there are two elements to consider, batch pricing and breakpoint pricing. Bidders provided...
I'm sorry, Mr. Mybeck. I do have page 40, but the paragraphs you mentioned don't seem to be here. So maybe you have got the wrong bundle. Is it BB8B.1?
Yes, and two in the same bundle. So BB8 in brackets B.1.
Yes, and page 40 I've got, but the paragraphs I've got are 16.30, 16.31 to 33.
I think your registrar has another bundle for you.
Oh, thank you. Yes, I've got it.
So at 9.54.11, Mr. Chaubi says there are two elements to consider, batch pricing and breakpoint pricing. Bidders provided indications of what it would cost them in the event of contract orders being terminated. The request for proposal stated that Transnet did not expect bidders to charge for changes in quantity. In the circumstances, batch pricing should not have been taken into consideration. I've therefore not allowed for a batch adjustment cost. Then if I could ask you to go to page 45. That, incidentally, was Mr. Chaubi's summary at the beginning. If you go to page 45, he then deals with this further under the heading batch adjustment cost. And he says at paragraph 10.15, the RFP in section 3.1 defined breakpoint pricing as a premature termination of a locomotive order by Transnet. It outlined the period during which break pricing would apply, which was the delivery period. I interpreted this to mean that break pricing could only apply once a contract was in place between Transnet and the OEMs. The batch price adjustment cost in the memorandum appears to be a breakpoint pricing cost. The idea behind breakpoint pricing is that financial resources would have had to be committed by the OEMs to ensure that Transnet's order from the contract stage is met. And then if you drop down to the next paragraph, the pricing schedule provided by bidders as per the RFP requirements were in respect of breakpoint pricing. Using the breakpoint pricing schedules provided by the bidders, a figure of 7.2 billion was obtained, figure that we've mentioned, assuming OEMs were contracted and orders were terminated at the point where CNR and GE had supplied 232 and 233 diesel locomotives respectively instead of 465, and BT and CR had supplied 240 and 359 electric locomotives respectively instead of 599. And then if you go over the page, at paragraph 10.17, the RFP in section 3.1, prior to requesting breakpoint pricing schedule, stated that Transnet required flexibility to exercise options including postponing, suspending or changing quantities, and that Transnet did not expect to pay a price premium to exercise this option. Transnet exercised this option when it accelerated the delivery schedule and does not appear to have paid a premium for it. I concluded that because Transnet expected to pay a price premium in the event of a premature termination of orders after contracting and not on splitting of orders prior to contracting with OEMs, the cost for splitting the orders was not warranted. So that's what Mr. Chaubi says. And perhaps I could just take you to the point that M&S makes in its report, which it makes perhaps a lot more succinctly. Could you turn, please, to the POR bundle, Exhibit BB27.
POI.
Yeah, so keep that open. Exhibit BB27. Could you turn to page 332?
Black or red? Black or red ones?
No, black.
332.
332. So right at the foot of page 332, M&S at paragraph 4.1.11, you see batch pricing and D, that's the D in the schedule. Quite usefully, they quote for us, sections 3.1 of the RFP relating to the acquisition of 465 diesel and 599 electric locomotives reads as follows, quote, Transnet requires flexibility in exercising options for the acquisition of the locomotives. These options may include suspending or postponing the delivery of the locomotives until a date later or changing quantities. Transnet, however, does not expect to pay a price premium should it exercise any of these options. You see that?
I see that.
And then they go on to say, our understanding is that this flexibility was required to enable Transnet to adjust its orders within the 7-year time frame, and therefore Transnet expected the OEMs to price this option in. We have therefore not allowed for batch pricing adjustment price in our analysis. Really on their interpretation of 3.1 of the RFP. So, Mr. Singh, can we now go to your version? And let me take you, please, to bundle 5C. And can I ask you, please, to go to page 1452. Yes.
Black, red. Black.
Unless I tell you otherwise, they're always black.
Okay.
Yeah. And you deal with this.
Mr. Mybeck, this might be the convenient time for that 5 minutes
Thank you.
adjournment. I'm sorry about this, but I just need to fix something. We'll adjourn for 5 minutes. team representing Mr. Anoj Singh on a confidential basis. It will be made available to them by the evidence leader of the Commission in the Transnet workstream. It is recorded that witness 3 has indicated that he has no objection to this amendment of the order. Have I captured it correctly?
I think so, yes.
Yes.
Chairperson.
No, we're quite happy. Thanks,
Yes.
Chair.
Okay, all right. Thank you.
Thank you.
Thank you. I think the registrar will just, or the legal team can make sure that later on the order is printed so that it's available in hard copy.
Thank you, Chairperson.
Yeah. Thank you.
So, Mr. Singh, I think what as I discussed with you in the break, what I will do is I'll paraphrase Chabi. I'll then take you to various parts of your affidavits where you deal with the question. Maybe just give a thumbnail sketch of that and then give you the opportunity to respond. So, if I could take you to page 1452, you deal with batch pricing from paragraphs 90 to 101. At paragraph 94, you say the RFP contemplated splitting. However, Transnet reserved the right not to pay a price premium for excising either the splitting or the break pricing options. At 95, I reject the finding of M&S and the opinion of Chabi regarding batch pricing for the following reasons. And you go on then to give a definition of premium. You say at paragraph 100, it is all relevant time understood that Transnet moved for price batching. The RFP contemplated a reasonable cost. Transnet never contemplated paying a zero cost for batch pricing. And then if I could take you to page 185, you deal with it again.
Paragraph.
1485. From paragraphs 233 to 239. You say at 233 that Chabi seems to be confusing two concepts that are different. These are the concepts of batch pricing and break pricing. And then, if I could ask you to go to 1489, you deal with the subject again in paragraphs 257 at the foot of the page to 261. And again, you deal with the question of break pricing and batch pricing. Now, just so that perhaps I can just make this point. What Mr. Chabi's evidence is it's not clear to me that he misunderstood the distinction. What he says is the 2.7 billion figure, he assumes that came from...
I'm sorry, I see Mr. Singh, you seem to have run out of space for the files there. You want some to be put behind you? Or will you manage?
I think these are relevant to...
Oh, for
Yeah,
now,
to-
okay,
for now,
okay, all right.
So as I understood his evidence, he was saying, well, you could do the sums, and the 2.7 million related to break pricing. So essentially, though, it seems that the controversy relates to this paragraph or section 3.1 in the RFP, which has been quoted. There's a whole lot of other things said, but what is your response to that?
I think, Mr. Chair, for us to navigate through the issue of batch pricing, I think it's important for us to understand the reasoning behind the need for, let's call it, the splitting. And for that, Mr. Chair, we probably need to reference the business case, and that will give a background behind why we needed to split in the first place. And we can then take it from there and run it forward until we actually incur the cost.
Sorry, could I just say this insofar as it's in the interest of time? From the legal team's point of view, we take no issue with the decision to split. It's really the issue of the cost in relation to that, because we know that the decision to split, that was authorized by, I think, the BADC and the board. And in fact, I think you correctly point out that even Fundutsi finds that there's nothing necessarily irregular about that.
Yes.
It's the question of cost that I would like to direct you to in particular, and it's the fact that it added on the 2.7 billion. So I don't want to prevent you from going to the business case if you want to, but we don't take any issue with the splitting it's per se, it's the cost.
Okay. Mr. Chair, in summary, okay, the reason or the rationale for splitting emanated from the risk that was included in the business case. If I recall on page 8 and 48 of the business case, there was the business case identified a shortfall of about 50 million tons and 150 locomotives. The business case further identified, Mr. Chair, the fact that in order to mitigate this risk that was identified, that no more than 2 OVMs per locomotive type will be awarded the contract to supply the locomotives. That is recorded in the business. And we can go to it, but in the interest of time, probably we can take it at face value for now. But it is recorded, Mr. Chair. And, Mr. Chair, the business case further goes on to actually identify the impact that this splitting will have on the total cost of ownership of the electric locomotives and the diesel locomotives. And the business case identifies that there is a bigger impact on the electric locomotives rather than the diesel locomotives in terms of the splitting. The business case further then in the procurement strategy of the business case section identifies again the fact that we would need to split the award. And I know Mr. Myberg is interested in the cost, but in order to understand the cost, we need to understand the build-up to why that cost actually was incurred. And this is the reasons, therefore, is contained in the business case, as I've just explained. The RFP, Mr. Chair, as quite correctly pointed out, does contemplate these 3 options: splitting, breaking, and terminating. It does contemplate the fact that we said we will not expect to pay a price premium. As we've mentioned already, that, in my understanding, does not mean we're not paying anything. It means that we will pay something, but a reasonable cost. Mr. Chair, in terms of the, I've dealt with the RFP, I've dealt with the business case. Mr. Chair, as Mr. Myberg has already alluded to the fact, the board was fully aware of the fact that the splitting, they actually approved the splitting. The BADC at its meeting on the 24th of February, I think it was, or 26th of February, were given the financial implications of the splitting, being the 2.7 billion number that we talked about. So the board was aware of that before we had actually signed the contract. The Kunduzi report, as we said, also concurs that the splitting was allowed by the RFP. And in actual fact, they actually go on to say that the splitting was actually allowed for by the PPM, or the Procurement Procedures Manual of Transnet, and therefore didn't find anything untoward into it. They actually went on further to say that the splitting of the award actually went on to save Transnet some 660 million, Mr. Chair. So from that perspective, Mr. Chair, if you look at all of these things that I've outlined, it's just a matter of consequence. The 2.7 billion was the consequence of all of these decisions that had been taken. up to that point in time.
So I just want to correct one thing. The rationale is understood, and the fact that I think the procedure manual allows for the splitting. I just must correct myself. There is an issue around the procedure in this regard. You know that Mr. Leher raised it with you. I'll come to his evidence in a moment. But so as I understand what you're saying, it's you accept that the RFP said that Transnet doesn't expect to pay a price premium. You saying, well, that we didn't pay a premium.
Yes.
You can't expect to pay nothing.
Yes.
It's really a fight about premium.
Exactly.
Okay. So can I take you to Mr. Chaubi's response to you, and then I'll give you another chance to respond. You find his response at page 1827.
Which one?
Sorry, that's your bundle 5C.
18.
I beg your pardon, 1827, not 57. Are you there?
Yes.
Now, what Mr. Chaubi says is he quotes at 64 and 65 the RFPs. And the words that Transnet, however, does not expect to pay a price premium. You see that in the quotations in 64 and 65. Then he says at 66, Mr. Singh is therefore not correct in submitting that Transnet reserved the right not to pay a price premium for exercising the change in quantities, splitting or break pricing options. At 67, he says, in line with the definition of a price premium noted by Mr. Singh, I submit the following. It says the benchmark or ordinary price in question as per table 2 of the memorandum on the increase in ETC, we know what the memo is, labelled best and final offer per board submission excluding hedging and escalation circa 29.4 billion. Then sub 2, the price premium or sum added to the ordinary price above charged to Transnet for changing quantities as per table 2 of the 1064 memorandum, labelled batch pricing adjustment or reduction of batch size to 40/60% was circa 2.8 billion. In percentage terms, this represents approximately 9% of the benchmark or relative price of 29.4 billion. 68, Mr. Singh's submission that Transnet never contemplated paying a zero price premium for changing quantities is therefore unfounded. Do you have anything to add to this or to what you've already said?
No, Mr. Chair. I think in terms of we can continue splitting hairs about price premium and reasonableness of the price premium. Mr. Chair, it is a fundamental and accepted commercial basis that fewer items of something cost more than a larger quantity of the same item. So if you buy 1,000 of something, it costs you per unit less than if you buy 10 of it. That is the concept that we're actually discussing here. The issue that, the fact that this quantum was contemplated in the business case, there was a rationale put forward for it in the business case, there was contemplated in the RFP. The board exercised the option, understanding that there was going to be a financial consequence to the fact that this option was exercised. That quantum has been quantified at 2.7 billion. And Mr. Chair, the reason why this 2.7 appears in the reconciliation to the board is because, notwithstanding the fact that the business case contemplated, as I've outlined, all of the issues relating to batching and the consequences of batching, it did not quantify a value for batching. So it contemplated the act of batching, but it did not include a value for batching. Because it did not know. When the business case was drafted by Mr. Keller, there was no way of quantifying that, exercising that option. And therefore, the RFP was prepared in such a way that if we needed to assess this exercising of the option, there would be sufficient information available from the tenderers to be able to identify and quantify what this impact would be. And that is why the RFP was structured in a manner that requested this information from the OEM.
Chairperson, I see it is just past 1 o'clock.
We can do one of two things in recognition of the stop-start for which I'm responsible this morning. From my point of view, if it's convenient to continue maybe until 1:30, we can do so. But if we may as well stop at 1 and then continue at 2, that's fine also. So I'm just checking with you in terms of what you have.
I certainly would value the opportunity to see if I can carry on at least for another half an hour, to see if I can
Yes,
at least
okay.
finish this and maybe another topic.
Yes, I think there should be no objection. Yeah, let's continue. Yeah.
All right. So what do the words price premium mean? I mean, I understand what you say, but when it says that the RFP, that Transnet, however, does not expect to pay a price premium, what was contemplated there as far as you're concerned? What was it not expected to do?
Well, it was certainly not expected to not pay anything, because as I've said, it's a normally commercially acceptable principle that if you're buying 1,000 of something, it would probably...
But then what do those words mean, Mr. Singh? That's, I think, what I'm getting at. I understand your position, but what do the words mean?
It would mean that we'd have to pay something.
Well, precisely. It
Yes.
said it doesn't expect to pay anything. It
No,
doesn't expect to pay a premium.
Yes, which means we would be expecting to pay something, but not excessive.
So is that your interpretation?
Yes.
You would pay something, but not excessive.
Yes.
Now, I mentioned to you the evidence of Mr. Lahir. Again, in the interest of time, I can take you to his affidavit. I can even take you to the transcript, which you've probably seen. I mean, to paraphrase, during the course of the negotiations, you would have seen that Mr. Lahir raised with you, and I think Mr. Gianni, his concern about this. And in particular, he said, well, look, if we're going to split these batches, shouldn't we have done this, and shouldn't we even go out to tender again? Because there might be some people who could actually meet the same price on a reduced batch. You recall that concern being raised by Mr. Lahir?
No.
Let me take you to his...
I'm aware of his affidavit, and I know what he said. But
Okay, so you say that didn't happen?
No.
Well, then I need to take you to portions of it, so
Yeah, sure.
you can comment on it. Let's go to BB4F. Where you'll find this is in Transnet Bundle 4A. Are you there? Transnet Bundle 4A? No.
Not BB4.
No. So it's Transnet Bundle 4A, not BB4A.
Oh.
So it's one of the latter files.
Okay. I'm there, sir.
So this is a file that's got a number of dividers. Can I take you to the last divider? That's BB4F. Are you there? Okay. And can I ask you please to go to page YIL14? That's on the right, and on the left-hand side we can perhaps stick with, it's 234. Are you there?
No, I'm there.
So at 51, Mr. Leher says, during one caucus, I raised with Singh and Gianni the issue of the original bid price per unit must be retained by bidders, even though the batch sizes were reduced. I pointed out that if not, it would mean that their prices may be higher than the other unsuccessful bidders who could have given lower prices for a smaller batch. Singh and Gianni disagreed, and Gianni said that the bidders were not evaluated on smaller batch sizes. He said all bidders were requested to provide breakpoint pricing and were not evaluated on smaller batch pricing, and that no bidders provided pricing for a smaller batch. And at 52, during the same caucus, I also asked Mr. Singh and Gianni whether TRF should not have gone out to all bidders pre-award to ask for a price based on a 50% batch. Mr. Gianni responded that it wasn't known that a batch size would be 50%, and he then refers to the recording. Do you accept that Mr. Leher raised these concerns or queries?
No. All right.
So you're saying, no, you don't accept that he did raise these concerns?
That is correct, Mr. Chair. That is correct, Mr. Chair.
Yes. Okay.
Then let me take you to the next file. This is Transnet Bundle 4B. So Transnet Bundle 4B, it should be wherever you pulled out this file, it's the next one. So it's Transnet Bundle 4, and you had pulled out A. This time you must pull out little b. Could you turn to page 736, please? So, and let me direct your attention to paragraph 17. This is another affidavit by Mr. Leher. In addition to the evidence presented in my main statement.
So this 736.
Yes.
736, paragraph 17.
I've got an FQC. Is that all?
It's the left-hand number,
Yeah.
736. Have you got an FQC file? That's a CALOD file. What you need to do is there's a series of dividers.
Yeah.
You must go to the divider 4F3. But this file is consecutively paginated, so you should, if you're in the right file, be able to find a page 736.
The bundle
Sorry, this is
is
Exhibit BB.
bundle 4B.
No, no.
4B.
No, you're in BB 4B. You want to be in bundle 4B.
Where are we again, sir?
Okay, 736. Are you there? Paragraph 17.
Yes.
It says, Mr. Leher, in addition to the evidence presented in my main statement under this heading in paras 51 and 52, which I read to you, I'd like to add that during a caucus on 7 February 2014, I raised with Messrs. Singh and Gianni that we had not communicated to the bidders that the pricing per unit must remain the same. That we had communicated to the bidders that the pricing per unit must remain the same, albeit that the batch sizes had been reduced. I pointed out to them that it was important to retain the price because the mandate required the same price. Do you recall Mr. Leher having raised that or not?
Mr. Chair, he did not.
Well, then if I can take you, please, to, you'll see at paragraph 18, Mr. Leher refers to the fact that Mr. Callard had put up a transcript of the discussion in question. Now, that transcript you find at page, unfortunately it's in the same file, at page 914. Are you there?
914.
So 914, the transcript headed negotiation team meeting at Transnet on 7 February, extract from video recording. You'll see present included Mr. Leher and yourself and Mr. Gianni. Do you see that?
Yes,
Now,
I'm sorry, your answer was not audible, Mr. Singh.
sorry, sir, I am at the page, yes, I see.
Yeah, okay. And you do see that according to that page, you were present?
Yes.
Okay.
so let me take you to page 916. And let me ask you to have a look at line 7, the right-hand side. This is Mr. Leher. Now that we are reducing the batches by 50%, we want the same price. And if we don't keep the price, then we got a big problem, a sort of deal breaker. So Mr. Leher raises that issue, doesn't he? Well, I take it you will accept it. You've read this transcript, Mr. Singh?
No.
Okay, well then let me take you through. All right. So at line 8, I read again. On the right-hand side, now that we are reducing the batches to 50%, we want the same price. And if we don't keep the same price, then we've got a big problem, a sort of deal breaker. You say, well, I would have had a problem from her for obvious reasons. And our mandate says we must get it, must get rid of this batch pricing because we must get the same price. I hope Brian has not signed off on it yet. You say, we have not given it to him. Sorry, we have not given it to him. Hey. Gianni, no, I don't think. But that is just a wish, you know. In fact, some would be laughing you off and think you're smoking something. Mr. Leher, yeah, but you see, we have a big issue then. Because if we don't get that, sorry, Tabby, if we don't get that price, some, and then you go over the page to 917, Mr. Leher carries on at line 9. The issue we have around that, and it now comes back to evaluations because they provided us, if we have to go back on it, it is critical that they give us the right price, because if it is not, some of the other bidders give us a better price on a smaller batch. So do you see that Mr. Leher raises these issues that he set out in his affidavit? And then Mr. Gianni says, no, but Yusuf, we've never had batches, and I think we must not confuse this thing. And so it goes on. And then if you go to page 918, and if you look at line 11, 12, 13, 14, 15, Mr. Leher, just a question. Should we not have gone pre-award back to all bidders and said for 80% give us a price? And Mr. Leher gave evidence about this transcript, and to the best of my knowledge, he said that should be 50%.
Sorry, so where are you?
At line 15.
915.
15, yeah, page 918. So on the face of it, Mr. Leher appears to have raised these issues with you. Would you agree?
It would seem like so.
So do you have any comment on his concerns?
But Mr. Chair, this is Mr. Leher.
Mr. Singh, sorry, won't you just speak into the microphone, please? I know it's difficult because you're looking at the files at the same time. I understand that.
Sorry, Mr. Chair. In response to this, Mr. Leher is raising issues that relate to procurement, in that we should have, I would assume, the point he's trying to make is that we should have given everybody the opportunity to have bid on an equal footing if we're now reducing the batch size. And Mr. Chair, Mr. Gianni was the, how could I call it, the procurement subject matter expert that was from TFR at the time. He had run the procurement process up to that point in time, and we would have taken our cue from him in terms of this matter. In addition to that, Mr. Chair, Mr. Leher, having made or had the concerns that he had, still continued with the negotiation process. Went through the process, received the prices, received the break price input from the OEMs, which was quantified at the 2.7 billion that we have just discussed, and accepted the same eventually. And also participated in the BADC discussions on the 24th of February when these matters were discussed, and didn't raise any of these concerns at that stage either.
But what do you make of the content of his concerns? I mean, what his evidence was is he raised it with you. He got a sense that you and Gianni both didn't agree with him, and he considered you senior people. That was the thrust of his evidence. What is your comment to the merits of his objection?
Mr. Chair, as I've said, I think the main issue that Mr. Leher was raising was an issue of fairness in terms of procurement. And as I said, I would have deferred to Mr. Gianni at the time in terms of whatever his view was in relation to the fairness of the procurement process, because that was his area of expertise. In terms of the issue of the quantum of batch pricing, I think Mr. Gianni even goes on to say that in the transcripts you will see that he says that we gave an instruction to say we would rather not have an impact of break pricing. But as I've explained already, Mr. Chair, the business case and the RFP contemplated a cost associated with batching and splitting. Our going in position into the negotiation was that we would like not to incur a cost And that is always your going-in position in a negotiation. You will probably never end up getting a zero cost because, as I said, commercially it would not be viable for the bidders to bid on 1,000 locomotives and still supply you the same 1,000 locomotives on a different batch size. Commercially, it would just not make sense for them. They would have to recoup that cost in some way, shape, or form. And Mr. Jayani basically actually says that. I think to the extent that he says, it would be difficult for us to achieve that, and in some cases, maybe someone will think that you're actually smoking your socks.
Then let me deal with the next issue, and that is cost escalation. So if we go back to the schedule that is attached to the ETC increase memo, and this is at bundle BB4B, you'll see that that schedule or table at
Just give me the page again.
BB4B, okay, so this is the Callard
Yeah,
file,
Callard.
one of the original ones,
FQC.
718.
I'm this.
You will see from that table that marginal letter E or note E reflects that cost to fix escalation to end of contract, that accounted for 6.7 billion of the 16 billion odd increase, correct?
That is correct.
Now, let me take you to Mr. Chabi's evidence. This you find in Exhibit BB8B.
I'm this.
And he deals with this at page 46. He says at
I'm
10.19,
sorry, Mr. Maybeck. What is the bundle?
the bundle is BB8 in brackets B.1.
Okay. And
It's
the
marked
page?
on the span Chabi.
Yes. And on the page,
The page, this bundle only has the red numbering,
Yes.
Chairperson.
Yes.
It's red number page 46, 46.
Okay, I'm there.
So what Mr. Chabi says by way of summary at paragraph 10.19 is this cost item is marked E in table 2 of the memo, which we've dealt with. The computation of this cost relied on the accelerated delivery schedule as per table 1 of the memo. The result of 3.5 billion led us to conclude that this cost was overestimated by approximately 3.2 billion. And perhaps I can just take you, before we break, to paragraph 10.21, which seems to be key to Mr. Chabi's opinion. He says the South African Reserve Bank, through its Monetary Policy Committee, in achieving its primary purposes of ensuring price stability, adjusts interest rates to achieve its inflation target of 3 to 6%. Our model assumes the upper bound of this target going forward. Likewise, in the United States, and he deals with this because the OEMs, they had local and foreign content. Likewise, in the United States, the Federal Open Market Committee set an inflation target of 2%, a target to which the US Federal Open Market Committee had been struggling to raise inflation to since the 2008 financial crisis. Considering this, I considered future inflation assumptions as at March 2014 of 6% locally and 2% internationally to be reasonably conservative. And then at paragraph 10.23, he says, paragraph 58 of the memorandum notes that a forward-looking inflation assumption of 6% per year, in brackets 18.54% over 3.5 years, close brackets, is appropriate, and that there should be no question over the 16.8% escalation applied. The concern here is that a rate of 7.35% per year, as opposed to 6% per year, is needed to arrive at an escalation cost of 6.7 billion. You see that?
See that?
Now, if I could take you then, please, to what you say in response to that. And this you find in Bundle 5C. At page 1492.
Is it 1412?
1492.
92.
Chairperson, I see it is now 1:30.
Yes, do you want to complete the particular question or?
I'm now going to take Mr. Singh to his version, so
Yes.
it's not it's a convenient time to break if it is.
All right, let's take the lunch break then. We'll resume at 2:30. We adjourn.
274. And amongst the points that you make, paragraph 271 at the top of page 1493 is that Chabi should have used industry-specific inflation indicators for each different country.
I'm sorry, Mr. Maybeck. It looks like this bundle, which is 5C. I think that's the one you are using.
Yes, it is.
It's got some pages that are not paginated. So I see that it moves from page 408.2 to 1564. Pages in between.
Well, they're all missing.
Mutually missing. And I don't know what would have happened because that's a lot of pages. If you think I might be able to follow, depending on how much you'll be asking in relation to what I don't have, while somebody is working on getting, I say you don't have a junior today. I don't know whether the registrar could do anything. Do you want us to adjourn so that we can?
I think that we may, subject to your guidance, Chairperson, we may be able to, I'm not exactly sure of the extent of the missing pages, but if it comes to this part of the examination, all I'm doing is I'm paraphrasing Mr. Singh's version, and I'm going to ask him to then explain it. If you are missing further parts...
I think I'm missing in the region of 800 pages.
I think that's very significant. I think then perhaps we need to try and sort that out.
Yes, but I think somebody could work on it while we are continuing if you are going to be paraphrasing.
Yes, certainly.
So
from when, so that someone can work on it, what pages are missing?
From the last page under 1000 is 408.2, and then the next page is 1564. I don't know whether it was in this work stream, Mr. Maybeck, but I do know that recently I had occasion to deal with a bundle that had documents that were not paginated in it. So
as I understand this, DCJ, this is not an issue of the pages not being paginated, is it an issue of the pages being missing, really, from
the pages are missing
408 until 1564?
It's two issues, but the most serious one is pages that are missing. There are some pages that are not paginated of certain documents as well. So at some stage that can be looked at. But the page numbers that I gave you are pages that are missing. I think with regard to the other documents that I say are not paginated, they actually include Mr. Singh's affidavit.
Yes, because this bundle C.
This is 5C. And the affidavit of Mr. Singh that
we actually should be in 5C, DCJ. Maybe there's a...
This is 5C.
Yes.
Yeah.
But you have everything after 1564.
Well, I haven't checked, but I've got other pages, but I don't know whether everything is there. So somebody would need to just go through and check. On the face of it, I mean, I've got a lot of pages, but somebody would just need to check whether the pagination is sequential, there are no missing pages.
All right.
So I think we can continue on the understanding you have indicated, and maybe in the investigation team, somebody could
All right, thank you,
see.
Mr. Chair.
Yeah.
So, Mr. Singh, at pages 1492 and 1493, you make the point that Chaubi, this is at paragraph 271, should have used industry-specific inflation indicators for each different country. And at 272, you go on to contend that Chaubi ignores the fact that a premium would be charged by the OEMs to assume the risk of future price escalations. And then if I could take you, please, to page 1985, Mr. J, which I hope you have, 1985.
I should.
So before we get to 85, perhaps I can take you to 1982. That is the commencement of
Yes, I've got 1982.
commencement of a report that you've put up. Who does this report emanate from,
Mr. Cronin,
and who is he?
he is the director of, one of the directors of Arteria Consultancy.
And who are they?
They are a firm of,
So won't you speak into the microphone, please?
they are a firm of financial consultants.
Financial consultant.
Yes.
And is it your contention that this person is an expert?
Yes, Mr. Chair.
That report runs from 1982 through to 1996, is that correct?
That is correct.
Now, this gentleman, if I can take you to 1985, deals with cost escalation to end of project or contract, item F, which we're dealing with. And if you go to 1986, he makes the 2 points that you make. After the schedule, he says, using the assumed weightings above results in an historical industry-specific inflation indicator of 4.2 for the US. And then he says, at the last paragraph, similarly, an industry-specific index can be constructed for the local component. I estimate this to be 7.7. So there's using, as you had said, Mr. Singh, industry-specific inflation indicators, one for the US, one for South Africa. Is that correct?
That is correct.
And then, if you have a look over the page at 1987, under the heading 2, inclusion of a risk premium, the third paragraph, he says, estimating the cost using only local inflation measured by CPI implies that the risk premium was in excess of 1.5% per annum. I would estimate that 1.5% would be a reasonable allowance for this risk premium, as the OEMs would also aim to seek a profit from this transaction. In effect, this gentleman makes here are the 2 points that you made in one of your affidavits.
That is correct.
All right. Do you want to address us on that issue further, or expand upon what I've paraphrased?
Mr. Chair, if I am allowed, the paraphrasing by Mr. Myburg is relatively accurate in that we do not agree with Mr. Chaubi's assessment that the forward-looking escalations is overstated by 3.2 billion. And Mr. Chair, the crux of the matter relates to the issue that Mr. Chabi includes in paragraph 10.23 of his affidavit. If we could just reference back to that one. Mr. Chair, that is in Exhibit BB 8B.1.
Did you say 10.23?
23.
So that's at page 47, is it?
That's at page 47.
Please go ahead, Mr. Singh.
Thank you, Mr. Member. Mr. Chair, if you look at paragraph 10.23, effectively Mr. Chabi is basically saying, at paragraph 58 of the memorandum notes that the forward-looking inflation assumption of 6% per year, 18.54 over 3.5 is appropriate, and that there should be no question over the 16.8% escalation applied. The concern here is that the rate of 7.35% per year, as opposed to 6, is needed to arrive at the escalation cost of 6.7 billion. So what he's in effect saying, Mr. Chair, is that the 6%, in his mind, he believes is appropriate, whereas we, or the memo, purports that 7.35 would be appropriate to justify the full 6 billion. Okay? So in effect, we're dealing with a difference of 1.35%. Okay? So, Mr. Chair, what we have explained is that in arriving at the, okay, let's put it this way first. This percentage, Mr. Chair, whether it be the 6 or the 7.35, is made up of two components. Firstly, it is made up of, let's call it the underlying factors that would result in an escalation. So you'd have steel, you'd have copper, you'd have labor, you'd have all of the components that would result in an escalation. The second part of this, Mr. Chair, or the second component of this 6% or 7.35% would be a premium that the OEMs would charge you to assume that risk. Because what we've done here is that we've said to them, we don't want to take any escalation risks into the future. So we want you to give us a fixed price. So they're assuming escalation risk. Now for that, they would have to charge you some sort of risk premium for it. So those two components, Mr. Chair, would make up the 6% or 7.35%. So now that we know that we have the two components, now we can understand how does each one of these components actually get made up. So if we take the first component, Mr. Chair, where you look at the underlying factors.
And that's basically the economic situation.
Yes, the economic situation, labor increases, steel increases, and all of those type of things. Those, Mr. Chair, would give you an indication of the first component. Okay. Now, Mr. Chabi, as we've said in our affidavit, takes a relatively simplistic approach. And he says, listen, US inflation would be X, South African inflation will be Y. And as a result of that, he believes 6% is an appropriate indicator. Whereas in our case, Mr. Chair, what we're saying is the basket of components that make up a locomotive, it's much more complicated than just looking at CPI or PPI, which again is a basket of components that results in that. What we are saying is we have to do what the OEMs would have done. Locomotive. Each one of these items will be affected by the following indices. and then taken a view as to how those indices would either increase or decrease over the period of time, over the contract period. And then they would have come up with the numbers that they had given us. That would, in our view, give us a more realistic value in terms of what the OEMs had done. Because, Mr. Chair, I can assure you, during the negotiation period, that is exactly what happened. And I think through the legal team, we will submit to the Commission 2 documents. I think it is a Bombardier Transport and a GE document, Mr. Chair, that is part of the signed locomotive agreements. But what it will show you, Mr. Chair, is that remember, there is no escalation. Part of the locomotive agreements, there is no escalation formula because it's already in the price. So you won't find in the locomotive agreements an escalation formula for the locomotive price itself. But what you will find in the locomotive agreements is an escalation formula for parts, because the parts relating to the locomotives were not priced as part of the locomotive cost price. So in the schedules, you will find that each of the OEMs would have put escalation formulas relating to price. Those escalation formulas for parts, Mr. Chair, will give you an indication of the complexity of these formulas that were used by the OEMs to project what these escalations would look like. And they're not as simple as CPI and PPI. They are relatively, I wouldn't say mind-boggling, but they are not as simplistic. So that is why we actually then said we would, in order to predict what the escalation cost would be, you would have to construct this, let's say, composite index of what the OEMs would have used to project the cost. And that is what our affidavit says, and that is what Mr. Cronin in his independent assessment had done. Mr. Chair, then we look at the second part of the makeup of the 6 or the 7.3%, which is the premium for having taken the risk.
1 second, Mr. Singh. Yes, continue, Mr. Singh.
So, Mr. Chair, the second part of the equation would be to look at the percentage that we could ascribe to the OEMs assuming the risk, which is the risk premium. Now, Mr. Chair, in our case, we assume that to be in the region of 1 to 3%. And Mr. Cronin has basically said he believes that 1.5% would be more appropriate for that type of risk. So, Mr. Chair, if you look at paragraph 10.23, it is a case of reconciling the 6% versus the 7.35%. So the difference of 3 billion between what Mr. Chabi says is justifiable and what we say is justifiable is represented by 1.3%. And that, in our view, emanates from the fact that Mr. Chabi, as you would see...
1.3 or 1.35?
Oh, sorry, 1.35.
Yeah.
Right. And that 1.35%, Mr. Chair, emanates from what we say is if you use industry-specific...
the 2 components.
Yes.
Yeah.
If you use industry-specific factors to determine the escalation rate, as Mr. Cronin has done, he ended up with a composite index of 6.2%. And then if you take the risk premium that you have to add to that, which is, let's say, 1.5, you end up with a number of 7.8, or 7.7, which compares to the 7.35, which we had included in the memo. So that is how we believe that this number should have been calculated. And therefore, we believe that the full 6.7 billion is justifiable, Mr. Chair. And you will note, Mr. Chair, that in 10.23, Mr. Chabi does not refer to a risk premium. He's silent about a risk premium being added to the numbers.
So can I then take you, perhaps just on that issue, let me take you to what Mr. Chabi says in reply. Could you turn please to page 1829 of bundle 5C? So at 1829, can I direct your attention, please, to paragraph 73?
Yes.
And here he deals with the point that you've just made. He says, I differ from Mr. Singh's view that a risk premium was not allowed for in my appraisal of a reasonable escalation cost. And then let me take you to 75 at page 1830. Over the 5-year period immediately preceding March 2014, the rolling 1-year local South African producer price inflation rate averaged 4.1%, well below the inflation rate of 6% assumed in my assessment of a reasonable ETC. If I could take you to the last 3 lines, he says, therefore, the expected cost arising from PPI falling outside the Reserve Bank's 3% to 6% target is minus 0.8%. An all-inclusive escalation rate, in brackets, escalation rate plus risk premium of more than 6% is not warranted. It says at 76, the approach adopted by Mr. Singh and Conant is not in the interest of Transnet because it ignores the upside risk of inflation falling below 6%, thereby taking the view that the minimum inflation will be 6% and allows for an additional 1 to 3% as a risk premium without substantiating the amount. At 77, he says, I maintain that the assumption of 6% adopted in my appraisal of the ETC is conservative, being the upper bound of the Reserve Bank's MPC target range of 3 to 6% and allows for a risk premium of circa 2%. You want to comment on that?
Thank you, Mr. Chair.
Mr. Chair, I think in response to Mr. Chabi's response.
Remember to face the mic.
Sorry, sir. In response to Mr. Chabi's supplementary, I think affidavit or supplementary response. Mr. Chair, Mr. Chabi now wants us to believe that, notwithstanding what he said at paragraph 10.23, which I referred you to, which he said 6% was a reasonable number. He would now like us to believe that the 6% was actually split into 2 components. 4% being, as I explained to you, the economic factors, and 2% being a risk premium. Yet he does not mention that in his 10.23 paragraph. Neither does he mention it in any of his preceding paragraphs. Yet, our memo to the board explicitly said that the 6% that we considered as escalation did not include a consideration for the risk premium that would have been charged. And at that stage, we didn't have a view of what the risk premium was, but we said, listen, it's in the region of 1%, therefore the 7.35% looks reasonable. Okay? Now, Mr. Chabi, in my view, attempts to backtrack and says, but I considered the risk premium in the 6%. And he says, in paragraph 77, he says, actually the risk premium was 2%. If you look at the last line of paragraph 77. So in actual fact, he's saying the 6%, in his view, was made up of 2 components, being 4% economic factors and 2% being the risk premium. So we understand that now. And I'm saying, Mr. Chair, in my view, Mr. Chabi is being disingenuous by now backtracking to accommodate the risk premium in his original 6% assessment. Secondly, Mr. Chair, paragraph 75 says the five-year period immediately preceding March 2040. Now, Mr. Chabi is fully aware that escalations are a forward-looking issue because you're looking into the future. 5 years worth of history is no way enough to predict what's going to happen into the future. Mr. Chair, at that time, we were actually in South Africa looking at above inflation salary increase. And we mentioned that in the memo. I think at that stage, government settled on 6 or 7% or 8% as a wage increase. That was the environment in which the OEMs were coming into. And there was no way that they were going to say, okay, we're going to accept 4%. That was historic. So, Mr. Chair, in this case, we reject Mr. Chabi's view again, in that he tries to come back and say, no, the risk premium was included, and also the fact that the forward-looking escalation should be more in the region of 4%.
All right. And then can I take you to one other passage? Mr. Chabi, as you know, also puts in a response to Mr. Cronin. Could I ask you to turn to page 204 in the same file? Sorry, not 204, 2004, 2004.
Form there.
I just want you to pick up on the 2 points that you've addressed, the industry-specific inflation and the risk premium. At 6.8, he says, Mr. Cronin argued for industry-specific inflation factors and proposed factors and weights in modelling the composite inflation rates in his assessment of the reasonability of the 6.7 billion cost for future escalation. The Cronin's approach presents with challenges for the following. First subparagraph, the 1064 memo does not provide for a full basket of factors, in brackets, or components, to consider when determining a composite inflation rate. It provides examples of such factors. And then if you go to the next subparagraph, the 1064 memo does not provide weights for the factors in question. Then at 6.9, the inflation modelling approach proposed by Mr. Cronin is complex, in brackets, and not brief as per the principle of parsimony, makes assumptions that are highly subjective, and as a result does not generalise well across the 4 OEMs. So that's what he says about industry-specific inflation factors. And then at 6.10, Mr. Cronin argued for a risk premium over and above his inflation assumption. He estimated 1.5% to be a reasonable risk premium and did not provide reasons to substantiate his estimate. And then at 6.11, Mr. Chabi makes the point that he's made in his answer to you. And then at 6.12, I submit, therefore, said Mr. Chabi, that an all-inclusive escalation rate plus risk premium of more than 6% on the basis that the 5-year historical producer price inflation averaged 4.1 and the Reserve Bank's upper bound for inflation of 6 is not warranted. A rate of 6% in assessing the cost of future inflation does not only cover the OEMs for the risk of inflation exceeding expectations, but also passes the benefits of inflation falling below expectations to the OEM. Have you got any additional comments or submissions that you wish to make in relation to that?
Well, Mr. Chair, if you look at paragraph 6.8 and 6.9, the only compelling reason that Mr. Chabi gives against using a composite index, or an industry-specific index, as we call it, is the fact that it makes the calculations highly subjective and as a result does not generalize across all 4 OEMs. And is also inconsistent in that applied in the modeling of the business case. Now, Mr. Chair, Mr. Cronin was not in the similar advantageous position that Mr. Chabi was in. Mr. Chabi had access to all of Transnet's information at all material times. If, as I said to you, the objective of this exercise is to put ourselves into the shoes of the OEMs as to how they would have done what they did. And if producing a industry-specific or composite index would result in us being able to predict what that value would have been, Mr. Chabi would have been in a better position to have done that, because he had access to all relevant information at all relevant times. Mr. Chair, there are engineers at TFR that actually sat and looked at these formulas. Because, Mr. Chair, I don't know what escalations actually result in an increase in the locomotive price. So when the OEMs came and said, this is a number, as I explained to you previously, the engineers had to sit and make sense of the fact that these factors, firstly, if it was copper, that the copper index that was chosen was the relevant one, that the amount of copper that was going into a locomotive was reasonable, because that also then determines the price of the locomotive and the predicted escalations. So people at TFR know this. People at Transnet know this. They have gone through this. So for Mr. Chabi to say that this process is highly subjective, Mr. Chair, in my view, is unacceptable. He says that it would generalize across all 4 OEMs. It would not, because each single OEM came up with their own formulas, which was tested by Transnet. This information exists within Transnet, because Mr. Lahare, Mr. Smith, even regiments, as we saw this morning, all of them had access to this information. Mr. Cronin, in an effort to get to an understanding of whether the numbers were reasonable or not, we provided him access to the issues, the parts schedules that I mentioned previously that we can make accessible to the Commission, which he then used to understand which would be the, let's say, big ticket items relating to how you would construct this index. And that's how he's come to this conclusion, Mr. In terms of paragraph 6.10, where Mr. Chabi says that Mr. Cronin does not give a reasonable reasons to substantiate his estimate, Mr. Chair. Mr. Chair, in my view, Mr. Cronin's assessment of 1.5% is below the risk premium that Mr. Chabi himself accepted of 2%, as I just explained to you previously. So why Mr. Cronin would have to justify this, I don't see the reason for, especially when it is below Mr. Chabi's own assessment of 2%. Mr. Chair, in terms of 6.11, I think I've already dealt with that issue in terms of the historic not being a predictor of the future.
All right, then can I turn, Mr. Singh, to the last component that I said I was going to lead you on, and that relates to contingencies. Could I ask you to go back to Callard and to the table at page 718, that's exhibit BB4B. We're going to come back to the file that you've been dealing with now, but if you have the table at 718, Are you at 718?
I am, sir.
You'll see that at marginal letter G,
Yes, sir.
add approximately a further 10% at least to cover this cost. And that is what we refer to as contingencies. And the amount is 4.9 billion, is that right?
That is correct.
And that's a 10% contingency.
That is correct.
Could I then take you to what Mr. Chabi has to say? And hopefully this is the last time that we have to play gymnastics with all of our files. So Chabi, as you know, is BB8B1. And if I could ask you please to turn to page 49. And there you'll see a heading contingencies, and it commences at paragraph 10.29. Are you there?
Yes.
Contingency costs at 2.232 billion made up 7.4% of the capital cost of the locomotives in the business case. In computing this cost, I adopted a conservative approach by retaining the 2.232 billion. This equates to a contingency cost percentage of 7.6% of the capital cost of the locomotives. I then added an additional contingency for the costs of capital spares, options and variations to keep in with the assumptions in the memorandum. This increased the contingency cost to 2.8 billion. 10.30, the memorandum used a 10% contingency rate to ostensibly allow for an additional contingency cost on escalation, foreign currency, TE scope and batch price adjustment. I was of the view that a contingency reserve need not have been held for sub-1 escalation and foreign currency risk because Transnet was already charged to have the escalation and foreign currency risk transferred to the OEMs. Sub-2 batch pricing adjustments because as this cost was not justified. And then 10.31, the DE scope, although allowed for in our costs, is still to be investigated. Should this cost be found to be reasonable, contingency reserve might be required, etc. So that's what Mr. Chaubi says. If I could take you back to your affidavit. This is bundle 5C, and ask you please to turn to page 1497 where you answer those paragraphs. 1497. So you deal with this commencing at 284 at page 1497. I deny that the contingency value should be 2.8 billion as concluded by Chaubi. And then you go on to say at 286, I'd respectfully request that the chairperson reads paragraphs 72 to 75 of the BOD memorandum. The same would clearly indicate to the chairperson the extent to which Chaubi incorrectly states facts and thus arrives at an unsubstantiated conclusions and or unsubstantiated opinions. Paragraph 72 to 75 sets out the reasons for contingencies being as follows: capital spares beyond warranty period, variation orders and options, and relocation costs. You say at 288, Chaubi in his assessment only allows an amount of 533,000 per locomotive in respect of the above costs, which in my view is relatively low. You say at 289 in paragraph 1030, Chalby states that the memorandum to the BOD allowed for 10% due to forex adjustments, escalations, batch pricing adjustments, and the role of TEE. This is categorically denied, as the contingency reserve was for the reasons stated above. So that's what you say. And then perhaps I can just take you to Mr. Cronin. He doesn't deal with this in much detail, or if at all, but let me take you to what he does say in the same bundle at page 1988. You'll see there, Mr. Singh, at the foot of 1988. There's a heading, contingency. And Mr. Cronin says, paragraph 18 of the memo confirmed that contracts were signed to the value of 49.5 billion. Purchase value did not include the contingency amount of 10%, which was requested as a buffer for the purposes set out in paragraph 72 to 75 of the memo. I'm satisfied that the requested contingency amount did not cover any items already catered for, in brackets, i.e. future escalation and currency hedging. The 10% value is determined with reference to the contract value. Its quantum is a value judgment by management and the board of directors, and I cannot express an opinion on this given the information at hand. So that paraphrases really the evidence of, or the opinion of Mr. Chalby, your view and the view of Mr. Cronin. What would you like to say on this topic?
Mr. Chair, I think Mr. Myburg has done a good job of paraphrasing the issue at hand. Mr. Chair, the issue at hand here, again, very simply, Mr. Chalby says X, we say Y. The difference between X and Y is around 2.1 billion. Now we can again go through the nuts and bolts between Mr. Chalby, myself, and Mr. Cronin. But the crux of the matter is what makes up the 2.1 billion. Mr. Chair, you will understand and have cognizance of the fact that a contingency is what it means. It is for unforeseen circumstances. In this case, Mr. Chair, the memo outlines the circumstances for which the contingency was premised. Parts, modifications, and so on. Let's deal with the 2.1 billion difference. Mr. Chair, in my view, the 2.1 billion difference is relatively easy to explain. We do mention that the part of the contingency was to allow for the relocation of the OEMs. And if I recall correctly, Mr. Chair, the value that was ascribed to that, I think, was in the region of about 1.5 billion or so. So, Mr. Chair, 2.1 billion of the difference can be quite easily explained by 1.5 billion. That then leaves you with a value of 700 million, which makes up the 2.1 billion difference between Mr. Chalby and myself. And again, Mr. Chair, with a contract as large as this, the contingency amount is not amount that is actually contracted. So there's no one that's writing out a check for that amount to the OEMs. That contingency amount has to go through another Transnet process for that amount to actually be committed to an OEM for any particular reason. Mr. Chair, again, you will see that in these two schedules that we will provide to the Commission relating to the parts and tools, you will see, Mr. Chair, the parts and tools schedules actually was not known the day on which the locomotive contracts were signed. Parts pricing and the parts schedules and the extent of the parts would only be confirmed at a later date, which was called design freeze date. Now, that in itself would say that at the date on which we signed this agreement, we had no idea of what the quantum of parts, tools, modifications, or the like would have been required for these locomotives. And hence, we believe that a 10% contingency would be better placed than a 7.5% contingency, which again is the difference of the 2.1 billion that exists between Mr. Chabi's assessment and our assessment.
So let me then take you, as I have before, to what Mr. Chabi says in response. Could I ask you to turn in the same bundle 5C to page 1821?
I haven't picked this up, Mr. Maybeck, but probably it is somewhere. Does Mr. Is it
Cronin.
Yes. Does he qualify himself somewhere in the report?
No, not that I can see, I have seen, Chairperson.
Yes, because obviously, as far as I'm concerned, in these matters, one would expect that he would be somebody who has the expertise. I raised the issue with Mr. Chabi as well, but if he has not done so, he probably can do so. It would be good if we can get something that qualifies him.
Chairperson, to the best of my recollection, we did obtain it from him. There might have been some miscommunication between us and the evidence leaders or the people that we communicated to, but it was one of the aspects that we made sure we did obtain. So we will place our fingers on it and make sure that it
Yes.
comes to the commission itself.
Okay, no, that's all right. I just saw his academic qualifications, which appear legal, and I'm sure but there is something else, so that would be helpful. Okay, yes.
Thank you.
Thank you.
So at page 1821, are you there, Mr. Singh?
1821.
What's the page?
1821 in bundle 5C, Chairperson.
1828.
1821.
Okay.
Mr. Singh, perhaps I could just take you to paragraph 36. The contingency amount of 2.8 billion from my assessment of a reasonable ETC explicitly allowed for capital spares to the tune of circa R600 million and implicitly allowed for the remaining and unforeseen cost items in the balance of circa 2.2 billion. Paragraph 37, having considered the costs associated with the expense items noted in the 1064 MEMO and raised by Mr. Singh in his affidavit, I maintain that a contingency of 2.8 billion at the time sufficed. The table below provides a split of the recommended contingency costs of 2.8 billion. And then he sets out in the table costs in relation to capital spares, options, CSR, relocation costs, unallocated, I beg your pardon, and that comes to 2.8 million. He says at 39, having allowed for the cost of capital spares, options, and the CNR relocation costs, an unallocated amount of circa 1.1 billion remains for the BT relocation costs of variation orders, and unforeseen costs. I maintain, he says at 39, that the 4.95 billion as a contingency cost was excessive. We wish to, well, perhaps what I could do is I can then take you to page 2008, where he responds to Mr. Cronin 2008. You will see there, he deals with contingency at paragraph 8. And as I have it, Mr. Singh, he essentially says the same thing. He's got the same table. You want to respond to that, please?
Mr. Chair, again, in terms of his assessment of capital spares of 545,000, Mr. Chair, that amount would equate to in the region of about 500,000 per local. Mr. Chair, I don't exactly know what one wheel on a locomotive would cost, but I would think it would be more than 500,000. So in my view, the 500,000 is wholly inadequate per locomotive. And Mr. Chair, you'll see that he has a postscript 1, which he obtains that from the memorandum on 15th of January 2014 memorandum, results of best and final offer responses, Mr. Chair. Now this is again before the locomotive agreements are actually finalized. Now, Mr. Chair, you recall that I always took the Commission back to the contractual commitment that we have with the OEMs. This was best and final offer. We didn't have a contractual commitment with the OEM at the time. So, by the time we actually got into the contractual commitment with the OEM, Schedule 6, which is the schedule that I've been talking about in terms of parts and schedules and tools, was a schedule that was actually then put into the actual locomotive agreement. And those schedules indicated that we would only be able to assess this once the design freeze stage of the procurement process had been achieved. So again, I would think that this would be an amount that is understated at this stage. Mr. Chair, in terms of the options, I am again not too familiar with the options, but again, the options in terms of Schedule 6, again stated that we would be able to confirm that at design freeze stage, not at the date, at the 15th of January 2014 memo stage. Mr. Chair, the CNR relocation cost of 9.5 million, as you know, and I think there's a significant amount of evidence has been laid relating to that, and I think Mr. Maiva may still go there, I'm not too sure. But again, that is wholly understated at 9.5 million. I think that number was more like 600 million. And then BT's relocation cost is actually not included here either, which is another 600 odd million. So, Mr. Chair, from that perspective, I would still maintain that Mr. Chabi's assessment is relatively conservative. And Mr. Chair, I think maybe it's also worthwhile to indicate that Mr. Chabi, for the better part of his assessment in terms of the 1064 price increases, has maintained that this is a greenfields project, which would require that you would look at it with a project that has a higher risk associated with it. Now, if you look at it as a greenfields project, Mr. Chair, you would assume that there is a risk premium that needs to be allocated to the contingencies in this regard. And that is the reason why we went for a 10% contingency and not a 7.5 or a 5% contingency. Notwithstanding the fact that we've taken care of the forex risk as well as the escalation.
All right, I'd like now to turn to two procedural issues. Maybe I can relieve you of the burden of having to have so many files open at once. I want just to revisit, firstly, the conclusion of the LSAs before obtaining the approval of the board. I think we've discussed this previously.
Yes.
Tell me if there are some that I can get rid of here in terms of files.
I think you could probably get rid of all of them, DCJ.
Yes.
I'm sure that as soon as I say that, then I'll be asking you to get one back. But we're certainly not going to need multiple files open
Yes.
now. Quite which one we're going to go to, I suppose. One
You
will
would
have
let
to
us
see.
know as and when.
Yes.
Yeah.
So, Mr. Singh, I don't know if you want to just take opportunity to close these various files, because if you need one just now, I suppose it will be easier to pick it out from. right. So on this issue of the conclusion of the LSAs before the board obtaining approval for the increase in the ETC, I think previously we agreed on the chronology, and that is that the board approved the increase in the ETC, we know, on the 28th of May, 2014, but the LSAs had been signed about 2 months or so before that, on the 17th of March, 2014. And I think I put the proposition to you before that if it was necessary to get board approval for the increase in the ETC on 28 May 2014, hadn't it been necessary to do that then before the LSAs were concluded? I think you had addressed that. I can't recall offhand what your answer was.
Well, I think we just got into addressing it, and I don't think we completed that.
Okay, well, it's then, I don't want to unnecessarily retraverse things, but there are one or two things I want to put to you, if I may. Can I ask you to go to Bundle 5, but this time not C, but Bundle 5B, the first part of your document. And can you turn, please, to page 1010? Your 1010. This is a part of the procurement procedures manual. I just want to get your comment on one provision, if I may. At paragraph 19.5, there's a heading, approval to award business after the PTN, post-tender negotiations. You drop down to 19.5.3. In instances where the relevant AC, that stands for Acquisition Council, has authorized PTN, post-tender negotiations, from a short list of preferred bidders, the ultimate award of the business, whether awarded to one or more than one shortlisted contender, i.e. a split award, should again be presented to the relevant AC which approved the preferred bidder stroke shortlist. I just wanted to get your comment on whether that happened before the contracts were signed.
Mr. Chair, as I think we mentioned before, the shortlisting of the bidders was approved by the board, I think on the 24th or 26th, sometime in January 2014. And at the same stage, I think, Mr. Chair, they delegated to the Group Chief Executive to take all necessary steps to conclude the contract, if I'm not mistaken, Mr. Chair. Or they referred us back to the BADC, which we then did in February, before concluding the contract.
All right, so let me just understand this. So the board, we know, we go back to January. If we need to go back to the documents, we will. But we know that in January, both the BADC and the board approves this shortlist of candidates.
Yes.
Right. Before the contract was signed, did you go back to the board to get approval?
No.
No. Okay, and you say, just so that I understand it, please, if I've got it wrong, tell me that I have and we can revisit it. You say, well, there was no need for that. And you mentioned two things. Firstly, you say that the board delegated authority to Mr. Malefe.
That's correct.
And secondly, you say, in any event, we went back to the BADC.
I think that's what I mentioned. In that January meeting,
Yeah.
if we if we could refer back to the
Yeah.
resolution.
Let's go to that, because I think the wording is important. Now, that you find in bundle BB4F1, Remember, Mr. Laher's got a whole lot of sub-bundles. BB4F1. And that will be in Transnet Bundle 4A. So, Mr. Singh, this file comprises various sections. It's the last tab.
Yeah.
And if my notes are correct, you should find the resolution at page 379. Are you there?
Yes.
So the recommendation, and perhaps just for the sake of the record, if you go to 371, this is a memorandum to the Board of Directors
That is correct.
from Mr. Molefe, 17 January 2014. This is the memo you had in mind, I take it.
This is the memo, yeah.
Okay. At 379, the recommendation, it's recommended that the Transnet Board of Directors, the third bullet point, approve the recommendation of the shortlist of tenderers as a result of the tender and evaluation process for negotiations and award of business. And then under that, delegate all necessary powers to the Chief Executive to sign and approve and conclude all necessary documents to give effect to the above resolutions.
That is correct.
Now, those resolutions were to approve the recommendation of the shortlisted tenderers and evaluation process for negotiation and award of business.
That is correct.
Do you read this to mean that the power to conclude the contract was delegated to Mr. Molefe?
That is correct. Because it does say and award of business.
Yes, but approve the recommendation of the shortlist of tenderers as a result of the tender and evaluation process for negotiations and award of business.
Yes,
So there were going to be negotiations and an award of business.
Yes,
You say that Mr. Molefe was delegated the power to conclude the contract,
yes,
irrespective of how much it was for.
that is correct.
So up until now, the only business case that had been approved by the board was for 38 million.
38 billion, yes.
Sorry? Billion, I beg your pardon.
Yes.
So he could do as he pleased.
Well, within the confines of the process. So he couldn't, for example, go and buy business case for 1064 locals, for example.
But what he could do is a contract at a 41% increase in ETC.
Yes, sir.
Now, if you have a look at the procurement procedures manual, didn't that have to go back to the board before he could do that? I mean, but for this delegation, you accept that one would have had to go back to the board before the LSAs were signed?
No, sir. Because the PTN that you quoted from basically says the PTN, basically, the post-tender negotiations was approved by the Acquisition Council. Right? It then envisaged that once this PTN was concluded, it would then need to go back to the AC, the Acquisition Council. In this case, the Acquisition Council was the board. Okay? But as you can see, the resolution that was taken basically was not for approve the recommendation of the shortlisted tenderers as a result of the tender and evaluating processes for the negotiations. If it stopped there, we would then need to go back.
Yes, but can I just ask you, are you sure?
I'm sorry, Mr. Mybeck, please don't
Yes.
forget your question. The clarification or answer you give now appears to me to be not the same as the one you gave a few minutes ago. I may have misunderstood something.
Sure.
Mr. Mybeck said earlier on to you, is your position that this resolution gave Mr. Molefe the mandate to negotiate and award the business and go higher than the amount that had been mentioned. And you said yes.
Yes.
And he asked you whether he could do as he pleased, you said, within the confines of the process. And then he said to you, do you agree that but for this resolution, he would have had to go back to the board, and understood you to be saying no. But what you are saying now is if the resolution had stopped after negotiations, he would have had to go back. Is that right?
That is correct.
So are the two not inconsistent? Am I missing something?
So maybe I misunderstood Mr. Maibek.
So in the earlier proposition,
Yes.
you would have said he should go back. He would
He
go
should have
back.
gone,
Okay.
yes.
All right.
Okay. Mr. Maibek, was your understanding
No,
the same as mine?
well, that's as I thought it should be, but
Yes.
I'm indebted to you clarifying.
Yes, okay.
So, in other words, what, on your interpretation, the board then decided to depart from 1953 of the procurement manual.
That's good.
Now, could it do that?
Oh, it was the board.
But the board can't just do anything.
No, well, the PPM, which is 1953,
Yeah.
is devolved from the board.
I see. Now, Mr. Singh, are you sure that when you read the delegation to Mr. Molefe, you accept there's a distinction typically between the conclusion of a contract and the execution of a contract? In other words, when you look at the fourth bullet point, isn't it perhaps capable of being interpreted as meaning that what the board was saying is, yes, you can sign these documents and you can approve what you must, but it doesn't mean that you can go and negotiate and conclude whatever contract you want to. Wasn't it authorizing him to sign?
Well, I don't see the distinction.
All right.
Well, let me put to you what I think Mr. Maibek may be having in mind, because that's what I'm having in mind too, but he will indicate if he had something different. I understand that sometimes, maybe it's not sometimes, it's all the time or most of the time, that when there's a procurement process, tender process that is being followed, it would be followed and there would come a point where the relevant committee or the relevant person with authority, maybe it's the bid adjudication committee, picks the winner, as it were, and says, this is the bidder that we are picking that should get the contract. But after that has been done, there may still be a number of issues that must be discussed or negotiated with that bidder before there is the actual signing or conclusion of the contract. I thought Mr. Maibek may be having that in mind, but Mr. Maibek, you will indicate. Is your position that that process doesn't mean anything really? He, that is Mr. Molefe, would have been mandated to take the process up to the signing of the contract after negotiating whatever needed to be negotiated.
Well, Mr. Chair, let me put it to you this way. This bullet point 4 wording is not specific to the locomotives, or it's not specific to this memorandum firstly. It is, I wouldn't say generic, but it is pretty much put into 90% of the memos that either go to the board, BADC, or to the board itself, because the board doesn't get involved in executing contracts. So that is the how can I call it, the wording that effectively empowers the group chief executive to take the action from the time that the board approves to final execution of the contract. So this is the empowering, if you want to call it legislation, that empowers him to do it. And that has been the standard practice at Transnet from the time I can remember.
But what you do say is that, as far as you are concerned, it allowed him to take the process right up to the end.
From here to the end, yes, Mr.
Okay.
And Mr. Chair, also, just to maybe amplify the point, if you look at what we're looking at here, this is certainly a recommendation from us, the people that signed this, to the board.
Yeah.
So should the board have requested that this not be the case, they would have taken a resolution contrary to this and said, listen, you go do PTN or post in a negotiation and come back to us. Tell us the outcome of that. We will then tell you whether to conclude or not.
Okay.
And maybe, Mr. Chair, as I said, I don't know what the resolution of this thing says. This is just what we've submitted.
Yeah, okay.
The board may have minuted something different, I don't know.
Okay.
But then, if Mr. Molefe could do as he pleased, and he could contract himself for the 41% increase in the ETC, why was it necessary to go to the board and get approval on the 28th of May for the increase in the ETC, which Mr. Molefe had already contracted for?
So, Mr. Chair, the delegation of authority framework actually addresses this point that Mr. Meyer raises. What we're dealing with here, Mr. Chair, as Mr. Meyer quite correctly pointed out, is that it's dealing with a procurement event and is dealing with a procurement process, which is governed by the PPM, which is the Procurement Procedure Manual. And it basically said, go and do your post-tender negotiation, and if need be, come back to the AC. We've now said, by virtue of this thing, you don't need to come back to the AC. So on the procurement side, Mr. Molefe was authorized to complete the procurement process, which he did through signing the agreements at, as we now know, 50 billion. However, Mr. Chair, there is an ancillary process to this, which is the capital process. Now, the capital process is the process that we've been dealing with Mr. Chabi and MNS and ourselves in terms of the values. Now, when we approve a project on the capital side, a value is allocated to that. That value remains there as a control figure because it's a budgeted number, and if the budget changes, then certain processes need to be followed to change that number. Now, in this case, the board approved 38.6 on the basis on which we have explained. That number, that 38.6 would have been allocated a warrant in the Transnet system, which would have tracked that project. Once we've now concluded the contracts, we knew that the 38 had now gone to 50 from a contractual perspective and 55 including contingencies. Now, a capital process, Mr. Chair, would have required us to go through a process to amend the 38 to the contractually committed 55. So that when Transnet now spends, they are spending against a capital allocated budget, that is 55, and a contractually committed agreements of 50 billion. So that is the separation of the two processes. So the board needed to approve the 55 in order for us to amend the 38 to 55 from a capital process perspective.
And what would have happened if the board had refused to do that?
Well, in effect, I can't speculate as to what would have happened, but it's never happened in my history that the board did not approve it. The board did, in fact, approve it. The delegation of authority actually does make provision for these type of instances. And Mr. Chair, to that extent, the significance and materiality framework, which is a document between the shareholder and the company, also recognizes the fact that these instances will occur when capital projects exceed their values, and we'd have to either go for approval or notification to the relevant ministry that these things have occurred.
Yes, but I'm not sure that addresses the question. I mean, what would have happened if they didn't?
Well, I guess then I actually don't know because I've never come across it.
But doesn't that show that the board really did need to agree first?
Not necessarily, because if you look at the, how can I call it?
Well, I guess if you want to make sure that you don't have that situation arising, you get the board to agree first.
Well, in essence, Mr. Chair, that's where I was getting.
Logically, yeah.
Yes, so in this case, Mr. Chair, from our perspective, when I say our, I'm talking about management, we had presented to the BADC, I think on the 24th of February or so, where we had indicated to them that, listen, we've now completed post-tender negotiations, and this is what the picture looks like. And this was remember in the morning when I referred to a number of 52 billion? That is the feedback that we had given to the BADC at that point in time. They then further took a resolution to say, listen, management, go ahead and conclude the contract. So had they had an issue with the value at that time, they could have stopped it and said, listen, this is not in accordance. They did raise concerns around why is this thing now gone from 38 to 55 and what are the reasons and so on. And we basically outlined the same reasons at that stage that we've probably outlined in the bottom line. So that was done to them on the 24th. Notwithstanding that, they still continued to say, listen, go ahead and sign this. And the locomotive contracts were effectively only signed, I think on the 17th of March. 17th of March. So there was a period of three weeks within which, if they required us to not sign, they could have basically taken the decision to say, do not sign.
And Mr. Singh, can I just take you, I'm not sure that they are particularly relevant now, given that you've accepted that but for the delegation, one would have had to go back to the board. Can I ask you to go to bundle 5C?
5C.
And it's a document that we added over lunch, something that you'd mentioned earlier in your evidence, to page 2339. It's hand paginated. It will be added to the bundle formally in due course. These are the minutes of the BADC meeting that you've made mention of, held on the 26th of February, 2014. You see that?
Yes.
And you see at page 2340, at the top, the purpose of the presentation was to request the committee to approve the award of business for the 464 diesel locomotives and 599 electric locomotives. And then at page 3, there seems to be something of a debate. There is a figure mentioned of 52 billion. I think you've said that was the amount at the time. But I just want to take you to what was ultimately resolved, if I understand the minutes correctly. If you go to page 2348, that's my hand pagination, and if I could ask you to drop down to paragraph 8.12, there it records supply of 465 new diesel locomotives for general freight business. The committee agreed that the final total cost of ownership will be tabled to the committee for consideration in due course and further submitted to board for information purposes. And then essentially the decision was made in respect of the 599 electric locomotives. Is that correct?
I can see that.
Sorry?
I can see that, sir.
I just wanted to ask you, when I looked at these minutes, I noticed something that I wanted to question you on, and perhaps you can shed some light on this. At page 2347, at paragraph 8.1, it says procurement of 1064 locomotives for TFR general freight business. The terms of reference for the appointment of an independent expert will be formulated and finalized by the board steering committee, comprising the committee chairperson, Chairperson of Risk, and Mr. Singh. The Board Steering Committee will gauge the skills required and appoint a service provider. Going forward, the expert will assist the Board. Management will finalise the process of appointing an independent expert. Conversation on how the matter will be finalised will be communicated to the Chairperson. Now, what was the role? What was the anticipated role of this expert to the Board?
Mr. Chair, this would go back to the, again, something that emanated from the business case. In terms of being able to govern something like this, it was envisaged that there would be a steering committee that would manage this acquisition process. But over a period of time, it became, I guess, less formalized, and this independent expert provision was never actually implemented.
Yes, well, that's what I wanted to ask you. Why not? It was decided here you were supposed to be involved in choosing the expert.
Yes, Mr. Chair. I don't exactly recall, but I think there was some discussion between Mr. Molefe and the chairman of BADC at the time, and it was agreed that we should not continue with this process.
But why did the Board need an expert? Because, as I understand, your interpretation is the Board had told Mr. Molefe that he could do what he wanted to.
No, Mr. Chair. This is a matter arising from previous minutes.
Yes.
So it had emanated some time before. I'm not exactly sure when.
We're in February now.
Yeah, so this would have been being carried forward from a number of...
Yes, precisely. But it's subsequent to the January meeting.
Yes.
But as your interpretation is, in January, the Board said to Mr. Molefe that you can go and conclude whatever contract you want to.
Yes.
Yet here in February, the BADC, the committee of the Board, is agitating about the fact that the Board actually needs an expert.
Mr. Chair, as I said, well, maybe I should have said this before we started. This minutes were basically given to us now. Maybe if I can have a couple of minutes, well,
Sure.
we could deal with it too. I don't
Well,
know. I
let's
would
just
have to go
deal
back.
with what you know.
Yes.
What did the Board need an expert for?
Well, as I said, in my view, this was conceived at the beginning of this process. And it was conceived on the basis that, given the fact that we were buying quite a significant number of locomotives for the first time, a transaction of this size, and also it was electric and diesel locomotives, there would have been a need for someone to advise the Board in terms of capital costs and, all of those type of technical things that the Board may had questions on.
So, just so that we understand this, you yourself, because of the size of the contract, needed transaction advisors.
Yes.
You went and you got McKinsey, regiments, we've traversed all of that. But what's contemplated that the Board would have its own expert.
In terms of the technical aspects.
Yes.
Yes.
And it was something that was raised here as late as 26 February 2014.
Based on,
Yeah.
on this stuff.
And now we get to the point of why was this not put into action?
I don't recall exactly, but Mr. Chair, but I think one was, who was this expert going to be? Where we were going to find the expert. And as time went on, it became irrelevant. As you would have seen, we were almost concluding the contract, yet we hadn't decided who the expert was going to be. So by the deflection of time, the proposal became irrelevant.
Well, the proposal would become, if it's a proposal, irrelevant if you have signed the contract. But if you haven't signed the contract, it would be highly relevant, even at the last minute. Because if the Board felt that it needed expert advice before it could give a final go-ahead, then that could be critical, especially when you deal with big amounts.
Yes, Mr. Chair, but ostensibly, they gave us the go-ahead, notwithstanding the fact that this matter arising was still not concluded.
But remember, this question by Mr. Maibek seeks to say, are you really correct in understanding the resolution to mean that the board had given a go-ahead and it wasn't going to be involved in the matter anymore? And he is in effect saying, them, that is this committee of the board, wanting an expert is inconsistent with the notion that they were not going to have anything to do with the matter anymore. Where he wants to know what you say to them.
Well, Mr. Chair, in response to that, the very same committee, in the very same meeting, basically tells us to go ahead and conclude the contract, which is on page 2341.
But that might raise the question, what did you understand this part of this proposal or request to be for them? Because one would have thought that if at the time you thought that it was unwarranted because the board had said go ahead, the one would have thought that you would raise that issue then. Say, why do you want that? Because you have given us all the mandates.
Yes, Mr. Chair. As I said, I haven't looked at this, these set of minutes in sequence. I'm just speaking of my memory at this point in time. But in terms of the question that you are asking, would this have changed the interpretation of what? Remember, this is the BADC. This is the Board Acquisition and Disposal Committee. The original resolution that we were looking for, that empowered Mr. Molefe, came from the board itself.
But the members of this committee would be members of the board itself.
Yes,
themselves.
and that delegation would have happened in January.
Yes, but what does remain is, if members of the full board,
Yes.
who happen to be members of this committee as well, if they take this position, the same issues would arise to say, but why do you ask for an expert? Because you were part of the board that said we must go ahead. So in other words, we go back to the question. One would have expected that you, having been in that meeting of this committee, you would have raised the issue, why do you want an expert? Because the board has already given us all the mandate. And if it's not raised, one wonders what your understanding was, because one would have thought that you would say, but why do you need an expert? Because you are no longer going to be involved in this matter. You have given it to us.
Well, Mr. Chair, I can't answer for the board. Maybe the board should be asked that question. As I understand it, no board members were asked for affidavits in terms of the 1064 locals. So they should tell you what they understood.
Yes,
Specific.
but I'm talking about you.
But I told you what Mr. Chair, I told
you don't know
what
what you may have understood.
I told you what my understanding was, that in my view, this it was past its expiry date.
So is your view that there was no need for an expert at that stage?
If we had already got to a point, Mr. Chair,
Yes.
of awarding the contract,
Yes.
the board, in its view at that point in time, had the information that it required to make the decision.
Yes. But of course, the minutes don't reflect you saying, why do you need an expert, isn't it?
No, well, Mr. Chair, that is in the matters arising. I said that, Mr. Chair, these items are recorded in the section called matters arising. So, yes, it doesn't record that, Mr. Chair.
Yes.
You see,
Mr. Maibek?
yeah, I just wanted to point out something to you. Well, what we know is as late as the 26th of February, 2014, which was 3 weeks before the LSAs were signed, at least 6 members of the board, on the face of it, the entire BADC members, wanted an expert to be appointed.
Well, if they wanted one, they should have appointed one.
And then what's also interesting is if you look at 2347, you see it records under paragraph 8.1, the matter was in progress. And it was for whose attention?
Just this.
2347.
Yes, sir.
It was for your attention, Mr. Singh.
I know that.
So what did you do about this?
As I said,
Nothing.
Chairperson, with the greatest of respect, I know you said it on numerous occasions that you're there to ascertain certain facts, but there is a line to be drawn with cross-examination. And I, with the greatest of respect, submit my learned friend is busy in the mannerism in which he's doing and the way he's doing and the question he's putting, that ventures into the realm of cross-examination.
Well, you talk about the distinction between asking questions to establish the truth and cross-examination. For quite some time, the issue occupied my mind as to what the difference would be. But to the extent that there would be a difference, maybe you might offer some insight. It may be that it might be simply that a cross-examiner is advancing the interest of the party that they represent, which an evidence leader in a commission such as this doesn't have. But, you know, when it says when the rules say an evidence leader is entitled to ask questions to establish the truth, obviously if there are differences, you know, probing is permitted. So I'm just saying, I know that, you know, the people make that distinction, and maybe there is that distinction, but practically it might be difficult. But from what Mr. Mybeck is doing, I don't think that he has gone that far. But it's difficult. I'm sure you would concede it's difficult.
I've placed my objection on
Yes.
record, and we'll deal with
Yes.
it if necessary.
No,
in
that's
due
fine.
course,
That's
Chair.
fine. Mr. Mybeck?
Yeah, well, perhaps I could just ask you again, Mr. Singh. It reflects that the matter was in progress and it's for your attention.
That is correct.
Perhaps I shouldn't have said that you didn't do anything. It was my interpretation of what you had said. Perhaps I should simply ask you, then what did you do, this being for your attention?
Mr. Chair, as I said, from my recollection, Mr. Chair, I was under the impression that this matter had been closed earlier in the procurement process. Because as I said, it actually emanated from the inception of the process till now, which is quite a while. So I'm actually surprised that this is an open item on the 24th of January 2014. As I said, I would have to go back and actually reference and understand, you know, what was or reconcile in my mind, why is it that I think that this matter was closed previously.
Thank you. I'd like then to turn to another topic, and that is the failure to obtain ministerial approval.
Just to close off on that item, do you propose to submit an affidavit after you have had the opportunity of reconciling why you thought it's something that had been dealt with earlier? I just don't want to leave it hanging.
No, Mr. Chair, we will do that. We will do that.
Yeah, okay. Mr. Maita?
Thank you. Mr. Singh, I want to deal with the, as I had mentioned, failure to obtain ministerial approval for the increase. Could I take you to one of your affidavits? This is bundle 5C, And can I ask you please to turn to page 1443. Now, what you say, sorry, tell me when you're there. What you say, paragraph 52, is, I stand by the contents of the memorandum of the Board of Directors dated 23 May, specifically paragraph 17 of the said memorandum, where it states, quote, although the approval from the Minister was not subject to a final cost of 38.6 billion for good governance and for information purposes, a letter will be sent to the DPE advising of the final ETC. Do you see that?
No, I see that.
And you were, in fact, the author of this memorandum, correct?
Yes, sir.
And then you go on at 54 to say the DOA framework effective 1 June 2013, approved by the Board of Directors in May states, and you then quote paragraph or clause 515 under the heading increase in estimated cost, and it reads, increase in ETC of projects already approved by the shareholder minister must be reported to the shareholder minister if the increase is in excess of 15%. Now, I think it's common cause that this increase was in excess of 15%, is that right?
That is correct.
And as I understand what you contend, and you must correct me if I'm wrong, is that one didn't need approval of the minister, one needed simply to report it to the minister.
That is correct.
Well, from what I've seen, and certainly from the reports, it appears that that also wasn't done. When was it reported to the minister?
I have no recollection of whether it was reported to the minister or not. I'm not aware of that, sir.
You're not aware of that?
No.
Who would have had to report it? Would it have been the board or the CEO?
It would have, the letter would have had to be, I would assume, drafted by the company secretary, would then go to Mr. Molefe for recommendation, and then would have gone to Mr. Mkwanazi for him to sign to send to the minister.
So it was Mr. Malefe's job?
Well, I would assume so, or someone that would be picking up these issues from the board itself.
But of course, that takes me back to that email string that we dealt with this morning, where you were corresponding with, is it Ms. Huma?
Mr.
Miss.
Mr.
Where you said to her that I hope this helps, but we will provide the DP.
Mr. Huma, yes.
Mr.
Yes.
Sorry, I beg your pardon. You said, I hope this helps, but we'll be providing the DPE with a full report on the transaction once the Board of Directors have approved same. That's what you said.
Yes, sir.
You didn't provide that report.
Well, it was under the knowledge that there would be a PFMA process that would require that to happen.
Now, could I please ask you to turn to page 1913? This is of bundle 5C. Now, this is an affidavit or a statement by Mr. Sedumeni, starting at page 1912. And he then deals with your contentions, as he puts it, at paragraph 3 at page 1913. And he sets out an argument here. I assume you've had the opportunity to read it. It runs from paragraph 3.1 to 3.18 at page 1915, where he contends that the obligation wasn't simply to report, that you actually needed to get permission. To a large extent, I suppose these are questions of law. Do you have any comment on this set of submissions by Mr. Sedimeni?
I'm not sure where Mr. Sidimini gets or comes to the conclusion that PFMA approval is required. He is obviously relying on the incorrect delegation of authority or significance and materiality framework to do that. The delegation of authority and significance and materiality framework that we have outlined in the affidavit that you referred to is the correct delegation of authority, and it requires that we merely report the increase to the minister. In this regard, Mr. Chair, we'd also refer you to the Worksman's report as well as the Funduzi report, who also do not take contention with the manner in which the approval relating to the increase from 38 to 45 is done.
But I suppose the more fundamental difficulty, and I'd ask you to address this, is that even on your own interpretation, that wasn't done.
I'm not, as I said, I'm not aware of whether it was or it was not done. I know Worksman's has indicated in their report that there is no evidence to suggest that a letter had been sent to the minister.
Well, perhaps I should put that more accurately. You're not aware. You have no evidence to the effect that it was done.
No.
I think Mr. Malefe, he, if I recall his evidence correctly, he accepted that ultimately this would have been his responsibility, and I think he accepted that it wasn't done. I stand to be corrected. All right. Let me then move to another topic. And that relates to the relocation of CNR from Pretoria to Durban. Now, Mr. Singh, what I'm going to do is I'm going to give you a sort of a thumbnail sketch of things. I think I only have one or two questions to ask you, so I hope that we can work through the rest of the stuff quite quickly. You know that the person who gave evidence about this was a Mr. Gonzalez.
Through the 3 notes.
Yeah. And what his affidavit reflects is that on the 11th of March 2014, and let me just position this, this was towards the end of your tenure at Transnet. As we know, was it from August you were seconded to Eskom. So on 11 March 2014, CNR submitted an initial costing of 9.7 million, and I think we've already seen that because Mr. Chabi referred to that. Then on the 23rd of April, CNR concludes what we refer to as a BDSA, Business Development Services Agreement, with BEX. Its benchmark is 280 million, that it would get a fee if it achieved that benchmark. That was subsequently increased to 580 million. So that's in April. Then in July, this is now in 2015, that's why the role that you played becomes important. In the next year, a costing of 647 million was submitted. To Transnet, And this was agreed by Mr. Gama in a variation order on the 23rd of July 2015. Well, that's shortly before you left. And as a consequence of this, Bex pocketed 67 million. So that's the rough architecture. All right? Mr. Gonzalez testified that you signed the agreement with CNR and Transnet. Do you confirm that?
No, sir.
So let me take you to Mr. Gonzalez's file. One of the early original files, BB5. You found it here. BB5, Chairperson.
Thank you.
If I could take you, please, to page RG 238. So here you will find a 238, an analysis of cost increases, and it's quite a lengthy document, but it provides for signature at 249. You'll see there it was signed by Mr. Jeff Wang, the CEO of CNR Rolling Stock South Africa, and then it provided for your signature. Do you say you didn't sign this?
Chair, I don't have any recollection of signing this. I did not sign this, Mr. Chair, from what I recall. Mr. Chair, I think this approval under 2307-2015 that Mr. Gama had given, I think would indicate who the delegated authority to sign this in actual fact was.
So, if I could take you, please, to your bundle 5B. So this is a 5B page 1011. I don't know if it's of any particular relevance, but I guess it needs to be determined. 1011.
Okay.
So it's an extract from Mr. Gonzalez's evidence at 1011. If you go to line 21, the version that we have on file is only being, say, signed by Jeff Wang. We do not have the version that was signed by Anoj Singh as well. The evidence leader says, but can you confirm that you are aware of the signed version which was signed on behalf of Transnet by Anoj Singh and on behalf of the consortium by Mr. Jeff Wang? Mr. Gonzalez, correct, Chair, and you will see later on that Siyabonga Gama confirms that this is accepted. So as I read his evidence, he says that you signed this contract.
Well, Mr. Chair, again, If that signed copy does exist, he should have provided it to the commission so we could deal with it. As of today, we still don't have a copy of that, do we?
But, well, not that we've been able to locate.
So
But do I understand your evidence to be that you can't recall whether you signed it or not?
I don't, I was not the, as far as I recall, I'm not the delegated authority to sign this, so I wouldn't have signed it.
I see.
And again, he says that you will see later on that Mr. Gama confirms that this is accepted. I don't think Mr. Gama has confirmed that either.
You know that, well, I think I've put it to you, that BEX is Gupta linked. It's one of the first line, as Moneyflow calls it, money laundering entities. You know that?
Well, from what you have said, yes.
Yeah. Now, I want to just take you to a series of concerns that were raised by Mr. Leher in relation to the proposed cost of 647 million. Can we go, please, to Transnet bundle 4A? And then go right to the end again, to the BB4F divider.
What page did you say we should go to?
I'd like to start by going to page 238, please. It's part of Mr. Leher's affidavit. At paragraph 71, he says, in June 2015, I was instructed by Singh to review proposals relating to the proposed move. And then at 72, he says, my comments on these proposals and my concerns from a financial point of view were articulated in email correspondence dated 21 June 2015 and 22 June 2015. Now that email correspondence you will find at page 471. Now, Mr. Singh, you will see at 471 that it's from Leher, sent on the 21st of June, and it's CC'd to you. Now, I just wanted to ask you to confirm or to comment on this. Mr. Gama, in his evidence, made mention of the fact that there was a relocation committee, a committee that was tasked to deal with this issue of relocation, and that you were part of that committee. Would you accept that?
I do seem to recall that, yes.
I beg your pardon?
I do seem to recall that something like that exists.
And you confirm that you asked Mr. Leher to look into this issue? And in the interest of time, I don't want to have to
I'm
go...
sorry. Did you give an answer?
Yes.
Yes, okay.
Sorry, sir, let me do some...
In the interest of time, I don't want to have to go through these 18 points. But you accept that Mr. Leher raises a number of material concerns about the costing.
Yes, sir.
I really just wanted to ask you this. On what basis were these concerns resolved?
Mr. Chair, these concerns from my perspective would have been dealt with by Ms. Mtleche who was the point person at the time dealing with the relocation. She was the, let's call it, project manager responsible for the, let's call it, relocation project, if you want to call it.
But there was a committee.
Yes,
She was part of the committee,
yes,
as you were.
yes, sir.
Well, my question, again, we'll put another way. Were you satisfied that these concerns had been met?
Mr. Chair, in terms of the memo that was then presented for us to recommend to Mr. Gama, I was comfortable that Ms. Mdletshe would have attended to these matters. I didn't go back to Mr. Lehe and say, listen, have these things been resolved satisfactorily? I don't think I did that.
Well, Mr. Lehe's evidence is no one came back to him.
Well, it seems like he did resend it to Ms. Mdletshe on the 3rd of July.
On the 21st of June.
No, I'm saying the original email was sent to Ms. Mdletshe on the 21st of June,
Yes, and then on the 3rd of July.
copying us, and then he, I would assume, resent it to her on the 3rd of July. Why he resent it, I'm assuming for her to either follow it up or she may have requested the fact that he resent it.
But just so that I understand your evidence, you as a member of the relocation committee, were you satisfied that Mr. Lehe's concerns had been met, bearing in mind that you were the one who asked him to look into this?
By virtue of the fact that I had thought that Ms. Mdletshe was had taken care of these. I think also one of the things that I certainly had reference to at the time was that we concentrate on the fact that we're looking at CNR for various specific reasons, which is in the mandate of the Commission. But from my perspective at the time, Mr. Chair, you'd appreciate that I was actually looking at the relocation as a project. And the project was made up of two people that were relocating. It was just not CNR. It was CNR and PT. So from that perspective, and again, Mr. Chair, one of the things that that I think I need to highlight is that the committee was not a formalized committee that sat in a room and then said, okay, we've now received all of these things, let us now deal with each one in turn. It was an informal committee that was made up of people that were, that had the ability to understand whether these things were sensible or not. Because remember, Ms. Mdletshe, Mr. Gianni, and TFR and TE were the people that actually received the original bids from the OEM. Then a decision was made to say, okay, all four cannot build in Pretoria, we need to relocate two. So the quantification of this process would have been undertaken to understand what is the deviation from what was submitted to what is now being requested. And these individuals were best placed to be able to do that. And that is one of the reasons why Mr. Lehe was incorporated into this team to understand that, because he had an intimate knowledge of what was submitted and what would now be required to be allocated for this relocation. From my perspective, Mr. Chair, as I said, I would have expected that between Mr. Lehe and Ms. Mdletshe that these issues would have been resolved prior to the memo coming to us. In addition to that, Mr. Chair, when I compared the two values between CNR and BT, they were not significantly different. I think the number was 647 that you mentioned for CNR. I think Mr. Myberg did mention a value of 647 for CNR. And I think the number for BT was around 600 million. So to me, the numbers didn't look significantly different, having gone through the process that the committee would have gone through. So from a reasonableness perspective, Mr. Chair, I was relatively comfortable that the two numbers were relatively in the ballpark. And therefore was comfortable that the values could be, or the memorandum could be supported. And again, Mr. Chair, you have appreciation that these things, the memo that went for approval to Mr. Gama was not authority to pay. There would have had to be a contract, there would have had to be a process that agreed that so the approval, yes, approved the amount, and Mr. Chair, what that would have done, as I explained earlier, it would have released 600 million for BT, and it would have released 647 million for CNR from that contingency amount of 5 billion that we had created through the increase from 38 to 55 that we discussed this morning. So the purpose of that memo was to release those amounts for which spending would then occur against. And there would be then a subsequent process that would need to justify the values that then were spent against each of those activities, if you will.
So what I just wanted then to get your comment on, let's just have a look at one of these business development services agreements. Again, can I ask you to go back to Gonzalez, exhibit BB5, go to page 216.
In Gonzalez.
BB5, one of the original files. Yeah. And can you please turn to page 216? That's where you see the cover sheet of the Business Development Services Agreement between CNR and Business Expansion Structured Products, BEX. I just want to maybe ask your comment on one thing. If you go to page 221, direct your attention to paragraph 2.5.
221.
221, paragraph 2.5. It says there, since BEX has undertaken to negotiate and finalize the deal with TFR on a risk basis, it's agreed between both parties that BEX is entitled to an agency commission. Now, you dealt with this, you received CNR's proposal, you asked Mr. Leher to look into it, etc. Did you ever get a sense of BEX having played any role in the negotiations and finalization of this deal? No. Did you even know who BEX was? Did you know anybody from BEX?
Your both answers were no.
Sorry, sir.
Yeah,
yes.
You were
yes.
speaking from away from the mic.
No, yes, that's correct.
Yeah, okay.
And perhaps just for the sake of completeness, if I ask you to go to 259, you will see that there's the invoice that was rendered to CNR by BEX and paid. An amount of 67 million, excluding VAT and including VAT, 76 million. This being a first-line Gupta laundering entity.
I see that.
To turn then to another contract. But thankfully this time, having completed the locomotives, we can speak about something else. Neotel. And I want to deal with the 2014 Master Service Agreement negotiations and asset buyback agreement. This, as you may remember, was something dealt with in evidence by Mr. van der Westhuizen. Can I ask you, please, to fish out Exhibit BB7, one of the original exhibits early on, and go to A, BB7A. And could I ask you, please, Mr. Singh, to turn to page 13. Now, at the Material Times, Mr. van der Westhuizen was a Executive Manager, Office of Chief Information Officer at Transnet. I just want to take you, if I may, I'm going to try and paraphrase as much as I can. I want to take you through paragraphs 47 to 56. It says at paragraph 37 that there were two streams included in the negotiations with Neotel, namely a commercial stream, which was responsible for the negotiation and finalization of the terms of the 2014 MSA, and a technical stream, which was responsible for the negotiation of the technical detail of the services to be rendered by Neotel. I was part of the Transnet negotiation team in the commercial stream. Then he says at paragraph 49, the contentious issue during the negotiations was the aspect relating to the buyback by Transnet of the assets and infrastructure which constituted its ITC network at the time. And if I can then take you forward, please, to page 16, paragraph 51, he says, the investigators from the Commission presented me with correspondence which reflects that a meeting took place between Francois van der Merwe from Neotel and Singh on 8 December 2014 in Umhlanga. I'm not aware what the purpose of this meeting was and why the Transnet CFO would meet directly with the supplier without including anyone from the Transnet negotiating team. This was not normal protocol, and what might have been discussed at this meeting is not known to me. Paragraph 52, in an attempt to resolve the stalemate, Singh became involved, as did Sunil Joshi, the CEO of Neotel. They convened a meeting on 11 December 2014, which took place at the Slow Lounge in Sandton, attended by myself and Singh from Transnet, Sunil and Francois van der Merwe from Neotel. 53, at some stage during this meeting, Singh and Sunil separated themselves from Francois and I in order for them to discuss the final terms of the repurchase of the assets and infrastructure, from what I recall. 54, no feedback was provided to us after the meeting between Singh and Joshi, but at some point during 11 or 12 December 2014, we must have been instructed to meet on 13 December 2014 to finalize the MSA. Paragraph 55. The final meeting to finalize the MSA occurred on Saturday, 13 December 2014 at the office of Neotel in Midrain. Singh arrived at the offices of Neotel and I handed him the final draft of the negotiated MSA and relevant approval documents. We exchanged pleasantries and I departed. I later learned from media articles that an entity called Homex was paid by Neotel for allegedly facilitating negotiations between Neotel and Transnet. I've been presented with two contracts that were ostensibly concluded between Homex and Neotel. Then he goes on to say, having read these documents and based on my involvement in the negotiations with Neotel, I'd like to comment as follows. I did not meet any person or representative of Homex during our negotiations with Neotel. 2, Transnet had everything to lose and nothing to win by delaying / not signing the MSA, as a network transition would have taken years to complete. Only Neotel would have benefited, as they communicated to Transnet that should the deal not be concluded before expiration of the LOI, the monthly fee would escalate to 57 million per month, from what I recall. Neotel knew they held all the cards, so as to speak, as they could switch off the Transnet network, which would have led to disastrous consequences for Transnet. 3, Transnet knew from the start of the RFP process that any transition would take years and cost Transnet a significant amount of money. Transnet did not have any options but to sign this new MSA or to extend the current MSA with Neotel at a significantly inflated cost. At no stage was it a viable option not to sign the new MSA agreement, which was business critical to Transnet. Sub 4, I fail to understand how any representative from Homex would have been able to get the parties to reach agreement in a single day, brackets calculated from the day upon which Homex contracted with Neotel, 12 December 2014, and the day on which I delivered the MSA to in its final form to Singh, 13 December 2014. The MSA was signed on 15 December 2014. Now, perhaps I could just take you to these two agreements. The one you find at page 494, but this is now in Exhibit BB7B. So Mr. Forming's affidavit is in A, and annexures, or the ones we're going to deal with, are in B.
You mean Mr.
BB7. B. Yeah. So at page 494, you find one of the agreements, 494. You'll see if you go to 504 that it is signed. This is an agreement between Neotel and Homex. At 404 it's signed by Sunil Joshi. That's the gentleman that you allegedly met with. And then there's another agreement at 507. And that is also signed by Mr. Sunil Joshi, person you allegedly met with. And in between these two agreements is an invoice at page 505, rendered by Homex to Neotel for an amount including VAT of some 41 million. Now, what we do know is that Homex was Mr. S's company. Money flows have determined that this money was paid. Homex, we know as well, was one of the first-line Gupta money laundering entities. So another transaction that you were involved in, another one of these BDSAs where there was this large kickback paid. What is your comment on the evidence of Mr. van der Westhuizen? Do you accept that you went to these meetings, that you intervened, and that it produced a signed MSA quite quickly?
Well, let's deal with the issues in turn. So Mr. van der Westhuizen does quite correctly summarize, from what I recall, the events that led to the MSA becoming contentious between Transnet and Neotel. Mr. Chair, the background that Mr. Meyerberg has not covered is that this was Neotel's second bite at the cherry. The background behind this is that there was an award to Neotel. The award was then overturned by Mr. Molefe, and that overturn was then again overturned to basically award to Neotel. So in that process, Mr. Chair, as you would understand, the negotiating power of Transnet obviously diminished quite significantly because of the change in award from Neotel first, then to another bidder, and then back to Neotel. And secondly, Mr. Chair, the negotiating power of Transnet was always, Transnet was always going to be on the back because Neotel owned the infrastructure. So basically we had a gun to our head in terms of negotiating with Neotel. And Neotel was, as you can see, the list of issues starts at 49.4.1 on page 14 and runs right up to 49.4.7.5 on page 15. So, and this was a significant period of time that the teams were trying to negotiate these contracts, Mr. Chair.
I'm sorry, Mr. Singh. I thought I was looking at the right file. Mr. Mike?
Oh, sorry, I'm using
Are you looking at the pages that you are mentioning don't coincide with my pages?
He's referring to Mr. van der Westhuizen's affidavit, Chairperson. That's at exhibit
That's
BB7A. We switch back to the A bundle,
okay.
which has got the affidavit in.
Got B. Okay.
sorry,
Okay.
so it's BB7A.
Yes.
So the point that I was trying to make, Mr. Chair, is that Neotel basically held all the cards in this negotiation process. And the attitude that Neotel had taken is demonstrated by the list of issues that were still outstanding at this late stage of the negotiation process, which is reflected in paragraph 49.4, which is on page 14 and goes on to page 15, which is a long list of issues that still needed to be finalized. And basically on paragraph 50, Mr. van der Westhuizen does state, and correctly so, that the negotiations became very strained towards the end of November and early December. And Mr. Chair, you would also appreciate that Mr. van der Westhuizen correctly concludes later on in his statement that we were at this point in time paying a premium for network services because we were on a month-to-month basis with Neotel. And that value, I think, was in like 60 million or close on to 60 million. And if memory serves, I think the monthly fee would have normally been in the region of about 40 to 45 million, I think, if memory serves. So it was a significant premium. And as Mr. van der Westhuizen says, there was more incentive for Transnet to sign than Neotel to sign. at any given point in time. The attempt to resolve the stalemate, Mr. Chair, actually was suggested by Mr. van der Westhuizen himself, if I recall, if not the negotiating team, which led to this meeting that was attended to by Mr. Joshi and myself. And again, Mr. Chair, I don't think there's anything untoward in me and Mr. Joshi meeting to discuss this matter. Because as Mr. van der Westhuizen has correctly outlined, that a stalemate had been reached by the two parties. And this meeting was really set up to engage with Neotel constructively at a senior management level to ensure that we get to a point where the two parties regularize our relationship going forward for the long term, which was what the outcome of the MSA process was supposed to be. And that was the discussion between Mr. Joshi and myself. And from my perspective, I made it quite clear to Mr. Joshi that, listen, we've gone through a tender process. You've submitted a pricing proposal, and you've submitted you've complied with the tender, the requirements of the RFP. That is which you were actually appraised on. So very simply put, please comply with those conditions and conclude a contract. Because all of these other issues that you raise is contrary to what you've submitted. And that is why my team has the issues with you. My team does not have issues with you other than the fact that you agreed in a tender process to do certain things. So all they are saying is, do what you agreed to do. And that is the discussion that we had with Mr. Joshi. And that was the reason why there was no feedback. Because it was up to Mr. Joshi to make sure that his team understood what the negotiating parameters were. And that then led to the conclusion of the MSA on, I think according to Mr. van der Westhuizen, on the 15th of December or 14th of December.
But I think really what I want to ask you is, can you think of any reason why Neotel decided to pay Homex 41 million?
I have no idea.
Let me just take you to the agreements. This is EB7B. I've shown you them, but I just want to take you to one or two clauses. At page 496.
At what page you answer?
496.
Yes, sir.
Paragraph 4.1 towards the foot of the page, the consultant, that is Homex, undertakes to facilitate the successful conclusion of the asset sale referred to in the master service agreement. Did Homex do that?
I have no idea. I had no interaction.
I beg your pardon?
I said I have no idea. I had no interaction with Homex.
Yes. And if you go then to page 509, paragraph 4, towards the foot of the page. The consultant agrees to undertake to analyze the requirements.
Sorry, what page is it?
509, paragraph 4 towards the foot of the page. Consultant agrees to undertake to analyze the requirements of both Neotel and Transnet to find a workable solution to the impasse in negotiations. Did Homex do that?
Again, Mr. Chair, I cannot comment on that because I had no interactions with Homex.
But then why, if Homex weren't involved, why did Neotel pay them this money? Have you got any idea?
No, sir.
Could I just ask you to comment on paragraph 51 of Mr. van der Westhuizen's affidavit? I think you've dealt with much of the rest. And that's at page 16 of BB7A, where it talks about this meeting that you had with Van der Merwe on the 8th of December in Umhlanga.
Mr. Chair, again, we've requested the Commission to present us with this correspondence, and we haven't received this to date. So we've dealt with this in the affidavit, and we said we did not have this meeting.
All right. Can you recall this meeting?
No, sir.
And why is it that you became involved again?
Sorry?
Why did you become involved in this?
Well, Mr. Chair, this was a significant procurement event. It was one of those that needed to go to the BADC, and I think, if I'm not mistaken, I don't think it went to the board, but it was part of the CFO's portfolio to oversee procurement events. So this was part of it.
But did you then, as I understand it, you became involved at this stage to resolve the impasse?
Yes, at the request of the negotiating.
Yes. And I've shown you that the HOMEX agreement talks about them intervening to resolve the impasse or finding a way to resolve the impasse. You've seen those words in that language, correct?
Yes, but I've described what my involvement in that was.
So I then have only two other small things to deal with. The one relates to Mr. Gama's legal fees in a different era and realm now altogether. Could I ask you to turn to Transnet Bundle 3.
Can I just put some of these? Sure.
I haven't agenda for a break.
Yes,
because
certainly.
I was thinking, let me allow you to finish in case you are close to finishing.
Yes.
But if the witness or anybody feels there is need to take a break, let me know. Mr. Singh, are you fine? Okay, all right. So let's continue and try and finish before we can take a break.
Thank you, Chairperson. I'm not going to be much longer.
Yes, no, that's fine.
Those may proven to be famous last words before.
So you're looking for that?
Transnet Bundle 3. You also see on the spine, it's Exhibit BB 16. 16 and 17.
Okay.
Can I ask you please to turn to page 25. This is an affidavit of Mr. Mpoma. And I want to direct your attention, please, to paragraphs 9 and 10 at page 25. Simply put, Transnet was to pay to Mr. Gama what it was supposed to recover from him as its costs in the High Court application and in the Transnet Bargaining Council. I cannot explain the logic behind the board decision. I was not party to it and was not there when it was taken. However, I actioned it as I was instructed. I also refer the Commission to the handwritten notes dated 28 March 2011 I made at the time on the two bills, one from Bowman Gilfillan and one from Eversheds. Then at 10, I would have discussed the matter with Mr. Anoj Singh at the time, as my note states. However, I don't recall the details of the conversation. The Commission is also referred to the memorandum that I wrote to Mr. Singh, dated 23 March 2011. Now that memorandum you find at page 104. Yeah.
Does it start at 102? Oh, that's a letter, not a memorandum.
No, this is a longer.
Yeah,
One-
I'm sorry.
105 is longer, 10 is...
Mr. Chairperson, perhaps I could I ask if we could have a short break and I can then just check these references. I'm sorry that something must have gone awry, but I don't have more than 10 minutes questions for
Yes,
Mr. Singh after that.
okay. Let's take, shall we make it the short adjournment?
Yes, certainly.
Yeah, let's make it the short adjournment,
Thank you.
15 minutes. We adjourn. Let's continue.
Thank you, Chairperson. The memorandum from Mr. Mapoma to Mr. Singh, you find in Transnet Bundle 1, Chairperson, Exhibit BB15, and it's at page 104.
Yes, I've got it.
So this was the memorandum that I was trying to find. Mr. Singh, was this memorandum sent to you by Mr. Mpoma, dealing with the payment of Mr. Gama's legal fees?
Mr. Chair, the memorandum is addressed to me, as you would see on page 104. But in effect, Mr. Chair, you will see on page 106, it actually hasn't been signed back. So it's addressed to me, but it didn't require my signature, so I don't think I've ever received this memo.
All right. Well, then I want to take you to the handwritten annotations that Mr. Mapoma spoke about. So let me start at page 88, the same bundle. Here is a statement of fees and disbursements due to Bowman Gilfillan. You find that at 88. And if you go to 93, it says, annotations at the bottom, Transnet to pay 75% of the tax costs above, i.e., and so it sets it out, 353,457. Payment has been approved as per attached memo, and it says discussed with Anoj. You see that?
There, I see that.
Did Mr. Mapoma discuss this with you?
Mr. Chair, I don't have any recollection of this said meeting with Mr. Mapoma. And on his own version, Mr. Chair, he says he has no recollection of this, of the details of this said discussion.
Well, he said he discussed it with you. Discussed in brackets with Anoj.
Yes, but in his affidavit, he basically says he has no recollection of the details of this discussion.
Yes. And I can show you there's a series of these. I mean, you find the same thing at 96, 117, 120. I needn't take you to all of them.
I don't deny that he says it, that he's written here that he's discussed it.
Yeah.
But it doesn't mean to say that he actually did.
Yes, well, do you recall him discussing it
No,
with you?
I don't.
All right. Let me then take you back to Transnet Bundle 3, Exhibit BB16. And I'll ask you please to go to page 31. If I could direct your attention, please, to paragraph 12.2. Mr. Singh, I mean, I don't know if it's necessary for me to explain to you what happened here. I assume that you've worked through these papers, but there was a settlement with Mr. Gama, you'll remember, and that there was an agreement to pay him 75% of the costs that he incurred in a High Court application. But what ended up happening is Transnet paid him 75% of the cost that he incurred, and then also paid him 75% of the costs that Transnet itself had incurred. So that was the anomaly that's being investigated. And those annotations that I've shown you, those were the annotations that then resulted in those payments being made. So at paragraph 12.2 at page 31, Mr. Mpoma, this is in another affidavit, said Regarding the first payment, it came about as follows. Following my dealings with Lange attorneys, who presented a ridiculously inflated bill, I was opposed to paying Mr. Gama's fees. This was an unpopular decision, and I came under pressure within the organisation to finalise the issue. In this context, I held a discussion with Mr. Mkonazi, in brackets, who I dealt with closely on the issue, which culminated in him instructing me to pay 75% of Transnet's tax cost to Mr. Gama. And then, in brackets, on the basis that he incurred liability for such costs. Given that I was unhappy with this, and one can understand why, as I've explained, I escalated the matter to Mr. Singh, who approved the payment. I refer in this regard to my handwritten annotations dated 28 March on various tax bills attached to Ms. Mtlapi's affidavit on cost. Those are the ones that I've taken you to. So here he says that he escalated the matter to you, he was concerned, and you approved the payment. What do you say?
Oh, sorry. So, Mr. Chair, as I said, I do not recall Mr. Mapoma escalating this matter to me. Mr. Chair, the background to this matter, I think, would be relevant to the Commission is that when the board was seized with this matter of Mr. Gama, given the fact that Mr. Gama had gone through a disciplinary process, which resulted in his dismissal, and me being in the previous board, they had asked me to recuse myself from the decisions relating to Mr. Gama, which then I promptly did. So any issues relating to Mr. Gama's reinstatement and the issues relating to these costs, Mr. Chair, I was not privy to. So if Mr. Mapoma had escalated this issue to me, Mr. Chair, my response would have been exactly as I just responded to you, is that I have no ability to assess whether this is good, bad, or indifferent, because I was not part of the process that made the decision to approve these costs or agree to these costs in the first place. In addition to that, Mr. Chair, I would not be the delegated authority to be able to approve these costs. And in my reading of this, Mr. Chair, the board had already taken a decision. So they had approved the costs. So there was nothing to approve, in essence.
You see, Mr. Singh, the board hadn't approved the costs. There was a settlement agreement that said Transnet would pay 75% of Mr. Gama's High Court costs. There was never an agreement, it wasn't a term of the settlement, that Mr. Gama would be paid 75% of Transnet's costs. So what Mr. Mpuma is saying here is when he was instructed to pay those costs by Mr. Mkonazi, he was concerned, came to you. That's what he's saying.
No, well, I'm saying I don't recall this. It never happened as far as I'm concerned. And as I said, if he had escalated the matter to me, I had no knowledge of this.
And then what he says, in furtherance of his version, is he refers to his handwritten annotations where he says, it's discussed with Anoj.
But Mr. Chair, also, if you look at what he then says, is that the decision was also recorded in the memorandums to Mr. Singh and Mr. Molefe referred to paragraphs 10 and 12 of my second affidavit. We have gone to that affidavit, to that memorandum, and we know that I'm not a signatory to that memorandum. So.
But if he needed somebody, or if he needed the Chief Financial Officer to approve payment, would he have any choice other than to come to you?
But that was my original point, Mr. Chair, is that I would not be the delegated authority to approve something.
But if he needed the Chief Financial Officer, you would be the only person if he needed the Chief Financial Officer.
If he needed me, but he didn't need me in this case.
Yes, you say he didn't need you in this case.
No.
Now, why would he need you if you were Why would he come to you if he didn't need to come he didn't need the Chief Financial Officer, do you know?
I have no,
Would he run some things by you, things that are financial?
Mr. Chair, these things would have been paid, I would assume, out of the group legal budget. So
Yeah,
again,
I
group
think he
legal would have
said
had a
so.
budget that would have been spent against. But Mr. Chair, as you can see, other than the handwritten annotations which he makes on these bills, there's nothing else I can say.
Yeah, okay. Mr. Mayor.
Yes, thank you. And then, Mr. Singh, can I ask you, in the same file, to turn to page 801? I want to just deal, if I could quickly, with Malusi. Now, 801 is a memorandum that was addressed to you by Mr. Selinga.
That is correct.
You then approved the payment of 20 million that you see at 802 to Malusi.
Yes, sir.
Did you have any idea what you were actually paying for?
No, on the basis that the letter from Mr. Molefe had been attached.
All right, so you didn't know what you were paying. You were simply guided by the letter is the letter at 803 that you're referring to.
That is correct, yes.
So you made no further inquiries or interrogation of this transaction.
No, sir.
And then,
why would Mr. Selinga have needed you here?
Mr. Chair, in this one, if you look at the issue of the budget, here you see the settlement amount was not budgeted for on page 802.
Was not budgeted for.
Yes, on page 802, if you look at paragraph 9, it said budget implications. The settlement amount was not budgeted for. The payment, therefore, will be made out of the corporate center. And then I added my handwritten note to say, and will be funded from overall cost savings. So basically, Mr. Selinga, Mr. Molefe had created the liability in terms of agreeing to pay. Mr. Selinga then identified to say, well, I don't really have the money to pay this. So where am I going to get this money from? So he then basically prepared this memo to say, listen, can I go ahead and pay this, notwithstanding the fact that I don't have the budget? And then he said, listen, in the overall corporate center budget, we can reallocate expenses to cover this. And at that time, Mr. Chair, we had a cost savings target that we were achieving. So I just added the point that we would be comfortable in terms of being able to pay this amount because of the cost savings initiatives that we had put in place.
But why would it need to come to you?
Because I was the CFO, and the budget, you can't overspend on your budget. So
Is the position that if payment is not budgeted for, it must come forward under the budget or allocation of a particular department or unit?
yes,
If they don't have the budget for that, it must come from somewhere.
it must be allocated to them.
It must be allocated, and you would be responsible
I
for
would
that.
be responsible for that.
Okay. Mr. Mayberg.
Mr. Singh, then perhaps I could just ask you, do you own shares or have you ever owned shares in a company called Venus Limited?
No, sir.
As I said to you at the beginning of the the day. I wasn't going to take you through all of your affidavits and everything that is in there. Obviously, it will have to be read and digested. But perhaps I could end by asking you, is there anything, I know you're going to put in an affidavit in re-examination, so as to speak. Is there anything that you would like to say by way of conclusion of the evidence that you've given?
Not at this stage.
That completes our questioning and inquiries of Mr. Singh. Thank you, Chairperson.
Okay, thank you. Where are we with the timelines for various things, affidavits and I think written submissions?
Chairperson, maybe just to fill you in, we've been receiving some documentation from Eskom during the week. I think this morning we received another document with, I think, about 50 annexes there too. The hope was that we will submit an affidavit tomorrow in response. That was our affidavit in response to the last, let's call it issues in main that Mr. Seleka. We're still hopefully going to do that. If we can't achieve it by tomorrow, we'll achieve that by Monday.
Okay.
And then there's the issues of our reply.
Yeah.
And then, of course, Chairman indicated that you want some heads of argument, if I can call it that, or submissions pertaining overall to the Eskom stream.
Yes.
So we still plan to do whatever is necessary to achieve what we set out, or we agreed to do.
Or the arrangement that had already been made in regard to written submissions were made in regard to Eskom. Okay, we had not made any arrangements in regard to Transnet.
No arrangements being made, Chairperson.
Okay. On behalf of Mr. Singh.
Chairperson, we've got no problem with that. We are going to, however, ask you, and especially in light of what you stated this morning, to be a bit patient with us, timeline-wise. We've taken note of your timelines, and we will, if you don't mind, we can revert maybe on Monday with possible dates.
Yeah, okay, no, that's fine. Okay, that's fine. Seeing that I might be mixing up things that were discussed under the Eskom work stream, maybe, and thinking that they were discussed under the Transnet work stream, let me check the arrangement that a re-examination would be dispensed with, but instead affidavits would be filed. Does that, have we reached that agreement under the Transnet work stream or not?
In fact, Chairperson, you will recall when we started off on the Transnet stream, we reserved our right not to make an opening statement, but to consolidate whatever we wish to state at the end of the process. So we still reserve that right to, instead of doing a re-examination in inverted commas, to submit an affidavit. There's a number of issues that we wish to deal with. And I think we've indicated to you also in chambers that we do not think a day would suffice, and it would potentially be better to rather just go on oath and deal with those issues on oath.
Yeah. Okay, all right. We will need then to have a time when we can fix the time frames. You suggested that on Monday you might be ready. Mr. Mybeck, do you think it would be fine if we made arrangements that in regard to what they need to file, by when they must file it, that we can discuss that on Monday? Would that be fine? How is your situation?
Well, Chairperson, I'm not sure that my learned friend will be here on Monday. But I mean, if we can't reach an agreement, it may present something of a difficulty. I mean, I don't know how long my colleagues need to put in let's call it the re-examination affidavit.
Yeah.
Perhaps you could give us an indication now.
We will revert on Monday, Chairperson. There's a number of issues that I need to canvass with both my client and my attorney. And we undertake to make contact with Mr. Myburg on Monday. We can telephonically try and see if we can thrash out some kind of arrangement. And if it's necessary to come and address you on the issue, we'll make ourselves available.
Okay, I think then maybe what we could do is, if on Monday there could be a discussion between both sides to provisionally agree some time frame that would be subject to my approval.
Yes.
Then Mr. Mybeck can talk to me after those discussions, and then I can indicate. Is that fine?
Yes, I think that's a sensible proposal.
Yeah.
Thank you.
It's
Yeah.
acceptable to us too, Chairperson.
Yes, okay, all right. It now remains for me to thank you, Mr. Singh. You have come to the Commission numerous times to be able to give your evidence and subject yourself to questioning. Thank you to your legal team as well. Thank you, Mr. Mybeck. I know that you and I are not going home as yet, but thank you very much for all your cooperation. Thank you.
Thank you, Mr. Chair, and Mr. Myburg as well.
Thank you. Shall I adjourn for a few minutes, Mr. Mybeck?
Thank you, Chair.
Yeah, we'll adjourn for about 15 minutes before we resume and then we will deal with the evidence of Mr. Gigaba.
Thank you.
We adjourn. Good evening, Mr. Gigaba.
Good evening, Mr. Chairperson.
Thank you. I guess almost everybody else has been here with us, except your junior, Mr. Myberg. Good evening to everybody. Mr. Solomon is there. Good evening, Mr. Solomon.
Good evening, Chair. Good evening to you.
Good, thank you, thank you. Okay, please administer the oath of affirmation. I'm sure by now, Mr. Gigaba, you can recite the oath.
By heart.
Yeah.
Please state your full names for the record.
My name is Malusi Gigaba.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath binding on your conscience?
Yes.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Okay, Mr. Myberg.
Thank you. Good evening, Mr. Gigaba.
Good evening, maybe.
Do you still have your schedule with you?
Yes, I do.
Could I pick up at page 36, please? Under the heading, the Gupta money counter.
Yes.
Ms. Mangoma said at paragraph 64 that on one of the visits to the Gupta residence, when you were still the Minister of DPE, we attended a function at the Gupta residence. AJ Gupta took us on a tour of one of the newly renovated houses in the Gupta compound. We were part of a small group of people who were unknown to me. He showed us a room that had been converted into a small cinema, and in another area I saw a sauna. At one area I saw a device which looked like a small version of an automated teller machine. Mr. AJ Gupta demonstrated how it operated by punching an amount on a keyboard of the machine, which was 10,000 Rand, if I recall correctly, and it dispensed the cash notes in denominations of 100 and 200. You want to comment on that?
I was never part of this tour. I've never seen an ATM. It was the first time when I read this affidavit that I knew that a private individual could have an ATM at their residence. I was not aware of this. It's the first time I hear of it. And it seems bizarre to me, as I said in my response, that Ms. Ngoma would be shown an ATM that could dispense an entire 10,000 Rand. I don't know how that happens. In my own opinion, if she saw such a thing, if she's not lying again here in this statement by herself, then it would mean that she was alone in my absence when she saw such an ATM. But as I say, it's the first time I hear that a private residence could have an ATM, because my understanding is that an ATM should be an available instrument to the public. I don't know. I don't know anything about this.
Have you any idea where Ms. Mangoma would have got this? Because this is one of those things that certainly isn't a matter of public record.
I beg your pardon?
This is not one of those things that's been in the media or is a matter of public record.
As I have indicated, Chairperson, previously, that Ms. Ngoma's affidavit was the works of accomplished lies. Very, very concerted effort to fabricate a story that doesn't exist. That is why I have visited many people, sir. I have been at the at the official residence of the president. I have visited many people who are wealthy. I've never seen any of them, including leaders of banks, who have ATMs at their private residences. I think she's the one who can best answer this and probably explain how a bank would install an ATM at a private residence. Which bank is this? There are several banks in this country. To my understanding, there are no regulations which provide for somebody to have an entire ATM, because people would need, if a bank needs to come and, an ATM doesn't have money that you can withdraw that is drawn directly from the bank. It means a bank has to deliver cash loads into the ATM. Now, why would you have an ATM if you wanted to have access to cash? As a private individual, you would simply go into the bank and apply for that cash. Why would you have an ATM, and which bank exactly would install such a thing? If it happened, I am not aware of it. I have never seen such an ATM.
I think I must just explain to you that I don't think it's Ms. Mangoma's evidence that it was an ATM connected to a bank. She went on to explain that it was really in the form of a cash dispensing machine.
What is a cash dispensing machine, sir? I've never seen a cash dispensing machine. I mean, surely, if a private individual needs to have cash from their bank, they go into the bank, they withdraw money. I have never seen a cash dispensing machine. I don't know what it looks like. The only cash dispensing machine I'm aware of is an ATM, and I have never seen this ATM. So I consider this to be lies.
You know that there was a cinema and a sauna at Saxonwold?
I've never been shown a cinema and a sauna. I would presume, again, I've been to private residences of many wealthy people. They do have saunas, they do have cinemas, many of them it's mini cinemas. And I'm sure if I were to fabricate a story about any rich person, I would also go on to say they have a lounge, they have a heated pool, they have so on and so on and so on. But at the Gupta residence, I have never gone to be shown a sauna and a cinema. In actual fact, I would be surprised if anybody showed me that thing, because what's special about a sauna and a cinema?
Then at paragraph 66, Ms. Mangoma goes on to say that during February 2020, I asked Mr. Gigaba for a divorce. Without expanding on the details surrounding the personal circumstances of my request for a divorce, I bring the following to the attention of the Commission. And she says at 66.1, Mr. Gigaba asked me to delay the divorce proceedings until after he appears before the Commission. And then you give quite a lengthy response to that, that spans from paragraph 141 all the way to 149. These are things that I think you've mentioned already, albeit in a different context, but what is your response to that?
As I stated in my affidavit, it's not true that she asked for divorce in February 2020. The issue of the divorce was initiated by me. I think it's in August or something like that, of August, September 2020. So it's not true that Ms. Mngoma asked for divorce in February 2020 and that I asked her to delay until I had appeared before the Commission. Mr. Chairman, in February 2020, I did not know that I would be appearing before the Commission. At that time, I was responding to a number of affidavits that were being submitted. The summons to me to appear before the Commission occurred very late last year, after which, after I think they appeared this year, earlier in the year, and we appeared here. We were requested to delay our appearance until at a later stage. I understand now that that was informed by the affidavit that she had submitted, that the commission obviously wanted to look at, but the issue of Ms. Mngoma is that in January 2021, she is the one who approached me requesting that my divorce attorneys should contact hers, making a number of pleas. She informed me at the time that Mr. Tembeka Ncukaitobi, senior counsel, was very excited about the prospect of her submitting an affidavit at the commission against me, and that they were in conversations with the attorneys of the commission. At that time, she showed me a number of WhatsApp exchanges between herself and the attorneys of the commission, and she said to me that her attorneys had assured her that should I agree with her proposal, they would prevail upon the commission to not to allow her to testify on the grounds of spousal privilege. I then had a conversation, as I say, with my attorneys, and the issue of us pleading with them was not part of the conversation. The issue that we were discussing with them was issues surrounding the divorce. I did not bother to say to her that she should go ahead and not come to the commission. It was her own decision, and I think that is demonstrated by the fact that when she first was supposed to appear before the commission, she instructed her attorneys to say she was withdrawing her participation on the grounds that the commission had doctored her affidavit and inserted in the affidavit things she had not written, and that in this affidavit that was now before the commission, there were things she had not written. She was only forced to sign the affidavit that she had not consented to. She didn't say, when she was here, through the mouth of her attorney, that I no longer wanted to participate because I am now pleading spousal privilege. She now said it was because the commission had manipulated her evidence. So you can see that you are dealing with lies, with inconsistency. You are dealing with somebody who is not willing to tell the truth as it is.
Well, I must just put this to you for your comment. When I put your version to Ms. Mngoma, in relation to paragraph 143, 1, 2, 3, and 4, she disputed that she ever said to you that she would not appear before the commission if you met certain conditions. And she said the same thing in relation to 147 and the Blue Valley House. Do you want to comment on that, or do you stand by your version?
I stand by my version, Chairperson. Ms. Mngoma lies pathologically. She makes a habit of lies. She says things today, she denies them tomorrow, or even on the same day. So these things that are here, where would I have found that she had spoken to Mr. Ncukaitobi? He's a respected member of the legal fraternity in South Africa. I would not go out of my way just to fabricate lies about somebody like that. These are all issues that she told me. How would I have known that she was in conversation with the attorneys of the commission? These are things that she showed me on her phone. All of the issues which I state here, including the matters relating to my house at Blue Valley are issues which we discussed with her, because she asked me, what about I give her that residence? And I clearly stated that the residence is the legacy of our children, that it was still owing quite a lot of money. That I then said to her, if you were to take it, you would have to carry on the bond. You know, I'm willing to give you the house, but you must then carry on the bond. But I then even said to her that, but you can consider selling the house and splitting the cash or taking the whole cash, which would be difficult in today's environment, because if you look at the property market, it's a buyer's market. If you sell a property at this stage, you are not likely to make a lot of money. And so we agreed that taking the house would not be in the best interests of the divorce settlement. And only for me to learn on City Press afterwards that she was saying, I think, angered by the fact that because when they talked to my attorneys, they then made an offer that we had agreed to waive the antenuptial contract. And my divorce attorney said to them, you are out of your minds. He said to them, you are out of your minds. There's no way we can agree to that. We can agree to some payment, a settlement of sorts, but not waiving the antenuptial contract. After that, she then approached the City Press claiming that I had made this offer to her so that she would not be appearing before the Commission. Mr. Chairman, it was brought to my attention by my divorce attorney that I was correct to be careful about this and not to comment on it when she made the offer, because it was clear that it was blackmail on her part, and so we took the view that there is no offer anymore on the table.
So, Mr. Gigaba, you style Ms. Mangoma, if I understand your evidence correctly, as a pathological liar.
Yes.
Is that right?
Yes.
And you say she lies on a daily basis.
Yes.
Is that right?
Yes.
So I assume by way of contrast, you consider yourself a person of integrity and honesty.
I beg your pardon?
You consider yourself a person of integrity and honesty, I take it.
Yes, I do.
Just in relation to some of the things that you've mentioned, Ms. Mangoma said about the WhatsApp communications between herself and the Commission that she couldn't have shown you them because she hadn't had any WhatsApp communications with the Commission.
She showed me WhatsApp communications with the Commission. I don't understand this point, Mr. Chairman, because it would seem to me that there is that the evidence leader is casting aspersions on me. The contrasting what I say about Ms. Mngoma and asking whether I'm a man of integrity, and then saying Ms. Mngoma says she couldn't have shown me the WhatsApp communications between herself and the attorneys. Where did I get that from? If she was showing me fabricated text, then the issue is on her and her integrity. Because insofar as I understand it, those were WhatsApp text exchanges between herself and the attorneys and the attorneys of the Commission. In those texts, there were proposals for meetings to be arranged as soon as she came back from holiday. That happened as it is. Those meetings were held soon after she returned from holiday. And so that has got absolutely nothing to do with whether I'm a person of integrity or not.
Well, the evidence leader is entitled to probe issues with every witness. Obviously, with regard to Ms. Mngoma's evidence and your evidence, and particularly with you rejecting most of what she has said as untruthful, and I think she has herself in her evidence also said certain things that you have said in your evidence are untrue. So the evidence leader is entitled to probe and look at both witnesses.
But with due respect, Chairperson, I doubt if he is entitled in probing my evidence to ask about my character.
Yes, about?
My character.
No,
Because
no,
I think the
he is
issue that we are dealing with here is the statement that I have
No,
made.
he is entitled to ask questions that are aimed to establish where the truth lies. The rules of the commission are specific that an evidence leader is entitled to ask questions, including questions aimed at establishing the truth. And obviously, if there are conflicting versions, that means even asking questions that hopefully can throw light of where the truth lies. So it's something that's permissible. But obviously, from your side, you are entitled to respond in a manner that supports what you say, and in a manner that indicates that, as far as you are concerned, there is no basis for anybody to think that you are not honest, you don't have integrity. You are entitled to, in answering, to put up there.
Thank you, Chair. I would like to emphasize that I am a man of integrity. I am being honest.
Yeah.
And I think it's unfortunate to have my integrity questioned in that fashion.
Yes, but I think you, in a forum such as this, don't take it personal. Don't take it personal. It's nothing personal. He's just doing his job.
I appreciate
it. So don't take it personal. But somebody like you who has been a member of parliament for a number of years shouldn't easily take it personal, because in parliament, you people say all kinds of things against each other.
I appreciate it, Chair. Point taken.
Yeah. Okay, Mr. Maibek.
Thank you. Mr. Gigaba, also in relation to Mr. Ngitobi, Ms. Mngoma testified in response to this that you like picking on Advocate Ngitobi, as she put it.
I'm sorry, what did she say?
She said you like picking on Advocate Ngitobi.
Oh.
Why?
Well, perhaps you can tell us.
Well, I'm sure she would have explained to you. I mean, I've got absolutely no reason. As I say, I respect him. I respect Advocate Ngitobi. He represented me at Home Affairs when I was still Minister of Home Affairs. I have no personal grudge against him. It is her who raised with me. There's a number of people that she has spoken about when she has spoken to me. And I'm sure she would be worried about me referring to them here, because it would mean to them that the issues they discuss with her are not safe. Because, as we would say in Zulu, she was kicked by a horse on the chest. She cannot be able to withhold the not to disclose the secrets that they have had. I've got no grudge against Advocate Mugwaitobi. I have high respect for him, not only in his professional capacity, but also in his personal capacity.
What Ms. Mangoma also said is that her appearance before the Commission and her cooperation with the Commission is not in any way connected to your divorce, and that she gave evidence here as part, as she puts it, of her civic duties, or duties as a South African citizen.
That would have been genuine. I would have considered it a genuine concern on her part had we not had a disagreement around their offer in terms of our divorce settlement and the issues she raised with me. And secondly, had she not gone on to lie so extensively. Because she has misled the Commission on a whole range of things, including accusing the Commission of authoring her affidavit and manipulating some of the issues and inserting things in her affidavit which she had not agreed with. Now, for somebody who would have done that, you would then expect that in her testimony, she would be very clear that, look, I want to testify only on the basis of an affidavit which I have done myself. Even her supplementary affidavit does not say that that was inserted by the Commission, therefore I will not talk about it. Even as she was asked questions, she continued to answer on the basis of the initial affidavit. So, in my opinion, the issues that prompted her to come here were related to our divorce and her concerns about what the settlement of that divorce would be. And that is why even the divorce features so prominently in her initial affidavit.
I could ask you then to direct your attention to paragraph 66.2. Around June 2020, says Ms. Mangoma, Mr. Gigaba asked me for all my electronic devices because he had brought someone to our home who he introduced as an IT expert to delete certain information from our phones, iPad and laptop, our devices. I refused to hand over my devices. This made him visibly upset. On querying what information needed to be deleted, Mr. Gigaba stated that certain pictures and information on my gadgets could be used to prove that he had visited the Guptas regularly, which would contradict his answers in Parliament to questions put to him by the economic freedom fighters, members of Parliament. He said that he did not want the same to happen to him as had happened to Mr. Malefe during the Public Protector investigation, which had used his cell phone records to prove that he had visited the Gupta residence. He was also particularly concerned to delete any photos that I had taken on our trip to Mumbai and New Delhi in India, photographs of our honeymoon trips to Mauritius and Dubai, and my private trips to Dubai. I did not hand over my devices. And let me just finish this because you answer all of the paragraphs together. 66.3, Mr. Gigaba also asked me not to speak to the Commission nor the law enforcement agencies about Gupta visits, the cash and the gifts. 66.4, she refers here to the 18th of June 2020, but you'll remember, Chairperson, that a correction was made to that date by Council before she gave evidence, and it was corrected to read 20 July instead of 18 June. So she says on 20 July, a domestic incident occurred at our home, and then the 24 June was changed to 22 July. So on 22 July, Mr. Gigaba called me into the living area where I met Captain Vaso and Sergeant Ntambani of the Hawks. They demanded my 2 iPhones, my old Huawei phone, my iPad, and my MacBook, and knew exactly where to locate each gadget in various parts of our home. They refused my right to legal representation They demanded all the usernames and passwords for the devices, all details of my email and social media accounts, making me search each one in their presence. When the confiscated gadgets were later returned to me, all photographs and emails relating to my trips overseas, visits with the Guptas and other information were deleted from the devices. And then she refers to a High Court judgment. Now, what is your response to all of that, Mr. Gigaba?
Thank you very much, Chairperson. Let's start with the IT expert. And I've challenged Ms. Mngoma to name the IT expert and provide proof of such an IT expert and conversation. Because there was no such an IT expert. Around June 2020, there was absolutely no need for an IT expert to come and do the things that she alleges I wanted to delete from her phones, her iPad and laptop. Again, Chairperson, this is a lie. A lie which I deny with the contempt that it deserves. I never brought such an IT expert. I've never asked her to delete any information from her phones or any of her gadgets. Ms. Mngoma does not have a laptop. The person, Ms. Mngoma, does not have a laptop. She has an iPad. She has a MacBook. I guess when she talks about the laptop, she probably is referring to the MacBook. I never asked any IT expert to come home to do this. So all of the things which flow from there, certain pictures and information, Ms. Mngoma is also a very public person. All her things are on her Instagram account. All the pictures she's talking about are on her Instagram account. So if she claims that there were pictures which needed to be removed from her phone, why would you remove those pictures from the phone when they were already on her Instagram account? The trips she's talking about, which were put to me when I was a member of parliament by various opposition parties, I responded to those issues when I was an MP. They are on the records of parliament, and I'm sure that the commission would be entitled to those responses because they were also for public record. Insofar as the information which could be used to prove that I had visited the Guptas, Chairperson, why would that information be on her phone and not mine? Anybody, I mean, just simple logic. Why do you remove information from somebody's phone when that information could have been found on mine? The issue about Mr. Mlife, I've never raised this with Ms. Mngoma. Never said to her that I don't want what happened to Mr. Brian Mlife to also happen to me, because the public protector did her investigation. I cannot recall the year. I think it must have been 2017 or 18. Published her report on the basis of
2016.
I beg your pardon.
The report was published in 2016.
Oh, thank you very much, Chairperson, for the correction. And that report did not include me. The public protector had no reason not to include me in her report, but after her investigation, my name was not in that report. So I would not worry about this 4 years later, when the report had been released, as the Chairperson has correctly corrected me in 2016. The photographs about the trips to Mumbai, to New Delhi, are not necessary. Why remove them? It's public record that I visited in 2015 New Delhi. I did so in my official capacity as the minister, and as I indicated in my response, the trip was part of my official visit to India, and therefore, if you wanted to know anything about the trip, you did not need to expunge pictures or to extract pictures from a phone. You just simply needed to ask me or go into the records of the Department of Home Affairs, which would explain the purpose of the trip, the reason why the trip was applied for in the presidency, and the report. Because the good thing is that back then, I wouldn't know now, I'm no longer a minister. Back then, if you went on an official visit to any country, you were expected to provide a detailed report to the president, because the presidency was concerned that many ministers undertook trips, some of which, or not many, some ministers undertook trips, some of which trips had nothing to do with official business of government or their departments. So we were expected, I think, much earlier on to provide reports when we came back on official trips abroad. The issues of the honeymoon trips to Mauritius, the trips to Dubai, those were on her Instagram account. I have no access to that Instagram account, and I could not have demanded of her to expunge those pictures. As I say, Ms. Mngoma is a very public person. She posts anything, including if she arrives at the airport, you will find pictures of her, Louis Vuitton bags and stuff like that. That's the person she is. With regard to not talking to the commission or the law enforcement agencies, I've never done this. I've never asked her not to do this. It's always been my view that if she wants to talk, I didn't expect her that she would do it. But when she decided that she was going to do it, I've never asked her not to do it. I understood that she needed to do it. She was angry. She had always said that she would drag me if we went through the divorce, and so I had no reason to stop her about it. With regard to the incidents of July, I've tried to explain here in detail, because, you know, it may sound as if what she describes are just petty, a petty forgetfulness about dates. But it's not. It's because she's fabricating a story. And in fabricating that story, she then fabricates the dates too. That is why you can see here, it's not only about this incident that happened at our residence, it's also about the trip to India. It's about the reason for the trip to India. It's about the honeymoon, a trip to Mauritius, all of those things. This is not just a small, negligible forgetfulness. It's about the fact that this person is deliberately fabricating a story, and therefore, in so doing, she fabricates the dates too. Captain Mavuso and Ndabambi, it's Captain Mavuso who came to do this, to take statements. The day after the incident of the 20th, because when this incident happened, I called Captain Mavuso and said, look, something like this has happened at our residence. Will you please come quickly and take a statement? Because in my opinion, there was an investigation which they were undertaking. I had not heard the results of that investigation. I still am not aware of the results of that investigation sitting here. I have not been given an official report on that investigation. And he came the following day on the 21st. He took the statements. He brought with him a police photographer who took photos of the damaged vehicle, the damage to my study, and inspected the items of evidence which still lay next to the car, and some of them had been taken to the kitchen. On the 21st, they did not demand her gadgets. That's a fact. It's in the police records. They did not demand her gadgets. These gadgets were collected on the day they came to arrest her, on the 31st of July. It is not true that they knew where the gadgets would be. How would they have known? Unless they had somebody who was in the house who knew where she puts her gadget. I did not know where she puts all her phones. As she says, she had several phones. I did not know where she puts those phones. When they came, they asked for these gadgets. They collected them as part of collecting the evidence which related to the other matter they were investigating, of an allegation I had received, which is in the police records too, of a plot to kill me, which involved her. The incidents, therefore, of 20 July, in my opinion, and I did not know, could not be treated as separate from the allegations of a plot to kill me. And so when the police took this stuff, it was for the purpose of extracting from the phone, of downloading from her phone, I presume, any information which could lead them to establishing the veracity of the claim that she was involved in a plot to kill me. It had nothing to do with expunging anything from her phone. Now, Chairperson, if there is any information that was expunged by the police from her phone, surely if you went to the IT department of the police, the records of what was extracted from her phone are available. Those records could be made available to the Commission. The court decision of February this year said everything which was taken from her phone must be returned. Surely there is an account and an audit of all those things. So there couldn't be a situation where there was something extracted from her phone, which was on police record, which was not returned together with the phones when the gadgets were returned to her. So what she is saying here is a deliberate lie in order to present a particular picture of an encroachment to her privacy and an attempt to hide any information. The advantage of IT, and she claims to be an IT expert, is that all of these things are available on police records and they could be checked on police records. And if there is anything which was never returned to her, those things would then be either returned to her or the police would have to explain why they were not returned to her as in accordance with the court order of February 2021.
So let me just understand, Mr. Gigaba, and I'm going to come to the judgment later on, but do I understand the sequence to be this? There was the domestic incident on the 20th of July.
Yes.
And as I understand what you've said, the Hawks came to take a statement in relation to the domestic incident on the 21st of July. They came the next day.
Yes.
And then 10 days later, on the 31st of July, they returned to your home, this time to arrest Ms. Mangoma.
Yes.
And it was at that point that they took the gadgets.
Yes. So on the 22nd, if I'm not mistaken, on the 22nd of July, they called me and asked me to go to the Brooklyn police station to make a statement there, which I did.
So you made a statement on the 22nd of July.
Yes,
Is
I think it must have been on the 22nd of July, but it was within that period of the domestic incident at home.
And I take it that that statement then related to the domestic incident.
Yes.
And these two gentlemen, are they from the Hawks in Mpumalanga?
Well, they are from the Hawks. I don't know, I didn't know which division of the Hawks. Remember, Chairperson, as I've said, a bit earlier last year, I received an SMS text which is available at the police, which informed me that, or which alleged that Ms. Mngoma had hired people to kill me. I approached the Minister of Police for advice on how do I handle this. Do I go to a police station to report it? Is there a unit where I needed to report it? The Minister of Police said to me that I will ask people involved in investigations of political matters and assassinations to contact you. I was contacted by the head of the DPCI, who indicated to me that they had assigned Captain Mavuso to come and take a statement. Indeed, he came. I don't recall what date it was. Indeed, he came, he took the statement, and they said, we are going to investigate, and we will keep you informed of the investigations. So when this domestic incident happened by the same person, and the fury, the anger with which it happened, if you saw that car and how it was damaged, you could see that this person was extremely angry when she did this. The damages to the car cost R500,000 to fix. And so the owner of the vehicle would not say to me, my vehicle has been destroyed, damaged at your residence. You did not report the matter to the police, you didn't open a statement, and I find that okay. The reason I called Captain Mavuso was because he already had an issue he was investigating in relation to the same person who committed the damages to the car. That she committed the damages to the car is contained in her own confession statement, which she made to Captain Mavuso and Sergeant Ndabambi, where she indicated that yes, indeed, I had damaged the car, and the instruments with which she had damaged the car were still there, and the police took those instruments. So that was the reason why I called Captain Mavuso. And the issue of them being from Mpumalanga was not known to me. Why would I have picked people up from Mpumalanga? What had I to do with the police, with investigators in the police, and to the point of knowing exactly who to call and where are they based? I had no such information. I acted on the information of the people provided to me by the relevant authorities within the police.
So when had you made a statement to Captain Mavaso about the plot to kill you?
Yes.
When was that?
I don't recall, sir. I'm sure the police would be able to provide that information to you. I don't recall. I don't recall what month it was, whether it was in May or April
Was it
or
in
June.
2020?
It was in 2020, yes.
So,
That's Captain Mavuso, huh?
Yes.
Mavuso.
Yes.
yes. So that would have been in the first half of 2020.
Yes.
So you talk and have confirmed that Ms. Mngoma was arrested on the 31st of July. What was she arrested for?
Damage to property, sir. Damage to property. Yes, she was arrested for damage to property.
By the Hawks?
Yes.
Can we then deal with the loss of passports? Well, that's at least the heading. At paragraph 66, and let me read to you 2 paragraphs, and then you can 66 and 67. On my return from Durban on 1 March 2021, I discovered that mine and my children's personal passports are missing and not where I'd left them. I found only an empty passport cover for my passport. I also discovered that copies of my passport that I had made earlier and kept them in my drawer were also missing. I confronted Mr. Gigaba about the whereabouts of my children's passports and mine later that day. He denied having seen them. I believe that the theft of my children's passport and mine was to conceal evidence of a trip that we took to Mauritius. What do you have to say to this?
But, Chairperson, I've not denied the trip to Mauritius. Why would I steal passports to conceal a trip to Mauritius, which I have not denied? But secondly, Chairperson, she kept the passports. My passport is kept by my assistant at Lutuli House because I often have to undertake official trips on behalf of the party, which is currently my employer. And so she keeps my passport with her so that if I have to undertake a trip, sometimes they are at short notice, she can be able to immediately act on the bookings and stuff like that. But the passport of Miss Mngoma and the passports of the children were in her possession. If she lost them, she's the one who needs to explain. And in actual fact, it bothers me that she has not gone to do an affidavit of the loss of the passports and informed Home Affairs of the same, because the passports of my children could be in the hands of any criminal around the country. They could be used, including hers. They could be used by people who steal identity to falsify passports and travel around on the information contained in those passports. But insofar as the theft of these passports, I have no knowledge of them, and I am surprised that I think it seems to me that she is claiming that I have something to do with those passports. I don't. She kept the passports. She knew where they were. Therefore, she should know what happened to the passports.
Mr. Gigaba, you raised the question of why you would want to take the passports, as you say. She said in her affidavit that want to potentially conceal a trip to Mauritius. You say, well, you've admitted that. The chairperson asked Ms. Mangoma the same question. I just want to read to you what she said so that you can comment on it, because her evidence went a bit wider than the affidavit.
Yes.
The chairperson said, why do you think, Mr. Gigaba, why do you think there were trips that Mr. Gigaba might not have wanted to be conveyed to the Commission? And Ms. Mangoma said, well, because firstly, on this affidavit, he denied that we, Ms. Dudu Meni, paid for the trip for us. So he does not want that trip to be there, which she did pay our trip to Mauritius. She even emailed a whole itinerary for us. And I remember when we were in Mauritius, Malusi did not even know where to go to get a car and everything, because he's not used to traveling without his staff. And at that time when we were traveling, it was the two of us. Then she said, too, when we went to Dubai, and there were certain trips I traveled with him, there are certain trips I traveled alone. So he did not want me to have proof of those trips that it happened. Hence he took the passport. And then the chairperson asked again, but why would he not want there to be proof of those trips? And she continued, because the trip that I remember when we stayed at the Hilton in Dubai, and even the trip when we stayed in the Waldorf in Dubai, there was a trip that Malusi said, AJ will sort out this trip for us. And then she went on to explain that you went with AJ to a jewelry shop. and that you came back with watches. And she said, so that trip, what I know, it was them who paid for us. So that is the reason he deleted those itinerary on my emails, because most of the emails are deleted. He also, when we went on those trips, also took pictures, and all those pictures are deleted because he's denying that we went on those trips. So hence he took my passport as well. So I just wanted to, in fairness, ask you to comment on this. You'll see that the evidence is wider than just the Mauritius.
Thank you, Chair. Chairperson, a trip to a country is independent of the country. If she wants to prove a trip to a country, it doesn't necessarily have to have a passport to prove it. I'm sure there are various ways that she can prove that she had visited a particular country. Secondly, there was no trip where I was in Dubai with Mr. Achi. No trip whatsoever. Again, I challenge her to provide evidence. You see, it cannot be that somebody makes an allegation that they do not prove, and it's expected of the person against whom the allegation is made to be the one who proves that the allegation is false. I challenge her to provide proof of Mr. Ajay being in Dubai on the trip she alleges, where he went out to buy me watches. There is no such as happened. I was never bought any watches by Mr. Ajay Gupta. The issue of the trips to Mauritius, to Dubai, are issues which I have not denied. And I have clearly indicated that if the trip to Mauritius was organized by Missy Mieni did not tell me that, Missy Ngoma did not tell me that, and when we went to Mauritius, she came to tell me, it actually was a surprise. She came to tell me that we were traveling to Mauritius, we didn't need a passport to go to Mauritius, and we then traveled to Mauritius. It was a holiday. It's true that I didn't know where do you get a car or stuff like that. In actual fact, we did not hire a car. We were being fetched from the airport. So I didn't have to go looking for any car. As we landed at the airport, we were being fetched. There was somebody holding a placard with our names. And so we went into the car and drove to the resort where we were going to stay. And the issue of the trip to Dubai, it had nothing to do with Mr. Ajay Gupta. He never paid for that trip. And he certainly never bought me any watch, whether in Dubai or anywhere else for that matter.
Gigaba, I'd like to turn to a different document. You should have a file in front of you, which is marked Transnet Bundle 7A. And it contains, in majority part, documents that relate to you. That's BB24. And you'll see a divider towards the end of the file marked BB26. To be right towards the end. That is Ms. Ngoma's exhibit. Right. And could I ask you please to turn to page 1027.8, and perhaps to make it easier for you. I would estimate, Mr. Gigaba, that that's about 10 pages or so from the end of the file.
1027.
0.8.
Yes, I'm there.
Are you there?
Yes.
So what one finds at that page is a supplementary or clarification affidavit. I just want to take you to certain parts of it for your comment, please. Could I ask you to go to page 1027.13?
Chairperson, has this document been provided to me prior to today?
It certainly should have been, yes.
I ask because I am not aware of it and I have not responded to it.
I don't think there's any obligation on you to respond to it, but if you would
the
like an
obligation,
opportunity...
Chairperson, to inform me prior to being ambushed with a document of this nature, surely it would have required me to prepare my responses.
This would be the supplementary affidavit that Ms. Ngoma came to the hearing with maybe the last time,
Yes, certainly.
or maybe the time before that.
Chairperson, I just want to make a point to Mr. Gigaba. I'm certainly not trying to ambush you. If you say you haven't seen it before, I'm more than happy for you to have the opportunity we can deal with it tomorrow. You can read it overnight. I can check whether or not it was sent to you and your counsel. I've certainly not my intention to ambush you. But already what I want to ask you relates to things that we've already dealt with. I was going to direct your attention to paragraph 8. Perhaps we can deal with it this way. If there's something that you feel you can't answer or you want to seek the advice of your counsel on or whatever, can we take it on a paragraph by paragraph basis? Because a lot of it really retreads ground that we've already gone down. Can I ask you
And
to go?
if you are not able to deal with it until you have had a chance to look at it, as Mr. Mybeck says, it can be dealt with tomorrow. So you can answer what you are comfortable with, or if you would really prefer that this document be dealt with tomorrow, that can be done.
No, we can go ahead.
We can go ahead. Okay, all right.
So at page 1027.13, paragraph 8. The submissions and or suggestions made by Mr. Solomon SC on behalf of Mr. Gigaba in his address to the Commission were that I cannot be a reliable... Paragraph 8? Page 1027.13.
Yes.
So let me start again. The submissions and or suggestions made by Mr. Solomon SC on behalf of Mr. Gigaba in his address to the Commission were that I cannot be a reliable witness as I'm unhappy and or bitter spouse going through a divorce, and that as a result my evidence will only serve my bitter purpose to seek to get to Mr. Gigaba. Paragraph 9, the narrative and or suggestion cannot be further from the truth. I wish to demonstrate this point by providing the chronology of events which this Commission is or may be unaware of as follows. 1. During or about the first quarter of 2020, I approached Mr. Gigaba and asked him for a divorce for reasons that are not relevant to this Commission. 2. In his response, Mr. Gigaba requested and begged that I should only consider the institution of divorce proceedings after the completion of his evidence in this Commission. I agreed to this request. 3. On or about June 2020, Mr. Gigaba then requested me to provide and hand over my cell phone and iPad for purpose of deleting certain information contained therein to get rid of certain information which might contradict his false testimony in this Commission. I refused to hand over my gadgets. Is there anything that you want to, to a large extent, you've already dealt with this?
With the interesting aspect that suddenly at 9.3 the laptop is omitted. Again, I repeat, this is not a menial omission. It's not. It must not be read to be we forgot to add. laptop. It says my cell phones, my iPad, but the laptop is suddenly not included, when in actual fact, in her statement earlier, she also had included the laptop. But again, I stand by my chronology, which I presented. In her initial affidavit, she was specific about the date during which she asked for the divorce. She said February 2020. In the supplementary affidavit, she now says during or about the first quarter of 2020. That also is not true. If you want to divorce somebody, you don't go to them and ask, I would like to divorce you, please. You don't do that. You serve them with the summons exactly the way that I did it. So on record, I am the one who filed the divorce application because during or about the first quarter of 2020, or in February 2020, as she claimed in her initial affidavit, there was no request for divorce on her part. She was still happily married, she was still a spouse, and so these omissions to me are not just minor. They speak to somebody who's saying something, and because she had the advantage by the time she submitted a supplementary affidavit to have read my response to her, I then find myself here responding to her initial affidavit, a supplementary affidavit, and her testimony which she submitted. The supplementary affidavit is clearly an attempt on her part to re-engineer the facts as she had presented in her initial affidavit.
All right. Then she deals with the arrest by the Hawks at 9.4. This arrest came soon after I had specifically refused to hand over my gadgets to Mr. Gigaba. More specifically, I make the point that had I done so, I would not have been arrested by the Hawks, who immediately and unlawfully arrested me, confiscated my gadgets, and deleted specific information from my gadgets. I reiterate that the deleted information specifically related to the events which are of keen interest to, and the amendment was made, this commission. This is definitely no coincidence. You want to address that, so far as you haven't already?
Ms. Ngoma says in her initial affidavit, Chairperson, if you just bear with me a little bit, I need to just take this thing out. No.
Okay, that's fine.
Sorry.
You need assistance?
No.
Okay.
All is in order. All is in order. Yes, I'm going to the schedule. I'm just pleading for a little bit of time so that I find, yes.
That's fine.
Yeah. So Ms. Ngoma says in her original affidavit that around June 2020, I brought an expert and asked her to hand over her gadgets. In the supplementary affidavit, she now says that the arrest came soon after she had refused. Now, this is a period of June, July. She says in June, I asked her to hand over to hand over her gadget. But the arrest happened on the 31st of July. Now, this is not soon after she had refused to hand over her gadget. The supplementary affidavit, as I make the point, is an attempt to re-engineer the facts, but a dismal attempt at that, because it continues to omit crucial information, it continues to confuse the chronology of events which she had stated in her initial affidavit. I've already said that there was never a request by me for her to hand over her gadgets. She said in the original affidavit I had asked her to hand over these gadgets to an IT expert. In the supplementary affidavit, the issue of an IT expert is suddenly omitted. It's now omitted, it's not there. She no longer says that the gadgets were to be handed over to an IT expert, but she says that they were confiscated by the Hawks. Of course, she said the same thing in the initial affidavit, but it's not just minor that in the supplementary affidavit, the issue of the IT expert is also omitted. It is to re-engineer the facts, that it's to re-engineer the original affidavit in order, because she has seen my response, in order for her to try and align her narrative with the response which I had provided. Again, I repeat, Chairperson, that if there was any deleted information, the records of the police will indicate what information was extracted from her phone and what information was deleted. And therefore, the burden of proof on this deleted, of this deleted information should lie with the person making the allegation. Because if she claims that I should know what information was deleted by gadgets which she claims were not handed over to me, but were handed over to the police, then she is asking me to perform a task which I cannot perform, because I'm not the one who allegedly deleted this information from her gadgets, because by her own statement, she refused to hand her gadgets over to me or to the so-called IT experts, the nameless IT expert. Then, if she says that the police deleted certain information, she must say that this is the information deleted, and then the police must check and provide information, proof of what information was extracted and what information was deleted, because the police were only interested in finding out if there is any suspicious communication between her and the so-called people that she was alleged to be plotting with to kill me. It had nothing to do with issues of her trips, private photographs. All of those things are found on her Instagram account. If they're not there, it's because she's deleted them herself.
All right, and then she says at 9.5, following from this, in or about August 2020, I learned from the newspapers the announcement of the divorce proceedings being instituted by Mr. Gigaba. Summons was only served on me in September of 2020. She says, only on 17 December 2020 did I conduct a television interview with ENCA, after which I was immediately contacted by the Commission on 18 December 2020. She goes on to say at 9.7, in or about January 2021, discussions on settlement ensued between me and Mr. Gigaba, as in normal divorce matters, and with the principal aim of avoiding a long and protracted process of divorce. You want to comment on those paragraphs?
If I'm not mistaken, Chairperson, in the original affidavit, Ms. Ngoma claimed that the Commission approached her. And I disputed that in my previous appearance and said it was not the Commission which approached her. It was her who offered to approach the Commission when she was interviewed on ENCA and in the City Press interview. So suddenly in 9.6, it is the Commission that approached her. No, the Commission may have technically contacted her, but it is her who offered to come to the Commission. She was specifically asked this question and she agreed and she said, yes, indeed, I would be happy to approach the Commission and make a statement about Mr. Gigaba.
Yes, but the fact is that the Commission did approach her, did contact her.
But the fact is that she offered to come to the Commission.
But I'm not
she
sure.
offered to come to the Commission,
yes.
But it's quite important to view her statements in how she contradicts herself along the way, because it speaks to the reliability of the submission which has been made before the Commission, about which I commented from the very outset that it was a misleading submission. And I think I have also provided a lot of argument to disprove a whole lot of things which have been submitted to the Commission, the omissions between the first and the second affidavits. Secondly, Chairperson, the issue of, I don't think the issue of the divorce and how it was made public is a matter of state capture. It certainly was not leaked by me. It was not leaked by me. I also read about it on the, I think it was the Sunday World, which reported about it. I'm sure they would be able to explain who leaked it if it was leaked. If it was not leaked, and I don't know about, I'm not sure about divorce proceedings. Once the summons are served, I think they become public. They become available. And journalists are always looking for news, and they probably would have found this information through that process. And on 9.7, Chairperson, on 9.7, on 9.7, Ms. Mngoma again conceals deliberately, and on 9.7 and 9.8, conceal. No, you've not come to 9.8, right?
No, not yet.
No, not yet. Yeah. On 9.7, she deliberately conceals issues which she raised with me, and the approach which she asked us to take in dealing with the issue of the divorce settlement. And I reported this to my attorney. I reported it to my attorney exactly the way that she raised it with me. And he said to me, he could only deal with the issue of the divorce settlement because there were two issues which he had raised. One was that I should withdraw the case against her, and secondly, that in reciprocity, she would reciprocate by refusing to come to the Commission. And my attorney said he doesn't think that that's a legal offer that we should make. We should confine ourselves to the divorce settlement.
All right, and then at 9.8, this is when the allegations of supposed extortion started flying around. I must indicate that I'm totally astonished at the utter suggestion that I would seek to blackmail or extort Mr. Gigaba into any form of settlement in respect of the divorce. As a matter of fact, I remain shocked as to what it is I would be seeking to achieve by such conduct. I say this for the following reasons. One, the house we live in is a rented house. Two, we are married out of, presumably that should be community of property. Three, the other house that Mr. Gigaba owns, there's still a huge amount owed to the bank in respect of the bond. Four, the entire furniture in the house that we live in belongs to me. Five, I'm in no state to have any intention to fight with Mr. Gigaba, as we have two minor children together, whom I had even proposed to leave with Mr. Gigaba to avoid any further confrontation and dispute relating to our divorce, and so as to expedite. And six, as confirmed in a letter from my attorneys to the Commission, there are no ongoing settlement discussions between the parties. It is therefore not clear what I stand to gain by assisting the Commission. I want to deal with that paragraph.
Yes. Let me start with the last point. There is no ongoing settlement discussion between the parties precisely because we could not agree on their offer, on what they wanted us to do. The very first thing which they raised with my attorney was that we should waive the antenuptial contract. And my attorney said that they are out of their minds. We would not do that. I was then supposed to look at, and I regret, Chairperson, to have to deal with issues of my divorce here, because I believe issues of my divorce have nothing to do with the mandate of this commission, except to the extent that it is being alleged that I had made an offer that we should settle and for Ms. Ngoma not to come to the commission. They first suggested that we waive the antenuptial contract. We refused. We then said, no, instead, let me look at my policies to see if I could be able to find, because I indicated to her that I had spent a lot of money. She asked me a very specific question. When you resigned from cabinet, what did you do with your policies, your pensions, and so on? And I said to her, I invested them. And part of what was from those settlements, I used it to pay the attorneys, whom I am still owing large sums of money. And then I said, I don't think I have any, because I said to her, I will check with my financial advisor, but I do not think that I have any remaining disposable cash which I can immediately deploy to a divorce settlement. But I said I would talk to my financial advisor, with whom we spoke. I advised my divorce attorney on what the outcome of that was. But it became clear that it was no longer necessary to even make that offer, even the hostile approach which Ms. Ngoma and her attorneys took to go to City Press and make the statement that we were offering a divorce settlement in order to prevent her from coming to the commission. We thought that it would be risky for us to continue with those with those settlement negotiations, even that they would then be read to be a confirmation of the allegations which she had made on the City Press. So that is why there is no ongoing settlement discussions to this effect. The chairperson, last time I came here, asked me a question. Mr. Gigaba, why would Ms. Ngoma say things which seem to be in your favor, but you argue that she is trying to harm you? And perhaps I did not understand the question well when it was posed to me, but I reflected on it, and I think it comes well in the context of, I think, 9.8.5, because she says certain things in her testimony that seem to be favorable to me, that I was not a yes boy, that I was resisting. As a result, there was this view to punish me by sending me back to Home Affairs. Now, but in my view, Chairperson, the mere fact of these testimonies and the issues being raised here do a lot of harm to me, to my reputation, to my profile and public standing, in the manner in which they are raised. And the lies, the extensive lies which have been perpetrated through these, including in the supplementary affidavit, which now makes certain omissions in order to re-engineer the initial affidavit that I had responded extensively to, and the lies of which I had exposed in my response. So it would appear, Chairperson, that Ms. Ngoma is not doing me any harm, but in the manner in which she deals with a whole lot of issues, and the lies that she perpetrates in her affidavits, both the original and the supplementary affidavits, including in her response, where she dragged the name of my late father and said really demeaning things about my late father, and how she deals with my family, the demeaning manner in which she refers to my family. All of those things are intended to harm and to portray an image of somebody who was receiving cash and gifts, who was being bought watches in Dubai, who was being sponsored for trips without providing a shred of evidence. So that even the areas which may appear to be favorable to me become minor compared to the harm, the damage that is being done to me and my family by the extensive lies that are contained in this affidavit. Many of these lies are to which I have responded.
Paragraph 9.9 at page 1027.16. I ought to highlight that the proposal I was making to Mr. Gigaba was that we should agree on the issues so that we can both move on with our respective lives. Indeed, the settlement discussions, which were even escalated to our respective attorneys, yielded no fruits, and were accordingly abandoned. Is that correct?
The question, Chairperson, that she should answer is why those discussions were subsequently abandoned. But let me repeat, for the sake of the Commission, that they were abandoned because we could not agree to waive the antenuptial contract. They were abandoned because I suppose we did not respond timeously on whether we could find financial settlement, because I indicated that the financials, that I had no available cash to dispose through a settlement. They were abandoned because I indicated that the property in Centurion was still owing, and that if she were to take it over, she would need to continue with the bond. And let me also further indicate that I had agreed to a divorce settlement. I had agreed to this. I thought it would work best for both of us, and it would work best for the family. But the offer which they made, and the strange thing was this insistence that don't say to your attorneys, I have approached you. Rather say to your attorneys that you and I have agreed. But we had nothing we had agreed to. We were agreeing on a settlement, but the details of that settlement had not been agreed to, and I could not go, because when I went to my attorneys and said, there is this proposal, they then came to him and said, apparently they've agreed on waiving the antenuptial contract, which obviously was not true. So the manner in which we were expected to deal with this was quite strange, and unfortunately, it did not yield any fruits. But it was my understanding that any settlement is based on negotiations, Today you agree, tomorrow you don't agree, you negotiate further, you compromise, you eventually find a settlement that works for all parties. But it seemed that the inability to agree on initial offers was taken to be a permanent inability to agree.
So when were the settlement negotiations abandoned?
It was at the beginning of this year. I wouldn't say they were abandoned. I would say that because I don't think there was a discussion and agreement that we are now abandoning settlement negotiations. The fact of the matter is that the divorce is going ahead. It will go ahead. It may just be delayed by the fact that we have to go through this process, but it will go ahead. So I would expect that there would still be reinstituted settlement discussions, because my understanding is that even if you were to finally go to court on the issue, the court would expect that on certain issues you would have discussed and agreed, so that it gets, I don't know what's the right word, but confirmed by the court, let me say so.
So what we know then is that the settlement discussions came to an end. I mean, whether they abandoned is correct. They ceased at the beginning of the year, is that right?
Jefferson, abandon and coming to an end seems to me to be meaning the same thing.
They were simply not pursued from a certain point.
Yes.
Yeah.
But that they will still be reinstituted, that's my expectation.
That might still happen.
Yes.
Okay.
So that was before then Ms. Mangoma filed her affidavit. You see, she did that on the 6th of March, 2021, that you see at paragraph 9.11.
Yeah, sure.
And then at paragraph 9.10, she deals with the High Court judgment. 9.11, she files the affidavit on the 6th of March. And then on paragraph 9.12, she says that on the 26th of March, the NPA withdrew criminal charges against me, which were related to my unlawful and malicious arrest. Do you accept that the charges were withdrawn against Ms. Mangoma?
Well, I was not involved in the case, so that's what I heard in the media. I was not represented in the case.
And then she concludes by saying at paragraph 10, I lay out the above chronology to demonstrate...
Just 1 second, Mr. Maybeck. I understood that, I assume that relates to what you have referred to as the domestic case.
Yes.
I thought that you said you were the one who laid the criminal complaint.
Chairperson, I reported the incident.
Yes.
I did not lay a complaint.
Or you reported
I reported the incident, yes.
And then you were asked to make a statement.
Yes.
Okay.
It was for the purposes of insurance,
yes.
And all of that process.
Yes. But the police, or neither the police, that is the Hawks, nor the NPA have informed you whether the charges have been withdrawn or not. You just heard in the media. I heard in the media, but I was informed informally. Yeah. Because I was not involved in the case itself. I didn't have legal representation. Yeah.
So we were not party to the case.
Yeah.
So that's why I was also saying I have not even been informed as to the progress or lack thereof, yes, of the allegations that Ms. Mngoma was involved in a plot to kill me. That's where the matters are.
Okay.
Yes.
Mr. Maita.
Thank you. At paragraph 10, Ms. Mangoma concludes this part of the affidavit by saying, I lay out the above chronology to demonstrate to this commission that the suggestion that I was a bitter spouse attempting to get to Mr. Gigaba through this commission is not only malicious in the very least, but is misleading on the real issues before this commission. You want to comment on that?
Chairperson, I hold a different view. I hold a different view because yes, if you look at 9.11, 9.11, she says that in January she filed, we had discussions, the settlement discussions were accordingly abandoned. That is on 9.9. Then in 9.11, she says on the 6th of March, she filed an affidavit with the Commission. The chronology of that is informative. There are settlement negotiations in January. Then on the 6th of March, she files an affidavit after, in her opinion, the settlement negotiations have been abandoned. I believe, in my opinion, that 9.11 confirms my argument that the reason she came to the Commission in March and not in January, as she had indicated to me that the negotiations, the discussions between the Commission and herself and her attorneys had already taken place by then. She didn't come to the Commission in January. She didn't come to the Commission in February, but in March, after, in her opinion, the settlement discussions had accordingly been abandoned. That is using her own language. So point 10 is, in my opinion, weak to demonstrate that she is not or was not a bitter spouse. Because if you read 9.9 and 9.11, they actually confirm that what subsequently happened on the 6th of March was an action prompted by the fact that the settlement negotiations had been abandoned. But as I say, in my opinion, they had not been abandoned. We had disagreed on a few things which could still have been ironed out. And only when she thought that the settlement negotiations had been abandoned, she then approached the Commission, which then confirms that she indeed was a bitter spouse.
Chairperson, you'll be aware that the curfew starts at 10 o'clock now.
Yes, I have been meaning to check.
I had discussions with some of the technical staff, and I was advised by at least one person that he would ideally need to leave by 7:30. So I have gone over that time a little, I'm sorry. But I think the position is, I'd hoped we could carry on until 8 o'clock. I canvassed that with the technical staff, but it's not possible in relation to everyone. Apparently, at least one person has got a long way to travel.
Okay, no, I think we have to be sensitive. If it is somebody, I was also hoping we could go up to 8 at least. If it is somebody that we can continue once he or she is not here, then, because if it's somebody that can go, but there is somebody else who can help us continue, it would be different. Your understanding is that if we release that person, we would not be able to continue in terms of technical support.
I'm not sure that I'm qualified to answer that question, DCJ, but perhaps I can...
the Reverend Stemela is not here now. He normally talks to them.
Well, he may have stepped out. In fact, I think he's the person that has a long way to travel.
Yes, he is the person.
Yes.
Oh, I'm just, because if other people can stay until 8 and that would not affect the proceedings, then it would be, we would release him
So I'm sorry, it may not be the reference to Mel, it may be somebody else.
Okay, no, I think maybe we must just stop for now. I think it will be important that somebody from the Secretariat is always here, because now we don't know whether if we continue until 8, there's going to be a problem or not. Okay, Mr. Gigaba, I think we'll have to stop here for this evening. Mr. Solomon, are you still there? His picture.
Yes, my lord, I am. I'm trying to put my video back on, yes.
Okay. We have to stop now. I was hoping we could go up to 8 o'clock, but I'm told that there might be one technical person who has to go far when they go home, and with the curfew starting at 10, we have to leave. I was hoping we could go up to 8, but we'll stop now, and then we will continue tomorrow. In terms of how much time we might need tomorrow, and bearing in mind that I think Mr. Solomon becomes unavailable from 4 o'clock, maybe we should start earlier than normal. Mr. Mybeck, how is that?
Yes, I think that would be a good idea,
Yes.
Chairperson.
Would that be fine with you, Mr. Gigaba?
I'm at your disposal, sir. I can start even at 5 in the morning.
Yes. Mr. Solomon, would that be fine with you?
Yes, now that would be in order, Chair.
Yes. Okay, I think then maybe let us start at 9:30. I think let's start at 9:30 tomorrow morning.
Thank you, Chairperson.
Yeah. Thank you to everybody for staying on until this time. We'll adjourn and continue with Mr. Gigaba's evidence tomorrow. We adjourn.